Okay, Rep. Devlin should be.
Madam Clerk, is Senator Champagne in the meeting? Oh, yay, there he is. Wonderful. Okay. He's the other person I wanted to make sure. Senator Champagne. It's good to see you here, Senator Champagne. We are recessed at the moment, just dealing with some technical issues.
Okay.
Madam Clerk, if I get you a separate email address, would that be workable?
And need to register at another email address?
Yes.
Okay, she hasn't received it on her CGA?
No, ma'am. I sent you a second email address to try, and I want to thank everyone for their patience as we work to make sure that we get everyone who belongs here in the meeting. Those are the pluses and minuses of technology, as Senator Cassano said. We will reconvene very shortly.
Well, we're not convened. We have 3 speakers in a row from OPM. I believe it says state of OPM. We give them a combined 9 minutes. How does that work?
Senator, I don't know. I think we can ask them when they get here, though.
Okay, all right. I just don't want to let them go on for 20 minutes and then have the next person come on and get cut off at 3.
No, we will stick with our 3-minute limit, and but if they do want to speak together for a combined 9, that would, I think, work just fine.
Senator and Representative, this is Undersecretary Martin Heft. They will be speaking with me. I will speak the 3 minutes, and they're just available to answer any questions we have or that you have of us, so that we will not, each of them will not be speaking for the 3 minutes, just to save you some time.
Well, you might get another minute. Thank you.
Okay, Senator Casano, Senator Wong, and Madam Clerk. Are you all set?
We're on to go.
Okay, I see. All right, I see Senator Wong and Madam Clerk. Wonderful. Okay, so we will break from recess and reconvene our public hearing this morning. And good morning and welcome everyone to our committee members, to our speakers today who have joined us, and to those who are watching on YouTube. We are so happy to have you here. As you know, planning and development hears a wide range of issues impacting municipalities. And then, as we'll hear today, some of the departments here in our state. And I will just kick it off with just a few housekeeping items before I turn it over to Senator Casano and Senator Wong, as Senator Casano brings us through the hearing today. Just housekeeping, this is our first hearing. So remind folks, if you are in the meeting, to please remain muted until it's your turn to speak. Just remind you to use the raised hand function to committee members. To those who are our speakers today, and we do have, I believe we have 65 registered, though we do have a couple who won't be speaking. Just to let you know, the speaker list is published on the committee webpage. If you click on the Planning and Development Committee and go down to the section that says for the record, there's a link under the public hearings section that says testimony. And when you click on that testimony link, at the top is the speaker order, so that any member of the public and committee members as well, if we can get that list sent out to you, perhaps Madam Clerk, if you could send that out to all of the committee, just so that they have a PDF. But any member of the public may also follow along that speaker order. Speakers will be numbered as they speak. So if you're a speaker waiting, you can see who's speaking and what number is before you. All speakers will be limited to 3 minutes each. At the end of, close to the end of your time, you'll be reminded to sum up. And we do have, as I said, 65 folks. So committee members, we certainly will be asking questions, but with the cognizance that we definitely want to hear from all of those who are here today to speak to us. And Madam Clerk, am I forgetting any of the important logistics? Yes, I am. There's one other logistic. There's a new Zoom feature. When you are promoted to be a panelist, you will have to, as one of our speakers, accept that request from Zoom. So please be aware, you won't automatically be able to be admitted by our clerk. You will have to accept that request and click on that in order to enter and be able to speak. So with that, I'm going to turn it over to Senator Casano. And I suppose if Senator Wong is still here, I think I lost sight of him. Senator Casano, there you are, and I see you now.
Senator Wong is here.
Okay.
Yes, good morning, everyone. Winding down for the day, but it's going to be a long day. I think we have 65 speakers. I don't know if we've reached Representative Devlin yet.
We have, Senator. She's ready.
Okay. All right. And she is our first speaker for the public hearing, followed by Representative Foster, who I know is online. Representative Devlin, are you there, please?
Senator, may
I see you. There's my neighbor.
I apologize to interrupt the good representative, but I also wanted to see, did Senator Wong want to make any comments before we started too?
Thank you, Madam Chair. I would defer to the Mr. Chairman for moving this process along. I appreciate the accommodation, but it's ready to get the show on the road. Thank you, ma'am.
Thank you, sir. Representative Devlin, welcome. Good to see you.
Thank
I
you,
wish it was in
Senator.
person.
I know, me too. And I miss having our offices next to each other.
I know it.
But I do appreciate the opportunity to testify before you today. So Chairman Casano, Representative McCarthy-Vahey, Vice Chairs Needleman and Gupel, and Ranking Members Huang and Zullo. Thank you for this chance. I have 2 bills before you today. I will be respectful of your 3 minutes and try to address these rather quickly. The first that I would like to testify on is HB 5170, and that is an act concerning the tethering and sheltering of dogs. This bill essentially mirrors legislation that passed the House in 2018. This is one of the Animal Welfare Caucus bills, and it was really revived. So what happened in 2018, if you recall, for those of us that were there, the Senate had closed early that year. Overwhelmingly, this legislation had passed the House, but it wasn't able to get to the Senate. And this was revived after an incident in Fairfield that brought to attention the need to revive efforts to strengthen our tethering and sheltering laws. It sets a foundation, if you will, where other municipalities are implementing their own ordinances that actually are even more strict. This does just a couple of things. It strengthens our current statute around tethering by including consideration for a dog's size and their thickness of coat, also ensuring that they're protected from potentially another animal, a wild animal, a coyote, whatever, that a dog isn't tethered and then at risk, and also provides for water. It also provides for adequate shelter and provides the definitions for that. So I did submit testimony that outlines everything. I will leave that, and I guess I should move into my testimony for the other bill that I would like to speak on, which is SB 130, an act concerning regulation of community residents. This legislation passed this committee in last session, didn't make it to the floor in the House. And let me just clarify a couple of things. Again, I have submitted quite lengthy testimony to you that you can look at, and I'm happy to answer any questions. But first off, let me just state, there is no question that there is a need for mental health addiction services. And I hope that we can all agree on that. This bill is not about whether or not there is a need for this services, and nor is it about obstructing group homes. What it is about is providing important clarifications to our statute 83E to prevent corporations from exploiting group home protections. What we have seen is some systemic misrepresentation by companies that bypass our current laws because of the vagary. So what this does is provide specific language that to qualify
Representative Devlin, you are close to your time limit.
Okay, to qualify as a community residence, you must accept DEMIS funding. And also, if you are a community residence, you do not need a certificate of need, which is limited to medical facilities. So with that, I will stop. I'm happy to take your questions. And sorry for cramming a lot in those 3 minutes.
You did well. Thank you. Senator Wong, you have your hand up.
Thank you very much, Mr. Chair, and thank you, Representative Devlin. Let me go to Senate Bill 130. You've been an advocate for a number of years, and let me be clear, and I'd like to have you reiterate that this could be any community, and it is a conversation to evaluate group homes away from examples that I like for you to be able to articulate that have been misrepresented by entities, commercial non-group home entities that have used this language. And the second part of the question is, could you also share that some examples of past practices, not only in the recent history, but for the past 6-7 years, that have had set precedent that indeed handcuff communities in regards to decisions that they have to make overriding local residential zoning?
So yeah, thank you, Senator Wong, for that question. Let me sort of tackle that, and if I've left anything out, please re-ask or clarify. What we are seeing is a corporation will go in and buy a home, and then under a unidentifiable LLC will go to the town body, the building department, or whichever they need to go to request a change of use. And what has happened, at least in the town of Fairfield, and I'm sure maybe this is happening elsewhere, and it certainly could, and operating from a platform of precedence is really dangerous. So when they approached the building department for a change in use, there was no questions asked whatsoever. And that change of use was just granted. So Then the company, under their operating name, would go to the Office of Health Strategy to request a certificate of need based on operating a medical facility. So right there, it's contrary. Now, this has happened in the town of Fairfield, where there are 4 homes operating, well, actually 3 under one name. One has since sort of changed its name. One of them now also promotes the fact that not only do they provide a certain treatment, they also provide partial hospitalization. So based on the precedent of this one operation, another company came into town, purchased 2 homes under, using the same agent as the other company, went to the town offices, requested a change of use that was granted, no questions asked, because that's how they were operating, because the protections afforded group homes are so important. And then under their operating name would go to the Office of Health Strategy to request a certificate of need, and then are trying to validate that this is appropriate action based on the fact that nothing was done to stop the other company. So like, when does that end? And, the first company was operating, not a lot of people were aware, but they did become aware when a new company came to town. And so it just seems absurd to me that based on perhaps that a precedent was set, that we should just let things continue inappropriately. It's just, a real systemic example of systemic misrepresentation that, because it happened once, shouldn't continue to happen.
And I want to thank you for that. It can be somewhat confusing. And I think I want to thank the leadership of this committee for raising this conversation and filtering it out. It ultimately, in a simplification, if I may, and offer if you agree, this is a case where residential laws, residential zoning regulations were being bypassed under the presumption of a group home. And the purpose of this bill is to clarify that definition so that proper group homes that offer as residents and homes to the protected communities is supported and empowered to take that exception. But what we're seeing is you wanted to filter out and clarify the definition that commercial entities that is not a group home do not any further claim this as a process. Would that be correct? That's the purpose of this, as I
100%,
understand it.
100%, Senator Wong. Bypassing local zoning is absolutely occurring in this situation. And I would think, and I think I'd mentioned this last year in front of this committee, with zoning being the purview of this committee, it's something that should be very concerning. And to your point also, it does, by doing this, it does crowd out the ability for a legitimate group home. And keep in mind, right? A group home is intended specifically to provide that sort of shelter in a home for an individual. That's where they live. And the purpose of having these protections is to enable them to, assimilate into the community. These medical health residential treatment centers are anything but. You leave your home, you go to this treatment facility at least $1,000 a day. You might be there for 60 days, and then you go home. They are not a group home. So yes.
Thank you. And I appreciate that we have a lot of other people to offer the perspective. Thank you very, very much. I just wanted to do a big, quick shout out in respect to your time of thanking you and also the Madam Chair, Representative McCarthy-Vahey, for participating in the library support and offering support and love of our libraries. That will be reflected on Bill 131. So I want to thank you for being there and offering your support of that as well. And I know it's a limit time in regards to that, but I wanted to publicly acknowledge and thank you and Representative Devlin and Representative McCarthy-Vahey for their support of this important bill relating to libraries as well. Thank you, Mr. Chair.
Thank you.
Representative Dubinsky.
Thank you, Mr. Chair.
Good to see you.
And thank you, Representative Devlin, for coming in to discuss these bills. I wanted to talk to you specifically about the dog tethering bill. Could you indicate to me, like when we talked about this, there was discussion about taking into account hunting dogs and different breeds and things like that. Would you be able to expound on that a little and just reassure me that a guy who's got a Finnish Pristicore of a dog who you bring them inside and they get sick. They live their entire lives outside in the harshest conditions in the world. That a guy like that's not going to be wrapped up in this bill and enforced against because some neighbor thinks that his dog's being abused because he's out in the rain.
No, thank you for that question, Representative Dubitsky. And the language of this bill really mirrors what was passed in 2018. And that was developed specifically, I believe, with the Sportsman Caucus in mind. So this is not about individuals who have sporting or working dogs. It's recognized that there is a huge investment of time and money and training for those dogs. Those owners, and perhaps like yourself, certainly my nephew, understands the importance of providing them a safe and adequate shelter. What this is really about is addressing irresponsible dog owners. It is not at all in any way to have an impact on those individuals with sporting or working dogs.
And who's going to make the call as to whether or not the conduct is irresponsible? So, if I've got a dog, if I've got a Alaskan Malamute who's outside and it's 31 degrees outside and my neighbor thinks that's abusive, who's going to make that call to determine that dog doesn't need to come inside when the temperature gets below freezing?
No, thank you for asking that, because that is one of the things that we did include in the bill related to the tethering, and that is to consider a dog's size and its thickness of coat. So, that is definitely a consideration that wasn't in our prior or our existing statute, but still the determination is left up to the local animal control officer.
Okay, and is there any type of training for these officers? Because, I know a number of animal control officers, they know what a dog is and they can distinguish it from a cat, but they can't necessarily distinguish different breeds and, different types of dogs and what they're trained and bred to do. Is there any way that we can ensure that somebody an animal control officer that doesn't have any type of knowledge about these dogs doesn't start an enforcement action against somebody who, improperly?
That's a real fair point. I know that both myself and one of the advocate, groups, Connecticut Votes for Animals, that may be testifying in front of you today, have reached out to multiple animal control officers. But to your point, right, they're all individual people and people interpret things differently. And what I'm not 100% on, but I would hope, right, when we pass laws in the legislative body that change the way somebody needs to work, that there is that communication and training as a part of that. So I would certainly be happy to follow up on that, but I would expect that, in fact, this clarification would be shared, and the animal control officers that we had spoke to were pleased to have this sort of specificity in the language that today is just very vague.
Okay, well, thank you very much, and thank you for your responses. I appreciate it.
Thank you.
Thank you, Mr. Chairman.
Thank you. Representative McCarthy-Behe.
Thank you very much, Mr. Chair. And Representative Devlin, it's nice to see you here. I want to thank you for your persistence. I know sometimes we have technical issues, and I just did want to acknowledge that and say thanks for reaching out and getting that settled so that you could be here with us today. I also wanted to just thank you for your work, specifically with the animal tethering bill, the bipartisan work that you've done. I know with both Rep. Leeper and the Animal Welfare Caucus, Rep. Michelle, one of our own committee members, Rep. Clara DeStitria, and others, and it's appreciated. And I know I think we'll have some other conversation during the course of the hearing about both that and about Senate Bill 130, and just look forward to ongoing conversations and working with you on both of those. So really just wanted to say thanks.
Thank you, Representative McCarthy-Vahey. And I appreciate as well, in addition to Representative Leeper, who we both, the legislation was submitted under both our names to your committee. I know both you and Senator Wong, as a Fairfield delegation, we have all worked closely, as well as, to your point, Rep. Michelle, who's always a strong advocate and one of the co-chairs of the Animal Welfare Caucus. So yeah, we've worked with a lot of people over the past several months to get this to you. So thank you for the opportunity for the hearing today.
And I would close by saying that I think that clearly we can get this bill through. It's going in early in the process, but we do have some work to do once it's passed to make sure that that information is provided, that those concerns are given to dog wardens across the state, because I don't know how often they go in for training or whatever it might be, but that's something that can be done once the bill is passed. And I think those are really legitimate concerns that Rep. Dubinsky has raised. And so let's get the bill through, and then let's do the follow-up necessary to make sure it's effective. I still
you,
have
Senator.
Representative Michelle.
Yeah, I just wanted to second the good words of my chair. I wanted to thank both Rep. Devlin and Rep. Leeper for bringing this piece of legislation forward and for keeping the conversation open. And again, thank you. And on behalf of the Animal Advocacy Caucus, which is a bipartisan caucus, and we're happy to see this bill through. Thank you.
Thank you.
Seeing no others. Representative Devlin, thank you. I'm sorry, Representative Smith. There you are.
Thank you so much, Senator Cassano. Thank you, Representative Devlin. I think this is a great piece of legislation. I just had one quick question. Are there, or have you considered whether there should be any penalties for people who make frivolous or malicious complaints against a dog owner, related to this bill in particular? And I say that only from personal experience, having had that happen, and had my late sister be confronted by a dog warden over a frivolous, malicious complaint from a neighbor. So I just wonder if there's any ramifications for false complaints.
That is a great question, Representative. Thank you. This legislation does not address really penalties in either way. The existing statute does have penalties in place for violating the statute, and we have not touched that. The existing statute does not include at this point, but is certainly something we could look at in the longer session of providing those protections. Absolutely.
Thanks very much. I appreciate you saying that. I think maybe a fine or something might be something worth looking at in the future. I certainly wouldn't hold up a good piece of legislation because of it, but certainly if the record shows, it might be something to look at. So thank you.
Yeah, no, I think that's really fair. And perhaps when we, work with the Department of Agriculture in terms of the, sharing of new legislation such as this, or a change that may be required, it's an opportunity to also get input from those ACOs, to your very point. So I appreciate you raising that. Thank you.
Thanks. Thank you, Senator.
You're welcome. Any other questions? Seeing none, Representative Devlin, thank you very much.
Thank you. It was an honor to kick off your hearing. Good luck today. Thank you very much.
Couldn't start with a better person. Thank you.
Thank you.
Representative Foster. Jamie, I see you over there in the corner of the screen. Welcome.
Hi to the members of the P&D committee, chairs Cassano and Rep. McCarthy-Vahey, ranking members Huang and Rep. Zullo. I am honored to be here in front of the P&D committee today on behalf of a bill that we are endearingly calling in our community the Bowser Bill. You will see later on in testimony for this bill, First Selectman Jay Bowser. He will talk, I'm sure, in great detail about the economic implications of this bill. But the gist of what we are asking for is a very simple linguistic change that would allow communities like East Windsor that have town meeting forms of government to compete with towns that have more swiftly and agile able to react municipalities so that they can compete and offer fixed tax assessments and tax stabilization agreements to recruit business sectors. As you'll hear later on in First Selectman Jason Bowes' testimony, there are many times where the town of East Windsor would like to positively impact taxpayers' taxes without cutting services to the community. And the best, most effective way for a municipality to do that is to increase its tax base. And to do that, they need to be able to recruit businesses that align with the values of the community. And to be able to do that in a town like East Windsor, to improve our school systems and to be able to offer better services, we need this very small language change that would allow us to enact an ordinance that would allow the town meeting form of government to offer fixed tax assessments to recruit business. I won't take too much of your time. I see you have a very long agenda ahead of you today, but I'm happy to entertain any questions. And thank you so much for having me here today.
Are there any questions? I don't see any hands raised. Yes, Representative Zullo, welcome back.
Thank you, Mr. Chair. And just a very quick question, Rep. Foster, if you don't mind, through you, Mr. Chair. The actual ordinance, that would actually have to be passed by the actual full town meeting form of government, right? First, so everyone would have a say in whether or not this proposal goes forward, what if we were to approve it. And then after that, the Board of Selectmen would have the ability, this freedom to be able to go out and offer these same tax, agreements that other towns can do now through their town council, correct?
Correct. It really does enable local control for each municipality. They have the option to choose what's the best fit for their town if they'd like to do it. East Windsor has already enacted such an ordinance. So if this law were passed, they would be able to do that. But if a town didn't want to, they wouldn't have to.
And thank you very much. That was going to be my second question, just as a summary, that it's permissive and not mandatory. So thank you very much for the comment, and thank you, Mr. Chair.
Any other questions? Seeing no hands, Representative Foster, thank you very much.
Thank you. Have a great day, everybody.
You too now. Martin Heft. Mr. Secretary, welcome aboard. I believe there are three of you, Jennifer Gauthier and Patrick Sullivan. Welcome.
Correct. Good morning, chairs, vice chairs, ranking members, and honorable members of the Planning and Development Committee. I'm Martin Heft, Intergovernmental Undersecretary at the Office of Policy and Management. Here with you today to support House Bill 5169 to implement the recommendations concerning property tax exemptions, special taxing districts, neglected cemeteries, revaluation of real property, property tax assessment and appeals, tax overpayment refunds, tax collection, payment in lieu of taxes, and the elimination of the municipal requirements relating to fiscal disparities. All of this may sound familiar because the majority of this bill is the same as it's been in the past 2 years' submission. The bill includes several amendments that are purely technical in nature to correct errors, omissions, obsolete law, or provide uniformity with existing practice. You may recall Section 7 aligns and establishes revaluation zones utilizing the 9 regional council of governments boundaries aggregated into 5 new geographical zones. I will note that a section by section memorandum explaining the rationale for each of the proposed amendments is attached in my written testimony. Would also like to add that under sections 20 and 21 is to clarify the payment in lieu of taxes, or known as the pilot program, to accurately reflect existing practice and the codification of the tiered pilot legislation that was passed last session. The bill codifies current practice for data sources and pilot calculation and clarifies that district only means fire districts and not all the district as defined in Connecticut General Statute 7-324, which includes many districts to which pilot statutes are not applicable. Open space is a municipal option requiring designation in the local plan of conservation and development and legislative body approval. As a municipal option, the authority to set the criteria and assessment values should be at that level. Section 22 modifies the PA 490 valuation schedule set by the Office of Policy and Management and Department of Agriculture by removing this piece from that valuation schedule. I would like to just note that in section 13, I believe it was just inadvertently that LCO listed subsection F instead of H. And in our original proposal, there was an omitted section on affordable housing plans, which is in the testimony, and we'll be providing amendment language to make sure that is included. And additionally, I would like to request a title change to the bill to add relating to intergovernmental policy to the end of the bill, as this is not a bill that's all for Office of Policy and Management. It is strictly for the intergovernmental policy area. I appreciate the opportunity to address you today. And with me, I have our Associate Fiscal Administrative Officer, Patrick Sullivan, and our Municipal Assessment Professional, Jennifer Gauthier. And we're happy to answer any questions that you have regarding the bill. Thank you.
Okay. Representative McCarthy-Bay, Madam Chair.
Thank you so much, Mr. Chair, and thank you, Mr. Heft, and to your associates from OPM for being here and for your good work on this piece of legislation over the course of many years. I know that it is a pretty comprehensive piece of legislation, and as is often the case with planning and development, there are some wonky pieces in here that may not seem to be all that important, but that absolutely impacts our ability to administer the functions of government on a few different levels. I just wanted to confirm the section 13 that we hear you and acknowledge you. That was just, I think, a miss on our part in terms of getting language in. So just so committee members and the public are also aware of that. And thank you for the piece about the title as well. I wanted to just ask, in the past couple of years, the committee has had a lot of business, and as I think Senator Wong used the funnel term, which I often use, I think this is just a bill that didn't go through. Were there specific issues or concerns that you had heard from people in the past that you'd had conversations with that you think were impeding the progress in some way?
Thank you, Representative. We have actually not heard from anyone that had opposition to, portions of the bill. Some of the larger portions, such as the revaluation zones. As a reminder, we've been meeting with vendors, with stakeholders, assessors, the COGs themselves, and that's where that whole process was developed. Under the Public Act 490, which is new this year, we have been meeting with Department of Agriculture, the Assessors Association, and working on that as a joint proposal. As those that may not know me, I'm one of those people that I like to build from the bottom up rather than the top down when we're presenting something or reviewing a piece of legislation, and bring all the stakeholders into review. So we have this has all been reviewed with assessors, with tax collectors. Some of these are their recommendations from their association that we agree with, and presenting them forward.
And Mr. Heft, I'm so glad that you highlighted exactly that. I think it's really important that folks know that you have worked collaboratively over a period of time, very consistently along with your team. And that's important. I will ask you my second question in this way. Would you like to comment on House Bill 5167, an act authorizing a delay in property revaluations, and what impact that might have on the work that's been done related to what you just commented on, the work with the assessors and that regional look?
Sure. Thank you very much. I know that 5167 looking at putting in a delay for property revaluations. I can give you a few little background information that, as we know, that this pandemic has been with us for a couple of years now. And over 2020 and 2021, 52 municipalities actually implemented their revaluations during the pandemic. So it's widely agreed that there's 4 assessment years, 2020 through 2024, that this pandemic, may impact it. Maybe it might be further with valuations on here. Part of that, is revaluations are done every 5 years to equalize the tax burden and bring all real property to fair market value. For this, looking at upcoming schedule, we have 38 municipalities scheduled for 22 revaluation and 46 in 2023. Now we know the bill doesn't, it allows a municipal option to postpone or delay the revaluation for 1 year without any penalties. But depending upon how many are actually going to delay, could cause problems with the companies that have to do the revaluations if they're going to have enough support there and the workload and employees to be able to do that work. For those that don't know, revaluation companies and employees need to be certified by the state of Connecticut by Office of Policy and Management. So it's not something that can just, happen overnight and anyone can just come into the state and do a revaluation. There's a limited number of revaluation firms. And as we discussed with our revaluation zone proposal, we've talked with them as trying to create that balance so that way they would be able to do that work with all of those zones over those years, over that 5-year period. So having a number of towns, 1 or 2 isn't, necessarily the problem. It's depending if we're going to have all 38, postpone a year. And if those other 43 from the next year do not, you've got over 70 towns in 1 year potential to reval, and the reval companies won't be able to handle that. So I think, that there is some concern about doing a delay, broad-based on it. We did last year, we had in 2020, we had 2 municipalities that did not implement. The secretary did waive any of the penalties for that. This current year for the 21 revaluation, we are only aware that we've received 1 request in for that they are not going to implement out of the current number we have. So most municipalities have been implementing through this process.
Martin, may I add one other comment?
Jennifer, please.
About the 2022 revaluations. In order to postpone them, most of them are already under contract. Half of the work is already completed and the towns probably have expended a significant amount of money on those revaluations already. So if we were to ask them to delay or not to implement one, they would have to redo the entire revaluation next year and find the funds somewhere to repay for and recontract. 2023 revaluation RFPs are typically done in the spring, so those will be popping up here soon. And it is possible that contracts may have already been signed for 2023 revaluations as well. So there could be a potential municipal impact for funding because these are typically capital items that are funded over a series of years. So to ask them to expend the funds for revaluation this year and then find the funds again to do it next year may be problematic.
Yeah, thank you, Jennifer. And I would just add, Representative, that, the committee would like to move forward this. We would be happy to work with you. We would look, think there should be some changes to the proposed language, the way it's drafted to better coincide with the way some previous legislation has happened with this, such as Special Act 16-14 or Public Act 9-60 as examples. For the proper language for the delay, if that's going to be a municipal option, as has been done in the past, we'd be happy to work with you on, some better language that we would, be more acceptable to.
Mr. Heft, I want to thank you. It's very funny because we did not communicate about this ahead of time, but you certainly were prepared for these questions. So I'm impressed with the detail that you have provided us, and clearly for members of the committee who are interested in this issue, you all will be a tremendous resource for that conversation. And I really appreciate you just helping give context to the impact about the broader conversation that you all have been having over a period of years with our towns and our assessors. So thank you very much for those answers and for the work that you've done. I'm hopeful that we can get your bill across the finish line this year to help really, as you said, codify many things that are practice and clean some things up. So thank you very much to your team, and thank you, Mr. Chair.
And thank you, Madam Chair. Secretary, I have one quick question that's relative. It seems like 80 and 90% of all of the revals are done by one company. I just wonder if with 169 cities and towns and changing the rules and regs and so on, I mean, are we able to do the revals on time the way things are going? Are there enough competitive companies out there willing to do revals? And I know it's a totally different question, but it's appropriate.
Sure, no, understandable that, and I may refer to Jennifer as well, because she handles the revaluations and all of the certifications for when those companies have been done. So Jennifer?
Sure. Currently, we have about 20 revaluation companies that are certified to do real property revaluations in the state of Connecticut. It is true that there are several companies that are more highly used than others, including Vision, including Tyler, including Unival, and now we have Equality. They also do revaluations. So there are several, and they have been able to accommodate the revaluations as they've gone along. In the bill that we have, all we did was try to even out the number of parcels so that there's about 1.3 million parcels in the state of Connecticut. So the way we did our reval zones, there's about 200 to 250,000 parcels per year. So to even them out like that, the companies are more than able to accommodate that. It's these spikes that we get when we delay a revaluation, or they get legislative approval to move one. Then all of a sudden you end up with 20 in one year and 70 in the next year. And what happens is that they don't have the staff to maintain that type of spike. So after the 20 are done, then all of a sudden they have to do a bunch of hiring, and then the next year they fall off and they no longer have them, and those reval personnel move on to different positions. So that's the problem, and that was the whole reason we went through the process of trying to even out the number of parcels per year in order to be able to have good quality data.
Thank you, and that obviously keeps it competitive and pricing more in line. So that's what I was wondering. Thank you very much. I appreciate that explanation. Are there Senator Wong?
Thank you, Mr. Chair, and thank you, Mr. Heff, and all of your OPM staff members. As not a surprise at all, you're very prepared, and this is definitely not a technical bill. You've always been professional, and I want to start by saying thank you for a lot of your provisions that address veterans exemptions and refunds. I see that in many of your sections, so I want to compliment and extend my appreciation for recognizing a unique population that deserves every bit of our support. And I also want to compliment you on section 10, which is talking about assessors that current statute does not require notification should an exemption be denied or adjusted. And this is a effort of transparency in requiring our assessors to let people know so that they can begin the proceeding process. So I appreciate that. But I do have some questions on sections 11 and 12. We've had past bills that looked at potential contingency appeal organizations. And what I'm seeing on 11 and 12 is you're looking at adding language that stipulates that taxpayers that are appealing their valuation to Superior Court cannot have any witnesses that are compensated on a contingency basis. I understand that CCM has advocated on this behalf on this language. Can you explain a little bit more of how OPM is looking to implement that in this in this OPM requested statute?
Sure. And Jennifer, would you like to start on that?
Surely.
Thank you.
What happens a lot of times is you will have these large companies that will get a hold of a grand list. They will take the top 20 taxpayers. They will send them a letter and say, I think we can get your assessment lowered. They take them to court. And what happens is the towns are not able to litigate them appropriately. Sometimes the judges, they There's no appraisal necessary. So they're paid based on the reduction that they get. So what happens is it's an erosion of the grand list. So all we're saying is that you can't just take the town to court for an assessment just to see if you can get a reduction in the assessment. There's no basis for it. They usually don't have appraisals done, and it creates an erosion of the grand list that then lasts for 5 years until the revaluation is done again.
What would you say then, Ms. Gauthier, for communities and residents that says, hey, I don't have the means, but I strongly disagree with the assessment, but I need some expertise. It's not a cost to them if indeed those do settle out or they're able to win and they garner a portion of it. What would you say to that, to take away a tool for many residents? You talk about grand list erosion. What if they're wrong and you don't afford a contingency representation to get the expertise of maybe some knowledge and insight that could bring people to discussion? Because with this statute, as I understand it, with this language, you can't hire contingency firms to go on your behalf to battle against municipalities. That could be wrong.
In my experience, the expert witnesses that we're talking about are not necessarily appraisers. What we would want them to do is provide an appraisal and have some expertise in what they're talking about, and not just saying, I think this value is wrong, and not have anything to base it on. So they're just taking this to court and hoping that they can have the assessment reduced in order to make money. There's no appraisal. That would be the key for me, is if they are a qualified witness. We're just saying you can't just be a witness and say the value is wrong.
And if indeed, I mean, appraisals cost money, and you're putting the burden on a taxpayer who feels they've been wrongly assessed and already bearing the burden. What you're saying is go spend some more money and get an appraisal, because that's the standard bearer. And even if they didn't have an appraiser, I'm being a devil's advocate here, ma'am, is
Understood.
that if municipalities are settling out of court and indeed they lose the case and they don't have an appraisal, why are we standing on an appraisal as a basis? But if you're worried about losing the court case on an assessment, then maybe you have been wrong. So I'm just saying that this was a bill that we had as a standalone discussion. And I wanted to point that out, that under sections 11 and 12 of this bill, that language is expressly similar to what was requested by CCM in the past. And I just want to point that out, that is a significant topic of conversation from a point of assessor representation and a fairness and the burden of proof as well. So I just wanted to raise it. It's not a point of discussion, but it is an important part that I saw in a bill that had many, many very good things on there. So I thank you for your effort, and I am eager to begin more conversations on it. But just simply saying you need an appraisal and that it may be erroneous and that vendors may be taking advantage of the status of the situation. Maybe there are, but there are many others that give the proper representation for people whose property's been assessed improperly and felt as though they had no recourse. So thank you, Mr. Chair.
Absolutely. Let me make one comment though. If an appraiser is working on a contingency fee, it's against USPAT, which is our professional appraisal practice. So that is actually a violation. It's an ethical violation. So I'm torn. I understand what you're saying, but if an appraiser is paid on a contingency basis, it's a violation, and it's against.
I completely agree with you. I've taken an appraisal class. I understand that.
Understood.
But again, you're talking about placing more financial burden on a taxpayer, property taxpayer, and you're not affording them recourse by taking away the opportunity of a contingency. So again, it's a topic of conversation. It again does not undermine a lot of the very, very good things that I see on there, particularly as it relates to veterans with notification. But nevertheless, I think it's a work in progress, I hope. And I just wanted to flag that and have a further point of conversation with the good staff of OPM. Thank you, Mr. Chair.
I appreciate the opportunity.
Thank you, Senator Wong. Yes, Representative Zullo.
Thank you, Mr. Chair. And just in follow-up to the good senators, questions and comments on sections 11 and 12. I just wanted, for my own edification, to get some clarification as well. So am I to understand that you can hire an attorney on a contingency fee basis to bring your case, but you cannot have a witness that is compensated on a contingency fee? Would that be correct?
That's correct. An appraiser that's working on a contingency fee it violates the law.
And when you say that, that's the law in Connecticut, that an appraiser cannot work on a contingency fee basis.
Yes.
Okay. And then obviously then, if it's a non-appraiser, if it's somebody who's not an appraiser, but offering their quote expert opinion, maybe they don't particularly belong as an expert witness in the case in the first place. Would that be your position?
Yes, and part of this stems mostly from companies that just don't do any research. They just take a copy of the grand list and decide who's the highest taxpayers, and they don't do any research on what the actual value should be. So they don't do any appraisal work on the back end either. They solicit the company and say, I think we can get you a value reduction, and let's just take it to court and see where it goes. And then they get to split the difference after the assessment is done. And we have to remember that all of these court cases are such a municipal impact financially to the towns. I mean, every time you go to court, it's court costs, it's judge cost, it's the town probably will have to do an appraisal themselves. So there's a lot of costs here that are associated with contingencies that have no basis in the beginning. They're just fishing, basically.
So obviously though, to bring an assessment appeal in the Superior Court in Connecticut, you need to be a licensed attorney in the state of Connecticut, correct?
I think you can bring it. You don't need an attorney to do that. You don't.
Well, no,
a regular taxpayer can file their own.
I should back up. So obviously, a taxpayer can bring their own case, but if you're an LLC, you have to hire an attorney because you can't represent yourself as an LLC. Mm-hmm. And then, if you are an attorney, if you want to hire somebody, you have to hire an attorney, though. You can't just hire a lay person to bring your case. You have to hire an attorney, correct?
I think that's not necessarily precluded in the law. What we're just trying to say is that you can't have somebody on a contingency fee basis bring an appeal to court without any backup, without any research, without knowing what the value actually should be.
Right. What I'm trying to get at is that I don't think you can bring a case in Superior Court unless you're either the party in interest, you're representing yourself, or unless you're an attorney. I'm not aware of anybody else who can appear at court and represent anyone else. You have to have a law license to do that. Mm-hmm. Just a suggestion. I've always thought about this issue in the terms of the medical malpractice field, where you need a certificate of good faith in order to move forward with certain types of cases. And I almost wonder if something like that might also be worth looking into as we're having this conversation. People aren't going to give out a certificate of good faith to bring an assessment appeal unless there's actually a good faith reason to do it. Just wanted to offer that as part of the conversation. I totally respect what you're doing, and having come from a municipal background, I definitely know the costs to municipalities to pay for attorneys, to pay for costs, to pay for experts, and they are particularly burdensome in revaluation years. So I understand the plight, wanted to add that to the conversation, and I wanted to thank you for the time today.
And thank you, Representative and Senator, on the issues regarding, sections 11 and 12 contingency fees. We're happy to get some more information to each of you and happy to discuss if there should be any amendments to those sections, and be happy to do some further conversations along with that.
Representative Zawitowski.
Thank you, Mr. Chairman. Not to beat a dead horse, but sections 11 and 12, I just wanted to clarify. I've had past service on the Connecticut Real Estate Appraisal Commission. And yes, if somebody, certified appraisers, licensed appraisers cannot serve on a contingency basis. And that's state law as well as USPAP. And if you are actually in court and providing an opinion of value, as far as I'm concerned, that if they are not a certified or licensed appraiser in Connecticut, they are also in violation of state law. But I mean, that's my opinion. That's for the lawyers to decide. But I just wanted to clarify that because I have firsthand knowledge. I was actually on the first appraisal commission that put the laws in place in the early 90s. So I've got a little history there. So I just wanted to add that. And thank you, Mr. Chairman.
Thank you. Representative Dubitsky, are you? Yeah, there we go. I couldn't see you.
Thank you, Mr.
Welcome.
Chairman. And thank you. And I also did want to address sections 11 and 12 with regard to the contingency fees. When we pass a law limiting the ability of a party to hire somebody, aren't we choosing one side over the other? Aren't we saying that the effect on the municipality is more important than the effect on the individual?
So, Jennifer, thoughts on that? Sorry.
Absolutely. I don't believe so, because the companies that do this do not do any research on whether or not the value that they are appealing is actually accurate or inaccurate. So what we're trying to get away from are frivolous lawsuits.
Well, wouldn't that be vetted during the case? If I bring in an expert into court and my expert doesn't know anything about the subject matter that the expert's supposed to be an expert on, the judge is going to see that immediately and say this guy can't testify because he's not an expert.
But look at all the costs that the town has to put up front in order to get in front of that judge. So you would have to do an appraisal, you would have to hire an attorney, the assessor's work, all of that money would have to be expended before that judge could say, this is a frivolous lawsuit.
Right, but that's what goes back to my saying you're picking one side over the other, because if you say that an individual can't hire an expert on contingency, you're requiring that the homeowner or the property owner puts money out of their pocket up front. What if they can't afford to do that? Then they can't bring their appeal.
I don't have an answer. I don't have an answer to that. What we're trying to fix here is the ability for contingency companies to come and have frivolous lawsuits, all the expense that the towns have to go through in order to get that adjudicated in court. There's thousands of appeals currently backlogging the system because they're just filing appeals to file them. It's not whether or not they are warranted or not. We're not trying to take away anybody's ability to fight an assessment. That's what the law is for. What we're trying to do is say that you have to be qualified and you can't just bring a lawsuit just to bring it. You have to have some backup, whether that's, you know, the appraisal really would be the qualifying thing there. And an appraiser cannot be paid on contingency basis in the state of Connecticut or under federal law. So how can you give an opinion of value if you're not an appraiser?
Okay, well, you're trying to you just outlined the problem. The problem is that people are bringing frivolous lawsuits, and that there are people who don't experts who don't do their homework. And you've decided that the solution to that is to prevent anybody from hiring an expert on contingency, where it seems like there are other ways to address what you claim is the problem without creating a new problem, which is what you'd be doing. You'd be saying that even if an expert is truly an expert and has done the research and is not a frivolous lawsuit and is not a frivolous appeal, the property owner still can't hire this person on contingency. It doesn't seem like your proposed solution addresses your problem.
Yeah, Representative, we're more than happy to work with if the other solutions or other suggestions. We did work with the Assessors Association, you know, looking at issues that they're having with this, with the tax appeals on this. And obviously we're looking, you know, we want to try to help the municipalities better defend their grand lists and ensure a fair system. If there are suggestions on better ways of potentially handling this than what's being proposed, we're more than happy to have that conversation with you and the other representatives and senators and see if there's some sort of compromise or amendment language that we can do. We're more than happy to do that. And we can also provide some additional backup materials on the contingency fee, proposal.
Okay, I'd appreciate that because, as we as legislators, we represent individuals. Our constituents are people. We don't represent towns. And although, all our constituents live in towns, and obviously the towns are important, I don't feel my job is to defend a grand list. My job is to make sure that when there's a tax appeal, both sides get a fair shot at it. And I'm thinking that if we say that an individual property owner can't do something in court that they might otherwise want to do, we're putting our thumb on the scale and saying in advance that their appeal is not valid. And I don't think that's right. So I'd appreciate the additional information and additional discussion on those sections. And I thank you for coming in about it and discussing it.
Yeah.
And
More
I
than
thank
happy,
you.
Representative. Thank you.
Thank you. And I thank you, Mr. Chairman.
You're welcome. And I think your point's well taken. There's one thing that hasn't been mentioned here, and I would say that I live in Manchester. Manchester is one of those towns that have been a target for this process for several years. Every taxpayer, and you're talking about that individual taxpayer, I believe the family that owns their home, every community, I believe, has a process where you can go in and appeal and sit there with the tax collectors. And I know we generally set aside 2 or 3 evenings and people come in. There's no contingency. It's an opportunity for them to make a case. And many times adjustments are made because they come in and do that. I think the focus has been with us in Manchester. It has been on commercial. We have a mall. It's very easy. I believe they're from Kansas, the same people every 10 years, I should say. We'll go and they'll evaluate our grand list. They look for blocks and bang, they hit. And if you have a mall in your town or something like that, or large commercial properties, that's what they go after. They don't even live here. They're not licensed here. They don't appraise. And so it's dramatically different from the homeowner that you're trying to protect. And I agree with you 100%. They need that protection. And we provide that with the local taxpayers having those meetings on their bills. So I don't know if that helps, but that is part of the process that protects the homeowner. All right, it's a great discussion. Senator Wong.
Thank you, Mr. Chair. For the second time, I'll be brief. I just wanted to bring it back and thank the Undersecretary of OPM, Mr. Heff, for his work and his offer of working with our legislative colleagues on this issue. So it needed to be acknowledged. So thank you, Mr. Heff. And I do want to underscore there are a lot of good things in this bill. And indeed, I'm very much looking forward to working with it. And I want to thank the leadership for raising this issue. It's a healthy conversation. The second point is on a procedural, sir, Mr. Chair. We've gone past the first hour of public officials. Are we going to rotate between public versus the general public? And how would you proceed with that?
Yes, we keep that. If we're past the hour, then we should be doing that, and we will begin that. Thank you. Any other questions for Secretary Heft or his team? Seeing none, Jennifer, thank you for your testimony. Appreciate it.
Senator,
I believe Rep. Hall had a question.
Oh, I'm sorry. Oh, I got you. Thank you. Sorry, I couldn't see you up there.
Thank you. Thank you, Senator. I really don't want to be redundant, but I do have some concerns in section 11 and 12. And I'll give you an example. And I understand what Jennifer has explained, and I 100% agree with you on what you're trying to do. Here's where my concern lies. And we have a great assessors association in this state. I've actually spoken with them many times on various issues. here's what is a legitimate question, and I think you'll probably understand where I'm going with this. We can have assessors that may be new to a town and are going in, making some very sweeping changes in a reval year that is affecting a good portion of the town. Like Senator Cassano explained, there's a process in place to protect our homeowners that can go in front of these Board of Appeals. What we've been told recently, which is really, in my understanding, defeating the purpose of the Board of Appeals, that once the Board of Appeals has made a decision, let's say in favor of the homeowner or business or whoever is in front of them, that the town assessor can immediately go in and reverse that. So to me, it's right. So I see Jennifer shaking her head, and we actually brought this up. OPM actually had written an opinion, and I'll share it with you, that was sent to me, which was, it to me, defeated the whole purpose of the Board of Appeals. And I'm putting this on the record because it's been a public statement locally in one of my towns that it doesn't really matter what the Board of Appeals does. As an assessor, we can go in and change that by simply notifying the Board of Appeals in writing why this change is being made and attaching it to the property card. So I would love to hear that that is totally incorrect. But that was something that came up as a local issue for me recently. So I'd love to hear your opinion on that. But it concerns me because if this actually happens, it goes to what you're talking about here. All these folks that are going to go to hear their appeals before our Board of Appeals are now going to be forced to file with Superior Court for these cases if an assessor arbitrarily goes in and overturns everything our Board of Appeals does. So I'm throwing that out there. I know that's not what your intention is with Section 1112. I heard everything you said and agreed with it. But maybe we can address that under 11 and 12 just to tighten it. And I'd love to, again, like all my fellow representatives and senators have said, would love to work with you on this section. So thank you for that. I'd love to hear your feedback on what I just said, because I'd love to hear it on the record.
I would love to answer you. So the BAA it's the Board of Assessment Appeal. So they are welcome to increase, decrease, or make no change at all to a valuation. If they make a change, it has to stay that way for at least 1 year. At the next grand list year, if the assessor believes that the value was incorrectly changed, they can make it again for October 1st, that new value. And that taxpayer can again go to the Board of Assessment Appeal again, and the Board of Assessment Appeal could do the same thing. They could increase it, decrease it, or make no change. But to do an immediate change after the BAA has made a decision, they cannot do that. They would have to wait until the following grand list year in order to make a change.
Okay, so I love hearing that. I hope the appropriate town that made that statement in a public forum heard you. If they didn't, I will refer them to this meeting because that is wonderful news. We got 2 different answers on that, and I hope this kind of clears that answer up for the municipality that seems to be struggling right now with this. So thank you so much, Jennifer. I appreciate your answer.
More than welcome. And there is a Board of Assessment Appeals handbook that is given to every Board of Assessment Appeals member. I'm sure that the CAAO, the Assessors Association, would be happy to share that with you or any of the board members or whoever it is that you're looking to educate.
We actually did share that with them, and they're their hat on the last line in that specific section. And I can share that with you offline, but
Absolutely.
thank you for that.
Would be glad to talk.
Representative Dubitsky.
Thank you, Mr. Chair. And I just wanted to comment a little bit about what Representative Hall said. I am an attorney and I do practice, part of my practice is in this area. And there are, it is very common to go into a Board of Assessment Appeals hearing and have the assessor sitting behind the table with the Board of Assessment Appeals. The Board of Assessment Appeals is supposed to be a sort of a quasi judicial body that hears in a judicial capacity a dispute between the assessor and the property owner and makes an independent decision. But far too often the assessor essentially runs the meeting and the Board of Assessment Appeals considers itself a branch of the town along with the assessor, and the two, the assessor and the Board of Assessment Appeals together will make a decision on the property owner's appeal. And I have repeatedly objected to that and made it very clear that I didn't believe that was proper. And I'd like to hear your comments on that as to whether or not the Board of Assessment Appeals should be discussing this with the assessor as if the assessor were part of the decision of the Board of Assessment Appeals.
I'd be glad to answer that. Most assessors do not want to go to the Board of Assessment Appeal meetings at all. They do not want to be involved. Sometimes the Board of Assessment Appeal will request that the assessor attend in order to help understand where the value was derived from. So sometimes they are there to explain, well, this value came from the addition of whatever they may have added or whatever may have changed. So they are usually not there unless the Board of Assessment Appeal requests them to be there. I would agree with you that they should not be sitting in the meeting unless they are only there to provide testimony against what the value is. So why they would be there, I'm not sure what town you're talking about or the circumstances, but the Board of Assessment Appeal is set to be separate and apart from the assessor for that specific reason, so that they can hear both sides and determine for themselves what they believe the value should be.
Well, I can tell you over the course of the 20 years I've been practicing in this area, I have seen it the majority of the times all over the state. I've been in Board of Assessment Appeals hearings in dozens of towns across the state for decades. And I would say the majority of times the assessor is there. And very often, if the appeal does need to go to court, when you ask the Board of Assessment Appeals what they did for deliberations, in some, I would say many instances, they will say, well, we met with the assessor and the assessor said no, so we said no. Do you agree that that's improper?
In my opinion, yes, I believe that's improper, and I believe that's against the essence of what the Board of Assessment Appeal is there to do.
Right. And I would just say, we always, Representative, we always recommend to any assessor, any Board of Assessors, that they always go with the state statutes and check with their municipal attorneys for any clarification, because the Office of Policy and Management can't give any legal advice, on the statutes or anything. So we always, we can provide, here's the best practices, here's what is taught through the Assessors Association and the certification and education pieces of it, but we do always refer those municipalities back to check with their local municipal attorneys as well, especially, in any of the process or questions that they have.
Understood. But and perhaps this addresses some of what Representative Hall said. I can certainly understand how the towns would consider that the assessors can override the Board of Assessment Appeals decision, because in many instances they're involved in that decision. And, you know, frankly, I appreciate your saying that, you know, that is not proper. And perhaps we need to address that in the statutes to make it very clear what the Board of Assessment Appeals role is and what the assessor's appeal is in the assessment appeal. But I thank you for your responses. Thank you, Mr. Chairman.
Representative Dubinsky, thank you for raising that issue. It's something that we obviously as a committee should be looking at. Obviously, we're not going to be able to get it done in this session, but clearly needs some work. Appreciate that. Any other questions? Seeing none, I want to thank the OPM team. Patrick, do you have any comments from?
I do not. I am all set. Thank you.
Okay.
Chairman.
All right, Jennifer, thank you. And Mr. Secretary, thank you as well.
Thank
All
you.
right, we're going to move.
Appreciate it.
Thank you for the opportunity.
All right, we're going to move on. We're going to start to alternate. We have, it was on deck, Luke Bronin. And then the first of the public speakers would be Linda Iavona. If Linda's.
Hello, I'm here.
Okay, you'll follow Mayor Bronin. Thank you, Linda.
Oh, I'm sorry. Okay.
Yeah. Mayor Bronin.
Good afternoon. Thank you so much, Senator Cassano and Representative McCarthy-Vahey and the representatives and senators on the committee. I'm grateful for the chance to testify. I wanted to just testify on two bills that are before the committee today. The first is House Bill number 5169, an act concerning the recommendations, the Office of Policy and Management, specifically dealing with property taxes, tax assessment appeal reform. There are some important reforms included in this bill, but I wanted to encourage the committee to consider additional reforms and wanted to highlight four in particular. The first is, as is under consideration, the elimination of contingency fee arrangements, which pay a percentage of any assessment reduction in exchange for appeal assistance. We believe that incentivizes dishonest representations of true property values and the filing of frivolous appeals. But in addition to that, believe that persons representing others in appeals should be required to be either attorneys or certified public accountants or certified or provisionally licensed real estate appraisers who are both knowledgeable and subject to ethical standards. Third, I think that when a property appraisal by a licensed professional should be required to be performed within 90 days of filing any assessment appeal. I think this is particularly important on higher value commercial properties so that those appeals have a grounding in true market value rather than personal opinion, misrepresentation, or simple desire to take a shot. Finally, strongly encourage the committee to consider a pilot program modeled on Massachusetts' approach to assessment appeals, which is based on the use of a quasi-judicial statewide agency that conducts hearings and renders decisions on appeals. This is, I think, critically important to accurate results. I will share our experience as a city that when appeals come before a judge, more often than not, the judges are not deeply experienced in the appraisal process and do not want these matters on their docket. And almost without exception, they drive the parties to compromise even when the underlying data and facts do not support a reduction. As a result, towns are forced to settle at reduced assessments even when that results in an imposition on other taxpayers by resulting in inaccurate assessment of large properties. Finally, I now want to turn quickly to another bill before the committee, which is House Bill number 5172. This is an act concerning reemployment and the municipal employees retirement system. May I have 30 seconds, Mr. Chair?
30 seconds to wrap up.
All right. Under 5172 was passed in 2013 previously and vetoed by the prior governor, encouraged the committee to pass it. The current law restricts municipalities' ability to hire retirees from other municipalities. It makes no sense. It provides no financial benefit to the state. It imposes a cost on municipalities by making us less competitive relative to private sector employers. In a competitive labor market where we need good talent for municipalities, this law should be changed. I'd be happy to talk more in question and answer if possible. Thank you very much, Mr. Chair.
Thank you. Representative Dubitsky.
Thank you, Mr. Chairman. Thank you, Mr. Mayor, for coming in. You mentioned that judges are not generally familiar with property tax appeals and don't want them on their docket. Are you familiar with the municipal appeal docket in New Britain?
I am not. I am not familiar with municipal appeal docket in New Britain, Representative. At least that's as far as I recall.
There's a specific docket in New Britain where tax appeals are typically directed or removed to. Most appeals around the state, if they are especially big ones, if they're brought in a district other than New Britain, they're generally moved to New Britain. Yeah. Where the court has specific knowledge and experience with regard to appeals.
Representative Dubitsky, I apologize. You are correct, and I had forgotten about the specific docket. What I will share, though, and no disrespect to the judges who are placed in charge of that docket, is that our experience with many appeals that are placed on that docket before that judge is that the judge who has that responsibility, despite being in charge of that docket, does not necessarily have a strong grounding in appraisal process, or more to the point, would rather see questions settle than decide them in one party's favor or another. Almost without exception, we are urged to reach a settlement with the implicit with the risk in being implicit that case will be decided unfavorably against a party who is not interested in settling. And that results in compromises that are not justified by the underlying facts and data.
Well, I've practiced in that docket for many years and find that judges that oversee that docket very knowledgeable in the area of tax appeals, and of course they're going to want everybody to settle. In every civil action, the courts always want the parties to settle in some way, because going to trial is very expensive for everybody. I'm not sure why anybody would object to a court trying to get people to settle.
Sure. Well, Representative, I think that gets to the heart of the matter. I think you're exactly right that courts would always like the parties to settle. However, that does not mean that that is the right public policy result. What that does mean is that individuals who represent property owners bringing appeals are incentivized to bring as many appeals as possible on behalf of as many property owners as possible, knowing that the result will be a settlement that reduces the assessment, even if that settlement is not justified by the data and the facts. What that means is that taxpayers as a whole, especially residential taxpayers, bear a heavier burden than they should, because commercial assessments are reduced, not because the original assessment does not reflect actual market value, but because the court would rather see them settle. I think you articulated better than I could have the precise problem with the current system. And that's why a non-judicial approach that involved a panel that is willing, in fact, to make decisions that are binding based on the data and the fact, rather than encouraging parties to settle, is an important part of creating a fairer, more accurate system. Now, again, I would suggest that the other elements of reform proposed are also very important. Requiring a full appraisal to accompany an appeal is important, so that you cannot, at very low cost, no burden, no risk, file what is essentially a frivolous appeal, and for the precise reason you say, come out with a win because you're encouraged to settle. That's very important. And eliminating the contingency fee arrangements to eliminate the extraordinary incentive to file as many appeals as possible. We have right now a system that fundamentally is not working and is unfair to those taxpayers who ultimately bear the burden when appeals are settled in a way that is convenient for a court, but not accurate.
Well, the court has no authority or power to compel any of the parties to settle. If you want to go to trial, you can go to trial, right?
Well, Representative, I think, as you know, judges have, first of all, as you know, trials are long and costly and burdensome. And when you have a city or a town that is as large as mine is, or even a smaller one, and you have some individuals who have figured out how to use this system to make a profit and file hundreds of appeals, that is an unmanageable burden to place on the small tax assessment staff that a city has. Secondly, judges will often strongly urge and encourage parties to settle and leave parties under the impression that a failure to settle may well result in an unfavorable result.
Well, but that's not that you go in front of two different judges. The judge that is handling your case is not the judge who would be encouraging you to settle. It's a different judge. You go before generally a judge trial referee who will try to get you to settle. And if you don't settle, you go back to the judge that's handling your case and say, Judge, we couldn't settle it. Give us a trial date. I think you know it's not. Hold on. Your indication that if you don't settle, the judge handling your case is going to rule against you. Ultimately, I think that's misplaced.
Representative, I would be curious if you have any views on the other point, which is that it is simply not practical for any municipality to bring to trial the multitude of appeals that are received and are incentivized under the current system.
I understand, but what that does is you're arguing both sides of the argument. You're saying that you don't want to be forced to settle, but you also don't want to go to trial. Well,
which is why
you've got a legitimate tax appeal, you've got to do one or the other.
Which is why I would recommend first those three changes that have to do with eliminating the incentive for the filing of frivolous appeals in the first place, right? So let's separate out of the four reforms that I spoke about. Only one of them has to do with the structure of the appeals process, and I'd be happy to talk more about that. The others are about trying to ensure that the appeals that are brought to begin with are meritorious, and that regardless of who decides those cases, that is important. Contingency fee arrangements incentivize.
Let me ask you about that. Let me ask you about that. You said that you would want to require an assessment or an appraisal within 90 days before the appeal is brought, right?
Within 90 days of filing an appeal, Representative.
Okay. What about if the appeal is of a time that's in the past? Like, if you get an appraisal that's, from a prior grand list, why would you require an appraisal? Or if it's a small property with a small, just a property owner with their house, you're going to mandate that they pay somebody to do an appraisal on the house?
Representative, I think it would be entirely sensible to limit this recommendation to larger properties, and particularly commercial properties or large residential and commercial properties.
Okay. And I won't go into the issue with regard to contingency. We've discussed that previously, and how that, I think that's a solution that doesn't, that's a tactic or an effort that doesn't address the issue that you're looking to solve. And perhaps there are better ways to solve it, such as penalizing somebody who brings a frivolous claim, as opposed to trying to prevent people up front from using an expert that they may want to use. But we can discuss that later.
Representative, if I may, I think we do have a disagreement on that. I don't think there's any way in which the prevention of contingency arrangements prevents someone from using the expert that they want to use. What it does is prevent experts from throwing countless Hail Marys against a municipality that clog up the system, and because they hope for a result that is maximally disadvantageous to all the other taxpayers in a municipality.
Well, you will admit that by preventing somebody from using an expert on contingency, you are making it cost them more up front, right?
I'm going to make a suggestion here. This is a conversation that needs to take place. We have had five speakers. We have 60 left. We're almost 2 hours in.
Yep.
I would like to have a meeting where we could sit down at a table and discuss this, because it's something that needs to be discussed. It's a committee issue. It shouldn't be resolved here in a public hearing. I think that the points that have been raised are clear to all of us that the discussion needs to take place. So I would recommend that we, after this meeting, we'll set up time and let's have that. The expertise that you have, as Representative Bitty has, from the mayor's point of view as well. Rep Zullo has been in the same process, so we have line to try to come up with a resolution. I'd like to do in a separate meeting. Is that all right with everyone?
Thank you, Mr. Chairman.
All right. And with that, then we're going to let Mayor Bronin go, and Mayor will be in touch. We'll set up a meeting. It's obvious that it's what we need to do, and I look forward to that. Now, I know Rep Zullo, you had a comment. I don't want to freeze you out here, so I'm going to turn it to Rep Zullo for a second.
Thank you, Mr. Chair. And just very briefly, I felt like, and good afternoon, Mr. Mayor. I felt you got cut off just a bit on House Bill 5172. And I just wanted to follow up on the your comment on the saving costs for towns. Do you see this as a cost saving measure for municipalities?
Thanks very much, Representative Zullo. So what this bill has to do with is a situation in which an employee who has retired from a municipality is seeking employment at another municipality that participates in the MERS system. There is a cost savings in a sense, both to the state and to the city, because under this proposed legislation, the retiree would not be able to participate in a new pension. So in that sense, the overall fringe benefit costs to the state and to the city are lower than if an employee who was participating in a new pension were hired. But I think fundamentally it is a question of competitiveness for municipalities in what is an increasingly tight labor market. And there's no public policy justification for saying that someone should be able to collect their pension while working for a municipality in Massachusetts or for a private employer, but cannot work for another municipality without surrendering their pension payments.
I appreciate the perspective, and in this kind of aggressive labor market, I think we need to give municipalities as many tools as we can to recruit the best people. And I think it also helps that we're getting people with municipal experience. A lot of times you're retiring from one municipality, but going to another and serving in a very similar role, whether it's public safety or education or something like that. So that savings as far as retraining is also helpful. So
absolutely,
I won't tie up any more time. I just wanted to give you that opportunity, and thank you for the insight.
I appreciate it, Representative. Thank you. Thank you, Mr. Chair.
Thank you, everyone. I appreciate and we will get back together. All right, I believe Linda Ivona is on deck, followed by Jason Bowser, and then Priya Morgenstern.
Hello, distinguished members of the Planning and Development Committee. I'm here to support HB 5168, an act concerning property tax exemptions for property used for charitable purposes, which would take steps to ensure that nonprofit charitable property tax exemptions are protected. My name is Linda Ivona, and I'm the CEO at CCARC Inc. in New Britain. We are a private provider of services for people with intellectual and developmental disabilities. We employ 270 people throughout central Connecticut and provide residential, day, employment, and vocational services for over 200 people. I believe that it is and has been the legislative intent to allow property owned or leased by a nonprofit and used for charitable purposes to be exempt from property taxes. Over the past several years, the language in the statute has been questioned, and assessors of many towns began taxing nonprofits' property. I previously worked in Middlesex County, and Cromwell began taxing group homes that had never been taxed before. And this resulted in an expensive lawsuit that, to my knowledge, has not been finalized. Now I'm here in New Britain, and CCARC has been being taxed on group homes in Plainville and Berlin. We recently applied for exemption and were granted it in both towns, but I did have a rather lengthy discussion with one town assessor where we debated the meaning of the word temporary and the intent behind it. And we had discussion about the individuals that lived in the group home as well. Now, understandably, he has the responsibility to taxpayers and the municipality, while I have a responsibility to CCARC, the program participants and their families. The interpretation of the statute should not be left to individual agencies and or assessors. The disagreement of interpretation causes costly litigation and or payment of taxes on property that is technically tax exempt from the law. In either case, critical funding is unnecessarily diverted away from direct service provisions to people in need. Nonprofits have not had an increase in rates in over a decade, while operating expenses have increased annually. And there has been an allocation of funding. There has not been an allocation of funding to nonprofits to offset these unbudgeted costs of taxes. While I was in Middletown, there was a loss annually for the cost of the taxes over $24K a year. And at CCARC, we were paying over $10,600 annually. HB 5168 is not an expansion of tax exemptions, but rather has many positive results. In particular, not eliminating subjective interpretation. It creates one statewide exemption form, so there's uniformity. Many nonprofits operate in numerous towns, and it will allow nonprofits to recoup attorneys' fees. I believe I'm coming up on my time, so I'm going to kind of slip to the end here. I want to thank you for raising this important bill, and I urge you to support HB 5168. Thank you for your time.
Thank you for your testimony. Any questions for Linda at all? Seeing none, thank you so much. First Selectman Jason Bowser.
Thank you, Senator, and good afternoon. And thank you to you and the members of the committee for the opportunity to speak today in support of HB 5166. Economic development is something that the town of East Windsor has been working hard on over the last couple of years, and we have been employing a number of strategies to help us grow our grant lists. We've had some success in that, growing our grant list by more than $50 million over the last 2 years. And there are a number of strategies that we have used to do that. We've done concept plan reviews and planned commercial development district implementation. We've done marketing and demographic studies. We've integrated partners into the process like Advanced CT, Metro Hartford Alliance, our regional and local chambers of commerce. And we've seen some successes. But the one thing that we have tried to use, and we find ourselves a little bit at a competitive disadvantage with in terms of our neighboring communities, are tax abatements. The way the statute is currently written, tax abatements need they need to be negotiated. They need to be approved by the Board of Selectmen, and then they need to go through a town meeting under our form of government. This happens at the same time that my community passed an ordinance 5 or so years ago where we delegated that decision-making authority in terms of tax abatements from the town meeting to the Board of Selectmen. The problem that we've run into, though, is that the statute as written doesn't allow that authority to be delegated from the town meeting to the Board of Selectmen, despite our town meeting's interest in so doing. And that leaves us at a competitive disadvantage to towns that have a different form of government than we do, where whether it's a manager council form of government or a strong mayor form of government, the legislative body is a board constituted similarly to my Board of Selectmen, except we have several added steps and added time that is required to enter into tax abatements when we're trying to close a deal for new development in the community. I don't believe that tax abatements are what start conversations around economic development, but I do believe that they can certainly help finish those conversations. And so what we're asking for is for the statute to be changed to allow that delegation from town meeting to the executive body, which is the Board of Selectmen, to be permissible, as my town has already tried to do and realized after the fact that it was not something that was delegable. So I appreciate the time to speak with you about this. I certainly appreciate the committee's willingness to raise the concept again, and I'm hoping to answer any questions that anybody may have.
Yes, Representative Hall.
Thank you, Senator, and welcome First Selectman Bowser. It's great to see you here today. And basically, all you're asking for is the same ability that all your neighboring towns to your north and to your south have the ability to do, kind of level the playing field, if you will. And it's not, I think, one of my first questions when this bill was raised is the ability doesn't go to you personally, unless your First Selectman board okay that ability, but it does go to the governing body, and all our other forms of government, council, strong mayor, have the ability to do this. So all you're asking for here is a level playing field, so to speak. So I strongly support this bill, and I think last year when we discussed it, it did get through part of the process and just didn't quite make it all the way through. So I want to thank you for your testimony, and it makes perfect sense to me, and you definitely have my support on the bill, and thank you for testifying today.
Thank you, Representative Hall. I appreciate that. And you did put a finer point on something that I had meant to clarify. In the First Selectman town meeting form of government, I am the chief executive of the town of East Windsor, but I am not the legislative body. That executive authority is based in all 5 members of my board. I can't so much as sign a contract changing the vendor for the ATM machine in the hallway without the Board of Selectmen's acquiescence. And so all we're doing is to try and provide consistency and expediency in the economic development process, particularly in relation to towns to the north and south of us that move at a much more deliberate pace than I am able to. So if the choice is between a parcel in South Windsor and a parcel in East Windsor, South Windsor could conceivably use a tax abatement to close the deal faster than I am able to do so. And that's something, if you're looking to locate a business someplace, your interest is having a shovel in the ground or a ribbon cutting opening the facility within a fixed time frame. I'm already at a disadvantage in that circumstance. So thank you for your words of support and for allowing me the opportunity to clarify that.
Absolutely. Thank you so much.
Rep. Davinsky.
Thank you, Mr. Chairman. And thank you, Mr. Bowser, for coming in. Now, in your view, what would be the process for the Board of Selectmen or the executives from getting this authority? How would that authority come to you?
I'm not sure I understand your question. Can you word that? Would it go? How do you? You're looking to have the town or the delegation of this authority. In what way would it be delegated? Would there be a town meeting at which the issue is discussed? How would that work? Yeah, so thank you for that. And I do understand your point now. So again, back in 2016, we actually passed an ordinance at town meeting allowing the town to enter into tax abatements or fixed assessment agreements. The town meeting passed the ordinance allowing the Board of Selectmen to do that. So I would imagine that those towns in my circumstance that are interested in availing themselves of what I'm requesting today would have to go through that same process where they would have to pass a local ordinance that specifies that the town meeting is granting the authority to the executive body, which is the Board of Selectmen. I'm sorry, go ahead.
But generally, the selectmen would draft an ordinance and put it on the agenda for the town meeting, right?
Yeah.
Okay, so if the town decided that the Board of Selectmen was abusing its authority, how would they take it back?
Well, certainly first and foremost, the Board of Selectmen are accountable to the voters on a 2-year cycle. So the voters could absolutely correct that abuse by saying, we're removing you from the equation. I suppose a community that was concerned about that could also write into an ordinance some sort of a recapture provision, or limitations. So for example, 12-65B allows for the tax abatements to be implemented in up to 10 years. My ordinance, and actually the part that is operable, only allows us to do that up to 7 years. So the town meeting did put additional limitations on the powers that they expected us to execute in the ordinance that they passed, more restrictive than the statute allows for.
Well, I guess my question is, any delegation of authority, there's a way to delegate it and generally a way to undelegate it. And I'm just wondering what's the, if it goes by ordinance, it doesn't sound like there's a way to undelegate it. Unless there's a way that the members of the public can have a town meeting to abolish an ordinance or something like that. Is there a way to do that?
There is a mechanism in the general statutes, and without the benefit of looking it up, I think it's CGS 7-9 that allows for an ordinance to be brought to a town meeting by petition, and it's a ministerial act that requires the executive board to set set a town meeting to consider a petitioned ordinance. Don't quote me on the chapter and verse, but I'm pretty sure it's right around there. There have been other instances actually in my community where we have dealt with petitions to town meeting that have actually gone to referendum. So I'm familiar with the ministerial provision that already exists in the statute, which could be employed to correct a circumstance that you raise.
Right, well, I appreciate that. I just wanted to make sure that it wasn't a one-way delegation that was unreversible if the town meeting decided that they wanted to reverse it. I appreciate it, and it sounds like a reasonable way to even out the powers between towns. Almost all of my towns operate under town meeting, and I hate to think that they were at some type of competitive disadvantage to a municipality that could move with greater speed to attract a business or do something else that might be beneficial to business development. So I thank you for your time, and thank you, Mr. Chairman.
Thank you. Representative Smith.
Thank you, Mr. Chair. Thank you, Mr. Bowser. I think this question perhaps should have been asked earlier of Representative Foster, but I'm going to just ask you to get your sense of it. So my recollection when the statute was originally passed was that the limit was 7 years. So it's obviously changed in the 20 or so years it's been on the books. But in our town here in Colchester, I was on and chaired the Economic Development Commission when this process took place. And we did in fact approve that ordinance. In our town, Economic Development makes a recommendation to the Board of Selectmen. If the Board of Selectmen accepts that recommendation, they have to vote that it go to a town meeting in order to become, to actually be approved. So my question is whether or not this change would, sort of override a pre-existing a process that's been established by a town that, adopted the tax incentive program years ago. Do you know that, or have you considered that question, or has it come up?
Well, as I understand the bill before you and the intention of the bill before you, it would be permissive and not compulsory. So A town could decide that they wanted to shorten that process if they so chose, but they wouldn't be made to. And certainly that's the circumstance that the town of East Windsor thought we were doing when that ordinance was passed in the previous administration, previous local administration. They thought that they were taking a step that they were allowed to take to make that process more streamlined. And upon further review, and when we tried to implement it, it was pointed out that the statute does not allow us to do that. So I'm not looking to force any community to change their process. I'm just looking to give communities in circumstances like mine the opportunity to do so if that makes sense for them.
Okay, so I understand that. So basically, you're in the situation that my town is in right now as well. We do have to take that extra step. You know, I mean, historically, they've been fairly non-controversial, but there is a time factor that gets involved in calling a town meeting. So I understand your point, and I would be supportive of the bill. Thank you.
Thank you, sir.
Thank you. Seeing no other hands raised, First Selectman Bowser, thank you very much for your testimony. Appreciate seeing you here.
Thank you, Senator, and thank you for the time.
You're welcome. Priya Morgenstern from Pro Bono Partnership.
Thank you very much.
Priya is here, and Priya, you'll be followed by Kate Barodi.
Thank you. Good afternoon, members of the Planning and Development Committee. I welcome the opportunity to testify today on behalf of House Bill 5168 regarding property tax exemptions for charitable organizations. My name is Priya Morgenstern, and I direct the Pro Bono Partnership here in Connecticut. We are ourselves a 501c3 nonprofit organization, and we provide free legal assistance to other nonprofits across the tri-state region. We serve a wide variety of nonprofits. Our clients feed the hungry, house the homeless, they promote the arts, they do education, they protect the environment and animals, and they provide essential services to families, children, the elderly, immigrants, individuals with disabilities, and more. Last year in Connecticut alone, we provided over $5.8 million of free legal assistance to nonprofits across the nutmeg state. So my position brings me into contact with a lot of nonprofits and nonprofit leaders. And I can tell you every single one of them is struggling to keep their heads above water and to do more with less to continue delivering critical services and to achieve their missions. But unfortunately, many of these nonprofits, some of whom are our clients and some of whom you're going to hear from today, or already heard from, in fact, they've been hit with property tax bills for property that previously, sometimes for decades or even generations, was regarded as tax exempt. And this is even though nothing has changed from before. It's the same organization, the same location, the same facility, the same services being provided, the same organizational mission. Nothing's different. The bills come as a surprise, they're not budgeted for, and they're often significant. And it's just wrong for our nonprofits that are trying to work so hard to be hit this way. House Bill 5168 is intended to address this situation. It's important to note it's not an expansion of tax exemption. Rather, among its provisions, the bill clarifies which organizations qualify for those exemptions. It creates a single statewide application form that assures that nonprofits across the state are treated equally from town to town and assures that they don't have to provide irrelevant or extraneous information. And third, it requires assessors to provide reasons if they're going to revoke or deny tax exemption. So overall, this is good for nonprofits, it's good for the people they serve, it's good for our communities. So given that the Pro Bono Partnership is all about strengthening our nonprofit community, I'm very pleased to support 5168. Thank you for raising this bill, and we look forward to your support. Thank you very much.
Thank you for testifying. Are there any questions? Representative McCarthy-Vahey, Madam Chair.
Thank you, Mr. Chair. I will be brief, but Ms. Morgenstern, thank you very much for speaking to this issue so clearly and for the work that you do representing and supporting so many of our nonprofits who support us. I know this is an issue that's come before our committee many times. There's been subsequent litigation since we last met as a committee. We had bipartisan support for this bill last year coming out of committee, and I'm hopeful that we can continue in that way again this year. So thanks for your time here with us today. Thank you, Mr. Chair.
And thank you for your
Thank you.
support.
Other questions? Seeing none, thank you for your testimony.
Thank you.
It was Kate Barodi, and then I did miss from New Haven, Kevin Alvarez, if Kevin is still on.
Mr. Alvarez will not be testifying today.
Okay. Kate Barodi.
Yeah.
Yin Wu and Daniel Casagrady.
Good afternoon. Thank you. Thank you. It's Kate Byrode. The E is silent. Some ancestor stuck it on.
Okay.
Good afternoon, Senator Cassano, Representative McCarthy-Vahey, Senator Needleman, Representative Goupil, Senator Wong, and members of the Planning and Development Committee. I am the director of the Creighton Memorial Library in Colchester. I'm speaking in support of Senate Bill number 131, raised by Senator Wong. The town of Colchester budgets $53,000 a year for the purchase of library materials. This includes books, magazines, newspapers, music, movies, ebooks, e-audiobooks, and databases, everything borrowed by our users. It isn't a lot of money, about $3.51 per capita. We never pay sticker price for physical library materials, substantially increasing the value of our residents $3.51 per capita. However, we pay substantially more for ebooks and e-audiobooks than we would for their physical counterparts. I included a comparison of the prices of books on the New York Times bestseller list with my written testimony. The bottom line, libraries pay 370% more for the same set of ebooks than an individual would pay on Amazon, and 278% more for the e-audiobooks. Even more challenging is that after paying these inflated prices, nearly all of these titles will time out of the collection in 24 months. Imagine if the 2,600 or so physical items that we purchase each year for the library simply vanished off of the shelves after 2 years. It would be impossible to build a collection that serves Colchester well. Imagine if all of the producers of copier paper decided that government, and only government, should pay 370% more for their product and would not negotiate with government. I do not believe that publishers have higher costs to produce digital content. My evidence is how digital materials are priced for the public. While Colchester's funds may be limited, my staff uses them wisely to serve Colchester, and we purchase thousands of books every year, putting money in the pockets of publishers and authors. I look for a bill that would enable libraries in Connecticut to purchase digital materials at fair and equitable prices with lending models that would allow us to build meaningful digital collections for Colchester. Thank you.
Thank you for your testimony. And I knew that Rep. Smith would want to say something. Representative Smith, welcome.
Hi, Brian.
I think Representative Del Nicky beat me to the punch there, Mr. Chairman. His hand popped up right before mine did. I would defer to him.
I will yield to you,
Well, thank you so much. Thank you, Kate, for appearing here and for your testimony. And, you know, as I look out my window and see the library that you're the wonderful shepherd of virtually across the street, I'd like to thank you on behalf of everyone in Colchester for the amazing job that you and your colleagues do for us all. I was curious, when I looked at the chart that you showed us, it was indeed shocking to see the price differentials, and particularly, I guess, as compared to an individual buying those items. So I guess my question is, exactly what's the process that you use as a library to buy ebooks? And why is it so different?
It's so different because the publishers the publishers control it so heavily. When I buy physical materials, I buy from vendors. Very few libraries buy directly from the major publishers. There's different jobbers, Baker and Taylor, Ingram, and a number of others. And we have statewide purchasing contracts that allow us to buy those physical materials at statewide negotiated discount rates. Ellen Paul from CLC can speak to that. When we buy, or actually we license digital materials, even though we're using a middleman, Overdrive or Hoopla or another platform, the prices are set in stone by the publishers, and the vendor that we're dealing with to provide the platform has no wiggle room to make things cheaper. So essentially, they're controlling the market. And, you know, frankly, I don't think they really want us to be their customers in this area.
Yeah, I guess I could see that.
So there's a company called Overdrive. So these prices are all Overdrive prices. There's another company called Hoopla, and Hoopla operates on a different basis. So if a library, so Colchester does not use Hoopla because it's so expensive. Towns that have Hoopla set a budget for how much they're going to spend on Hoopla, and then they restrict the number of loans per month, and then they pay based on the use of the Hoopla collection. So it's so it can be 99 cents, it can be $3.99, it can be $9.99 just for one use for one patron. So it's wildly expensive.
Okay, well, thank you for that. I appreciate it. And I guess I will yield back to Representative Delnicki.
Thank you, Rep. Smith. Representative Delnicki.
Thank you, Mr. Chair. And Kate, thank you for coming forward. I had a conversation the other day with my librarian, Mary Etter, about the cost factor here and what it does to their library budget and how it affects it, and how electronic data, books have become today's common way of doing business.
Yeah.
Yet libraries are penalized to do business in that fashion. And could you tell me what you feel is an equitable cost? And I do have to make one comment before I get that answer. I want to thank Senator Wong for having stewarded this bill through here and requested it, because I think it's a fantastic thing that we need to deal with. And if we're looking at municipal budgets and how they're affected and how library budgets are affected, buying electronics should be a way to save money, not to cost a huge amount of money more. And secondly, the fact that they literally evaporate after a period of time is shocking. Go ahead.
Thank you. You understand the situation really well. So I would say that something that would be equitable would be that when we license an item, that we do purchase it, we can keep it indefinitely. And that the decision for it to leave our collection is just like with our physical materials, because books wear out, books stop being interesting to people, books stop being current and accurate. So that we would manage our collection, our digital collections, the same way we manage our physical collections. So right there, and I would want to see pricing that was, it cannot cost more to produce an ebook than it does to produce a paper book. It just cannot, because they're not being shipped back to the United States from China. They're just can't cost more to produce. So I'd like pricing that somehow reflected the actual cost, because when we buy those physical books, the list price on, if you look at that chart, the list price is, $29, $30, something like that. And we get 45% off. Well, the publisher has made a profit. He's paid the author, and the jobber is making a profit before we get that 45% discount. So it is clearly possible for them to conduct business and make profits all along the distribution chain at those pricing levels. So this is not a business case. This is, I think it's anti-competitive practices, but I'm not a lawyer. I can't make a legal opinion. So I would like to see something equitable. The pricing was, let's say, because we can hold on to it indefinitely and it will never wear out. Let's say that we paid the list price of the hardcover, so $29, $30, which is still a lot more than we pay for the paper book, but that we had a perpetual license. And we only lend these one copy, one user at a time. So just like when the new James Patterson arrives at the library, we buy 4 or 5 copies to help move the reserve list along so more people can read it sooner and faster. We would buy multiple copies, but right now we can't even afford to buy multiple copies of our e-licenses because it's so prohibitively expensive.
Well, I thank you for your commentary there. To me, this is an issue that affects literally every city and every town in the state of Connecticut, because I'm assuming that you all have to abide by the same rules when it comes to temporarily purchasing the ebooks. Is that correct?
Yes, yes. Technically, we're licensing the material because it's software, and that gets into other legal areas. But yeah, we don't actually purchase; we lease, if you will. And it's it's just no way to build a meaningful library collection.
Yeah, and I only use the term purchasing, temporarily purchasing, try to put a face to the issue, and the fact that the licensing literally evaporates after that period of time.
Yeah.
Again, thank you for coming forward and testifying on the issue, and have a great day.
Thank you.
Thank you, Rep. Delnicki. Chairman McCarthy-Vahey.
Thank you very much, Mr. Chairman. And Kate, it's wonderful to see you. Thank you for being here with us. And thank you to you and every librarian out there. I currently have Cast as an audiobook on my device, and I also have a hard copy on my nightstand, so I can alternate back and forth. And I think our librarian in Fairfield has said that I think we're well over 1/3 of users in Fairfield who are primarily using their devices to lend things out from the library. I just want to follow up with a question. I know you were mentioning prices.
Yep.
Earlier you were talking about percentages. So just to clarify, to use my example of the book Cast, if you were to buy a hardcover physical copy of that book for the library versus the leasing or purchasing the license, I'll use the term leasing, which, as you said, you have a limited time period, perhaps 26 loans for the period of a year, for example. What is the price differential between those two things, or approximately what would that look like?
I think the list price of Cast off the top of my head would be about $30, maybe $35. So for the physical copy, and we would pay roughly $17 for that copy, for a physical copy. So the book on your nightstand costs $17 for the library. You're listening to e-audiobook, that is probably $90. Now, the good thing about audiobooks is that although they've started to model to this vaporizing in the last few years, most of them are still available with a perpetual license, so that's somewhat better. And we do know that audiobooks have higher production costs. So, like the ones on CD had comparable pricing. So that's the audiobook, but the ebook would probably be priced at $60. And then in 2 years, that ebook would disappear from the collection. And we'd have to decide, is it worth buying or leasing again for the community? And a book like Cast has a lot of value over time, probably. But that paper copy, we could have it for 40 years. Last week, I put a book into the hands of a patron that was published and purchased by the library in 1949. It's still valuable. The book hasn't fallen apart yet.
That's extremely helpful to understand very specifically. And also, I appreciate you differentiating between the ebook and the audiobook and the production cost differences. I accidentally borrowed the ebook first and couldn't figure out how to return it either. But thank you, Kate, very much for this. And I know that there have been some legal issues in other states. And I think that it's a worthwhile conversation for us to continue through to see how we can work on this, because as we've said so many times, libraries serve folks from cradle to grave, and they offer the opportunity for everyone in the community to access information, knowledge, and connect to community. So very thankful for you and others who will be with us today. But since you're first, I thought I would ask you some of those questions. Thank you, Mr. Chair.
Thank you. Senator Wong.
Thank you, Mr. Chair. And Kate, indeed, since you are the first by the lucky draw, I want to take a moment to thank you and all the librarians in so many different capacities, reference, outreach, for your great work in the community. In our household, librarians are super cool. The other is an important point out that it's a unique budgeting process that our municipal libraries that serve our community, it gets no state funding in regards to how you conduct your business. I think the only state allocation is your interlibrary loan utilization. That's the only appropriations that you get. And that all of our libraries funding comes from our municipal budget items. So that's an important consideration. And of course, your various friends groups that are very strong supporters and donations from the community. And I think the other important part is another point that libraries is not just about books anymore. It's about digital, but it's also about meeting spaces, creating programs of jobs and various other community interests. I know in Fairfield, we're about to do a one book, one town kind of celebration of bringing the community together. It really has been a tremendous haven for many in our community. And some people we take for granted that don't always have broadband access. Libraries serve as an avenue for broadband access as well. So since you're the first and many other librarians will follow, I just want to take this moment and do a pitch from standpoint. We're looking at electronic books and copyright concerns and cost efficiencies, but it is important for us to note, and I won't repeat it, but it's important to note that libraries are such an integral part of our community. It's the very fabric of our founding and knowledge and democracy. So thank you very, very much. And you get to hear all this because you're the first. So many others, I hope, will know that we care deeply about them. Thank you, Mr. Chair.
Thank you, Senator. And following up on your comment, there are several libraries, librarians that have signed up to testify today, which is kind of heartwarming to see. We know what it's like just trying to get an improvement physically on a library building. People say, well, we don't need libraries anymore. It's examples like this that really help people understand the value.
Well, if I may, Mr. Chairman, also
Yes,
for me to extend my appreciation and acknowledgement of yourself as chair and Representative McCarthy-Vahey and Representative Zullo as the leadership of this committee to recognize the importance of this and all of you shepherding this bill through. It's a committee work. And I think we all agree that we all love our libraries, but sometimes we don't always acknowledge what we need to do to help and support them. But I want to thank the leadership and acknowledge all of you for being leaders on this bill as well. Thank you, Mr. Chair.
Thank you. Well said. Yanji Wu. I didn't see his name come up on there anywhere. Yanji Wu, number 12. Okay, I'm going to pass on. I see Dan Casagrande is here. Casagrande. Dan?
Yes, thank you, Mr. Chairman. And thank you to the committee for the opportunity to comment on HB 5168. My name is Daniel Casagrande. I'm a lawyer and a partner in the law firm of Kramer and Anderson in Danbury. I submit my testimony on behalf of the Caring Community of Connecticut, Inc. I represent Caring Community in a pending appeal under General Statute Section 12-119 from the town of Colchester's denial of charitable purpose tax exemptions under 1281-7 for 7 properties that Caring Community owns in the town. For many years prior to the 2015 grand list, Colchester had exempted all 7 of these properties as devoted to a charitable purpose. As of the 2015 grand list, however, the Colchester assessor determined that the properties were no longer exempt because they constitute, quote, subsidized housing, close quote, which is not, quote, temporary housing, and thus is subject to taxation under the current version of 1281-7B. The case is scheduled for trial this spring. It's been pending since 2016. Caring Community owns and operates 19 community living arrangements, CLAs, in Eastern Connecticut, including the 7 properties in Colchester. The parties have agreed that at all times Caring Community has operated these properties exclusively as CLAs and for no other purpose. Caring Community is recognized by the IRS as a tax-exempt charitable organization. It's undisputed, Mr. Chairman, that Caring Community's target clientele are individuals who would otherwise require care in long-term, state-funded and operated CLAs or other large institutional programs such as the former Mansfield and Southbury training schools. Caring Community's CLAs provide 24/7 intensive care and rehabilitative services to their residents who suffer from severe intellectual disabilities. The CLAs relieve the state of a legal and financial burden because they discharge the state's responsibility to care for these individuals at a cost which is less than what it would cost the state, substantially less, frankly, than what it would cost the state to provide the services in state-run programs. There's no question, Mr. Chairman, that the average length of stay of individuals in Caring Communities CLAs is several years. Many of the residents come in there and they stay there until they die. The town, however, has seized on the term temporary housing in 1281-7B, the current version, to say, well, this is just housing and it's not temporary, and therefore you don't qualify for the exemption.
Mr. Casagrande, your time is almost up.
Okay, thank you. We intend to prove at trial that the CLAs are not housing within any sense of the term. But more importantly, I want to just say we support the enactment of House Bill 5168, which would remove the term temporary from 1281-7B's exemption. And that's for 2 reasons. First, Colchester probably would never have revoked the charitable exemption that it had for years before granted the Caring Community had the statute not limited the exemption to temporary housing. More fundamentally, exempting from taxation a charitable purpose entity that provides shelter as part of its mission should not turn on whether the housing is temporary or permanent. That turns the statutory remedial purpose on its head. And it's inconsistent with the modern approach to charitable tax exemptions articulated by the Supreme Court in the St. Joseph's case. So the bill unquestionably would further the remedial purposes behind the tax exemptions, but failure to pass the bill, Mr. Chairman, would encourage the recent disturbing practices of several local assessors to deny exemptions to these types of entities for reasons totally unrelated to the critical charitable services these entities provide to disabled persons throughout the state. I also would echo the concern of prior speaker that we would ask the legislator to make clear that this is clarifying legislation so as to avoid the need for my client and other CLAs throughout the state to engage in continued costly litigation under the current statute. I thank you for your time, Mr. Chairman.
Thank you. And you have written testimony to submit.
I did. I submitted it the other day, Mr. Chairman.
Okay, great. Thank you very much. Your questions? Seeing none. I appreciate your testimony. And
Thank you, sir.
Obviously we will consider that. Laurie Malucci, then Brad Bullis and Chris Sparks. Laurie? I'm going to go up to Brad Bullis. I'll come back to Laurie if she's on. Brad, welcome.
Good afternoon. I'm here to testify on behalf of Senate Bill number 131, an act concerning electronic book licensing. Senator Cassano, Representative McCarthy-Vahey, and distinguished members of the Planning and Development Committee, thank you for having me here to speak today. So my name is Brad Bullis. I'm from the Connecticut State Library, and I oversee the state's ebook program, EgoCT. This program utilizes the PALIS Project app to deliver ebook and e-audio content to Connecticut's public libraries. PALIS takes our state purchase content and combines it with consortium and individual library purchase content and makes it seamlessly available all in one place. The state collection currently offers about 20,000 items to public libraries at no cost to them. But in the process of building this collection, I've been challenged both by the high cost of ebooks and the limits imposed by restrictive licenses. I'd like to share some of the licenses that we encounter as we try to do our collection development work. So before I do that, I'd also like to just reiterate that ebook licenses allow libraries to lease books, not to own them like we do print books. Now, the best possible license we could have would be a perpetual ownership and simultaneous use license. But that model is typically not available, especially for bestsellers and popular titles. One type of license that we often encounter would be time-based and metered. And what this means is you would say get 1 year, you would have an item, and during that year, you could actually loan it 26 times. At the end of the year, whether you had loaned it 26 times. Now, another model that's out there is provided by Hoopla, which is really like a pay per use or borrow. And it allows for simultaneous use, but it can be very cost prohibitive. Most libraries that take advantage of this model have to limit the number of loans their patrons can borrow each month. So it's not the best option necessarily. Kate had mentioned Overdrive. This is a model where the content provider also is providing the platform. And in this case, you have to purchase your content from them and then pay a platform fee to allow access for use of that content. I also want to share some of the more generous publishers who have worked out with distributors to come up with alternative license models that allow for simultaneous use or remove the time-limited component of a license. So you may have the same 26 loans I referenced earlier, but you can share it and there's no time limit associated. So that's much more beneficial for libraries. That way you get your return on investment. So as you can see from the discussion from Kate and myself, the ebook ecosystem is somewhat complicated, and the cost associated with these various models, as Kate referenced, can be up to 370% more expensive than purchasing a physical copy. So,
Mr. Bullis, your time is almost up.
Okay, I just want to say that an example of a title that I recently purchased as a print book it was a New York Times bestselling book. As a print book, it would cost about $15 for us to purchase it. For a 2-year license, I would have to pay $55 for the ebook. So that's almost 4 times as much that it would cost. So the cost of e-content obviously is too high to be sustainable, and we need to encourage publishers to provide models that allow libraries to effectively and equitably provide access to e-content to their communities without ruining their budgets. So I thank you for your time and attention, and I'll answer any questions.
Senator Wong.
Thank you, Mr. Chair. It would not be a planning and development without Senator Cassano on mute. Great to see that.
Now I'm comfortable.
Mr. Bullis, thank you very much for your work. Now, you handled this on a statewide basis, but you talked about the license expiring and the cost difference. You cited the price difference after 2 years it expires. You don't own this, right?
That's correct. We don't own it. And, it's very interesting. I started in this position in December of 2019. I began actively ordering content in February of 2020. So we're preparing for the launch of the Palace app. We actually have libraries going live now in the app. And so I'm trying to make sure that I have lots of content for them to access. And as I'm preparing for that, I took a look at our collection and I noticed that it was reduced from what it had been previously. And what I found is that items I ordered in February of 2020 have expired. So 500 items that we had in January are no longer available in February for libraries to access. And so this presents a budget challenge, a decision-making challenge. And you can either say, hey, we'll repurchase these items, so we'll pay again for the same thing, or we'll spend money on new titles. But it puts us in a bit of a difficult situation. And in the end, probably no one's going to be happy with the result.
And your budgetary constraints are quite evident in every budget cycle, but how does this impact the book collections that you provide to the various libraries? Does it limit access to informational bestsellers, New York Times bestsellers? Does this impact the kind of collection that you can provide to the libraries?
It can. It makes it much harder to purchase popular titles. And the state budget has remained flat for a number of years. And so when that happens, the dollars that we spend don't have quite the value they might have had 10 years ago. So we're very limited in terms of our ability to really grow robust collections. Even though we've been lucky at the state level, I think, to provide at least a basic collection for public libraries that maybe don't have the budget to purchase the items on their own.
Okay, and take me through, you prior to your role now with the state library system, you were involved with the New Haven library system. Would that be correct?
That is correct.
Okay, and just recently moved over to the state. Is that correct?
That is, in 2019, December of 2019.
So you talked a little bit briefly, but just a quick summarization. There are delivery platforms, unlike in Amazon Books, you buy through the Firebooks or various other platforms that you read, your iPad. Talk about the various forms of delivery and how the payment system works. I believe I've heard Hoopla, Overdrive. Can you differentiate the payment structure for that system? Because that's important to set the foundation in regards to how libraries manage their cost and how they kind of use that model. Hoopla versus Overdrive.
Right. So Hoopla is, when I utilized it in New Haven, I'll just give an example of what happened. So we basically, we budgeted a certain dollar amount so that we could provide these simultaneous use of items, which was great. So if there was a popular title, everyone could check it out at the same time. But we had budgeted a certain amount and it was used up within about the first 3 months of the year. So basically what we had to do is we had to kind of rethink how we were going to provide that content. And going forward, I think, as I said in my testimony, what we had to do is put a limit on the amount of items someone could check out. So a patron, instead of being able to check out whatever they want, whenever they want, it turned into maybe they could check out 4 or 5 items a month. And we sort of had to always adjust that based on where our budget was. So that puts a big limit on people's ability to access the materials they like through their library. And then with Overdrive is they provide content and it's at the costs I kind of explained that we see, so say for an ebook, it's going to be about $55 for a 2-year license. But you also have to pay a platform fee. And that's why the legislation back in 2013, I'm not sure which year it was, but the legislation then sort of helped us build the Ego program, which allows for one platform basically to have multiple streams of content, and libraries can use that platform to share the state collection and their individual collections with their patrons.
Thank you. You shared that the state in 2014 has created a platform that may be a model that we could look at. Now, what I understand when you said about the Ego program in New Haven, that you had allocated, I believe it was $50,000 for book programs, and it was so well subscribed by people that wanted to read and utilize your digital books in New Haven that it pretty much ran out of money because of overutilization, people wanting to read in less than 3 months. Is that correct?
That's correct. And that's what I was referencing when I talked about the hoopla. Basically, we had a purchase order for X amount of dollars, and I think it was around 40,000. And, you know, at the time, again, it was expended so quickly that we basically ran out of funds for the access to those materials in 3 months.
So, I mean, and I appreciate you taking us through the technical aspect of the delivery system. The other librarians, I think, will offer a little bit more of the broad array of services. But I'm going to ask every one of you from a proponent of this, from a concern of copyrights. We're very cognizant and we want to be very protective of that. But wouldn't it be accurate to say that the ability to discover authors and their books through the digital library access system would actually increase book sales? We're certainly pitching James Patterson here today.
Yeah, and really, any author I think that's represented in a library gets exposure that they wouldn't otherwise get. So discovery is certainly key. And so, you know, Library Journal did a study back in 2011, and they found that, you know, library users were avid book buyers as well. And then the Panorama Project did a study recently, and basically what they found is that 31% of library users eventually buy books that they discover in libraries from bookstores, and 35% eventually buy online books that they discovered in libraries. So either print or online, these books are getting purchased because of library discovery. And then 30% of library users will buy a book rather than wait if there's a long waiting list, you know, or a lot of holds on a book already. They'll just go buy the copy. So, you know, so you can see, I mean, that's roughly a third of library users are spending dollars based on their experience at the library.
Thank you very much, Mr. Chair. I appreciate the indulgence. Thank you. Thank you, Brad.
Thank you for your questions. Representative McCarthy-Vahey, Madam Chair.
Thank you, Mr. Chair. Thank you, Mr. Bolus, for being here with us. My question is one that I'm going to ask you to opine on that's a little outside of your field, which is our K-12 or pre-K-12 public schools. And I'm thinking of Doug Casey as I think of you today. I'm wondering what impact these pricing models have, in your opinion, on our public school system and their ability to provide content within the school setting as well.
Yeah, you know, I think in a lot of cases, the school library and media centers have even a more limited budget than, say, a public library does vis-a-vis ebooks. And so they're trying to provide the content that they need to support the curriculum. And, you know, in light of that, one of the things that we're working on, working with one of our vendors, is to deliver content from the EGO program directly to public schools. But of course, that takes dollars and it takes some cooperation, but we're currently working on that. And I think that's one way when you look at the sustainability and the future of the EGO program and how it can impact not just public libraries, but K through 12 and hopefully academic as well. There are some opportunities there if we can have adequate funding.
Thank you for your answer. Thank you, Mr. Chair.
Thank you. Seeing no other questions, I want to thank you for testifying and all the librarians. It's obviously that we have a situation here that needs to be dealt with and quickly. It's interesting. A lot of people, I keep hearing, well, you know, libraries, we don't need them anymore. You can get this, you can get that. And yet the libraries are increasing every year, more and more participation. Which is a great message to the general public that, yes, we do need them and we need to stock them the way they should be and we need to pay for it. And so I think this is a discussion that probably, as I know we said as leaders, we're going to probably get together and see how we can attack this besides just looking at the bill. Appreciate your being here. Thank you.
Thank you, sir.
Next on Dan Kasich, Dan spoke. All right. Laurie Malucci, did Laurie come in yet? Brad just left. Brad just left. Chris Fox.
Good afternoon, leadership and members of the Planning and Development Committee, state representatives and legislators. Thank you for the opportunity to speak. I am speaking in support of Bill 5170, improving the shelter standards. I am the Senior Animal Control Officer for the Bloomfield Police Department. I am a certified humane investigator in the state of Connecticut, and to my knowledge, the only certified humane investigator in the state. And I do support the language to establish a clear direction for me in this field in an entry capacity for speaking with and educating the citizens of Bloomfield about shelter standards for dogs that live outside. It, for me, presents a stopgap measure in what potentially could become a criminal offense, and instead starts it at a conversational level that may involve social services and a more proactive presence on scene when there is a shelter question. I do think that based on the metrics that I pulled up for 2019 and 2020, I had 17 shelter investigations and sheltering investigations between both summer and winter for 2019. I had 31 for 2020. I have not yet compiled the numbers for 2021 based on COVID distorting some of the numbers. I think others in my field would agree that all the dogs went somewhere in 2021. I don't know where they were, but we couldn't find them. So based on those numbers, I think that it would have been beneficial for me to be in the field and have language that supported what the needs are to keep a dog outside. Too often it is left to me to creatively comprise something within the town to then offer to pet owners to let them know what standards need to be met, what size needs to be met. And there are different standards in place for different breeds. If someone has a Chihuahua outside, the needs are clearly different than having a Malamute outside. I think it would be disrespectful to others in my field to suggest that we don't consider those parameters when dealing with the public and pet owners. I think that this language will prevent animals being in crisis more than they are now. I think it will be beneficial.
Thank you. Representative Michelle.
Thank you, Mr. Chair, and thank you, Chris Parks, for your testimony. Does this bill, which is clearly directed to irresponsible dog owners, give you enough direction while giving you sufficient flexibility to use your professional judgment in cases within municipalities?
Thank you for the question. Yes, I think that it does give a clear direction because it includes the language about the construction of a shelter. All too frequently in this town, I've been here for 17 years. I've been in the field for 23 years. All too frequently, I will get a pet owner who wants to show me what's essentially a plastic device used for perhaps storing oil that they have attached to the ground as a shelter for an animal. I can give you testimony for people keeping beagles in wire boxes and telling me that that's sufficient structure. So yes, I think that very clear definitions of what an animal requires. I mean, we're talking about bare bones language here. You make a box, and it has a pitched roof to keep rain from collecting on the top of it, and you put insulation material inside of it that doesn't absorb moisture. We're not looking at redefining the wheel here. It's 2022. If you don't know that putting your dog outside in freezing cold weather without insulation and protection from the elements is bad, then yeah, having some clear language to point that out and say what would be a good alternative would be necessary.
Well, thank you very much for your testimony. I think it reinforces the idea that we also want to ensure that most possible ACOs across the state also can interpret in the same way. So this is very helpful. Thank you very much, and thank you for all you do.
Thank you.
Any other questions? Thank you very much for your testimony. In fact, your testimony cleared up some of the concerns that I think were raised earlier, so I appreciate that. Moving on.
Thank you, sir.
You're welcome. Number 17, Kathy Flaherty, 18, Emmeline Harrigan, 19, Nelson Malowitz. Kathy Flaherty is here. Welcome.
Thank you, Senator Casano, Representative McCarthy-Vehy, and members of the Planning and Development Committee. My name is Kathy Flaherty. I am the Executive Director of Connecticut Legal Rights Project. You have my written testimony, so I can keep this very short. I am in favor of Senate Bill 126. I know this is a concept that's been raised before about studying the accessibility of the Legislative Office Building and the state capitol. And I think you all know, the building was built in '88, which was 2 years before the passage of the ADA. And we want to make sure the buildings are accessible for everybody so that everybody can take part in the political process. Also here to testify in favor of 5168. This does not create a new charitable exemption. It simply preserves an already existing exemption and provides clarification, especially following the Connecticut Supreme Court decision that I linked to in my written testimony. And I encourage you to read that. As somebody who represents people with psychiatric disabilities, it's been incredibly discouraging to see elected officials in multiple towns around this state pose such difficulties to the charitable organizations that provide housing to the clients that we serve. Cromwell was found guilty of housing discrimination for what they did regarding a group home, Gilead's group home in Cromwell, that deprived people of opportunities to leave state hospital facilities, keeping people unnecessarily segregated and institutionalized is a violation of the ADA, and state policy should be set up so that people can live in our communities. It's pretty simple, and yet we are here repeatedly talking about this. I'd also point all the members of the committee to the written testimony from Attorney Hinson, who's also on your agenda at number 55 regarding Senate Bill 130. I'm not testifying on that bill, but I do support Attorney Hinson's testimony. So happy to answer any questions regarding either 126 or 5168. Thanks.
Are there any questions from committee members? Seeing none, Representative McCarthy-Vehy, Madam Chair.
Thank you, Mr. Chair. I just wanted to say thank you to Ms. Flaherty for her unceasing advocacy, and it's really wonderful to see you. Thanks, Mr. Chair.
Thank you.
Thank you.
Kathy, thank you very much.
Thank you. Have a great day.
You too now. Number 18, Emmeline Harrigan. I don't see her on the screen. Yes.
Hi there.
Emmeline, welcome.
Thank you, Mr. Chair and members of the Planning and Development Committee. I'm here to speak about HB 5165. I'm speaking on behalf of my co-chair, John Guskowski, and myself. We are the co-chairs of the Government Relations Committee for the Connecticut chapter of the American Planning Association. And this bill is regarding an act concerning the State Plan of Conservation and Development. As you know, the State Plan of Conservation and Development has been pending for quite some time, and it's in its fourth year of its fifth year plan. It identifies principles and policies for the state in terms of both development and conservation, just like regional plans of conservation and development and local plans of conservation and development. But it has not been adopted. So as the organization that represents planners, we feel that this is a very important document that the state should have available, and that it should finally be adopted. Hopefully with this adoption, we can start the work on doing some update to the Plan of Conservation and Development for the state. Many of the principles and policies are still very relevant to our state, but due to the pandemic and other things, we are experiencing rather intense housing pressures. I think that although climate change is discussed within the document, probably not with as much specificity as, we have new knowledge from our Connecticut Center for Climate Adaptation and Resiliency. So, I think that there could be principles and policies that could be updated, but it's still a very sound plan. So with that, again, CCAPA lends its support to moving forward on finally adopting this document. And, please, as the planning organization for the state, we hope that you will see us as a resource should you move forward in wanting to make any revisions to that plan. So I thank you so much for your time.
Thank you for your testimony. Are there questions from any of the committee members? Madam Chair, Representative McCarthy.
Thank you again, Mr. Chair. And Emmeline or Ms. Harrigan, I am thrilled to see you here, and I want to thank you for your leadership on the Government Relations Committee, the planners. You have been a resource to this committee. And just wanted to clarify, the bill before us today is not the resolution itself that is the plan. The bill addresses the process related to the plan. And we had the similar bill before us last year with the idea and intent that the resolution that the continuing legislative committee passed that includes that 2018 to 23 plan together with this bill would, for me personally, be the #1 priorities of the Planning and Development Committee this year. But just want to make sure that as you speak, that you are speaking in support of both of these items to move through the process together.
Certainly, yes.
Thank you. Thank you, Mr. Chair.
Thank you. Any other questions? Seeing none. Emmeline, thank you very much for your testimony. 19, Nelson Malowitz. Nelson, you've been waiting patiently. I can see Jim Haran and then David Kluski. Nelson, welcome.
Okay, well, thank you very much. I assume you can hear me okay.
Yes.
I'm speaking against really the proposed bill, LCO 970, SB 128, concerning foreclosures of unpaying sewer assessments and other fees and charges of a WPCA. And I'm chairman of a WPCA in a small town, Brookfield, but I'm also on the board of they changed the name, but it used to be the Connecticut Association of WPCAs. And what this bill was originally introduced to prevent foreclosures unless the principle of the of an assessment or some kind of a bill exceeds $10,000. Well, if the use bill in the state, the average use bill was $520. So to get to $10,000, if you didn't have an assessment, just the use, it would be 19 years that a WPCA would be deprived of revenue. This bill was originally introduced last year, and when it moved to the House, we had some discussions with the Connecticut Association of WPCAs with House members, and we asked what prompted this bill or what problem was it trying to solve. The representatives didn't really know, and so a little bit miffed that they didn't really know what was the root cause of this issue. There's a couple issues with it. One is that it calls for the property be owner occupied, but the term owner occupied is not defined in a Connecticut state statute. So there's no burden upon the owner, or whoever owns the property, to prove that it's owner occupied. So if a landlord goes in for 1 hour a year, he could declare it's owner occupied because it's without definition in the state. If somebody winters in another state for say 7 months and comes back, it doesn't meet the it doesn't meet the is that mine? It doesn't meet the requirement of owner occupied necessarily, because the IRS rules or wherever your primary residence is where it might be owner occupied. Anyway, it's a burden for a WPCA to, we're trying to deal with wastewater, and that to be in the legal business of determining who's owner occupied is really an unreasonable burden. The other thing is that there was a bill in New York recently that's been floated out, made national news for no eviction ever. Well, this is like a no foreclosure ever bill if it's 20 years where you end up having to not being able to
Mr. Malowitz, your time is almost up.
Yeah. So anyway, so it ends up being that there's no means test in this bill. So millionaires could escape the rule just by simply not paying, and a WPCA would be deprived of its revenue in order to run its operations, and that would be a health, safety, and environmental problem. So the other thing is that only a WPCA is singled out in this bill. No other utility, other utilities like electric, gas, cable, TV, or water can shut off their service, but a sewer commission can't. So there's no incentive for anybody to pay up. And anyway, in Brookfield, it's been very rare that we've had movements for foreclosures. Usually they always settle by a bank or a relative or something. It's settled in a private sector, and doesn't really need to be a burden for a WPCA to be deprived of its revenue in order to run its operation, which is it's America. We need sewers, and we have sewers. We expect sewers, and so to deprive the revenue would be.
Mr. Malowitz, thank you for your testimony, but your time is up.
Thank you.
Senator Casano would like to offer more.
Senator Champagne.
Thank you. Nelson, you said it would take 19 years to pay off that sewer bill or for to hit the $10,000 mark. Are you aware that after 15 years, the first payment would be automatically deleted? Which means if that person never pays, you would never collect the money from them. In essence, this is an argument that I brought up last year. So $500 and something is a little more than some of the small WPCAs collect. And my question to you is, if there's no means to collect, why would anybody pay?
Well, that's exactly the issue. So we're, in fact, it's not even said that it's not even limited to residents. It could be commercial businesses. It could be major enterprises that don't have to pay necessarily until it reaches $10,000. So anyway, there's no means test to. There's in the state, there's ways to sort of defer or even forgive taxes if you don't meet a certain income threshold. Well, that ought to be baked into this bill, that you have to have, there has to be a means test so that rich people, millionaires, can just skirt the bill and then pass it on to their next generation. So, so that's, it's an issue. If say 10% of the people, the average bill by a study was $520. If 10% of the people decide they're not going to pay because they don't have to, then the rate would go up to $570 just for honest people to cover the people that are skirting the bill.
Which means a lot less people would collect. So I had we had worked out a deal last year in the Senate. I had worked out a deal on this. It basically, instead of a dollar amount, make it a number of years, so that you can't really start a collection until it hits the 4-year mark. Do you see that as a better option?
Yeah, far better. In fact, we don't really do nuisance foreclosures. Nobody does from fellow WPCAs. So 4 years would be to the point where somebody is really stiffing you. So,
and normally it goes hand in hand. If they're not paying their sewer bill, they're usually not paying their taxes, and they go hand in hand, and both are collected at the tax sale. Usually that's a pretty drastic point, but to say we're not going to collect till we hit $10,000 with the expectation that most of the sewer authorities will not be able to collect anything ever, because it's never going to hit that dollar amount.
So it puts the burden on honest people.
Absolutely. And I actually am in charge of, two different WPCAs. One of them is a very small one based out of Bolton. And, when you only have maybe less than 600 people that are part of that, and you start subtracting people, it's going to get costly. It's going to get costly for the other people very fast.
No, that's right.
Okay. All right. Thank you.
Yeah.
Thank you. Madam Chair, Representative McCarthy-Vahey.
Thank you very much, Senator Casano. And Mr. Mowitz, it's nice to see you again. I remember speaking about the bill with you. And in fact, I may have been one of those representatives who wasn't as familiar with the nature of the issue. And I appreciate that we did have, per Senator Champagne's comments, conversation last year that there were members who were working together with Senator Looney and others to negotiate this bill. I would just, in terms of, understanding the issue from another perspective, if you're able to stay on and listen to our speaker number 27 or point you to the testimony there, that really gets at the nature of the concern and the issue on the other side of this in terms of the foreclosure process. But I also hear what you're saying, and I think that we will continue to have conversations related to this issue in the committee with you. And I've spoken to some others who I see here who will be testifying later on the issue as well. So thank you very much for being here with us today. And thank you, Mr. Chair.
Thank you. Other questions? Seeing none, Mr. Malowitz, item Jeff Gentle is number 27 is only a few away, so he represents Connecticut Fair Housing Center. He might have something to say.
All right, I have
Thank
also,
you.
sure.
All right, thank you for your testimony. Jim Haran, I haven't seen Jim on the screen. Jim Haran?
Yeah.
Okay. I'll find you here. Oh, I got you. Good to see you, Jim.
Good to
Welcome.
see you, Senator. Good afternoon, Senator Casano, Representative McCarthy-Vahey, Senator Wong, Representative Zullo, and members of the Planning and Development Committee. Thank you for the opportunity to provide testimony in support of HB 5171, specifically removing the municipal population threshold for certain parties to petition the Superior Court for appointment of a receiver for a blighted and abandoned property. I'm Jim Haran, Executive Director of the Connecticut Program of the Local Initiative Support Corporation, LISC, and a member of the Connecticut Vibrant Communities Coalition. LISC is a national community development organization that has worked in Connecticut since 1984. Our mission is to create resilient, inclusive communities, great places to live, work, do business, and raise families. LISC supports revitalization efforts in cities and towns across the state. As part of that work, we manage the Connecticut Vibrant Communities Coalition. This coalition is dedicated to transforming vacant, abandoned, and deteriorated properties into productive community assets. CVCC is comprised of over 35 municipalities and partner organizations which address these goals through education, peer learning, leadership, and policy development. In 2019, we, along with other members of the Connecticut Vibrant Communities Coalition, supported passage of Public Act 19-92, an act concerning abandoned and blighted property receivership. This legislation makes it possible for qualified entities to petition the court to become the receiver of a vacant or abandoned property, carry out necessary rehabilitation, and return it to productive use. This legislation enables approved receivers to transform problem properties into productive and tax-paying uses such as quality housing, economic development, and community facilities. The receivership statute provides a critical tool for communities in promoting redevelopment. It allows for parties in interest to file a petition with the Superior Court to be appointed as a receiver and take possession and undertake rehabilitation of a building. However, eligibility is currently restricted to those communities with populations of 35,000 or greater. This threshold limits the ability of CVC member towns like Derby, Windsor Locks, Newington, and New London from accessing the receivership process. In fact, 83% of Connecticut municipalities are excluded based on the population threshold, despite the pressing need to address blighted properties. At LISC, we believe that many smaller communities can benefit from this tool, particularly in the older industrial sections of towns. We respectfully request the committee to support and approve HB 5171, an act concerning abandoned and blighted property receivership. Removing the population threshold from the existing law will expand access to the receivership process as a strategy to address vacant and abandoned properties for all communities across Connecticut to generate economic development and create thriving places of opportunity. Thank you for the opportunity to testify today.
Thank you for your testimony, Jim. Are there any questions from any members of the committee? Representative McCarthy-Vahey.
Thank you very much, Mr. Chair, and thank you, Jim, for being here and for your work with LISC and on this issue previously. When we did pass this bill before, it was without any, originally, the original bill that came before us in 2019 was without any of the population thresholds. And in the course of the negotiation, I think in concert with folks from the Senate, that the decision was made to go with that 35,000. And I think I'm not sure if Rep. Dubitsky is here, so I'm going to go ahead and ask some of the questions that he might otherwise ask and some of the concerns that he has raised.
Sure.
Which is specifically, you know, the idea of a receivership. Does that really just let neighbors kind of take over other neighbors' property if they don't really like, you know, what's happening? I mean, I can say, I think this issue happens in communities of every size. We had an issue in our neighborhood at one point in time, and you know, we're a community of over 60,000. I know the cities have issues, and I think it happens in small communities. So if you can address that concern, which I understand.
Sure. Yeah. I mean, this requires an extensive legal process. You have to go to the Superior Court and request to be designated as a receiver, and not everybody can be designated. You have to be, you can be a property owner within 1,000 feet. You can be a nonprofit development organization, and there's other limited categories of who can qualify. But then even if you do qualify as a receiver to petition the court still has to find a whole series of conditions in order for you to be designated as the receiver. So in particular, the property has to be blighted. It has to not be occupied for 12 months. The owner has to not have tried to market the property for a period of 12 months. The property can't be subject to foreclosure. And then they have to find at least 3 conditions indicating that it's a public nuisance or a hazard to children or others in the area. So there's a whole series of provisions, and it doesn't just allow somebody to go in and be designated as the receiver. And then in addition, through the receivership process, if an owner can say that they will undertake the actions to remove the blight, and that is one of the factors, and in that case, the court would permit the owner to remedy the violations. So there's an extensive process, and it's not just a matter of one neighbor wanting to do something on somebody else's property and being able to make it happen.
Thank you for the answer and those specifics. I think one of the things I've heard Rep. Dubitsky say in the past is the concern about our farms. You know, a farm, of course, is a little bit different than, for example, a suburban neighborhood or a city block. And, you know, how do you see those issues being different? Because I think 83% of communities being excluded is a pretty big number. And I know we've heard from communities who do want to be able to take advantage of this. So can you talk specifically about the concerns about the farm?
Sure. Yeah. I mean, I think that, as you said earlier, that this receivership statute makes sense to apply to towns of any size, large or small. And we often do think about blight being in the big cities, but there are definitely a lot of smaller communities that would be interested in this. We have a number of them that participate in our Vibrant Communities Coalition. I mentioned, you know, Windsor Locks and Derby, for example, that are much smaller than 35,000. And last year, one of the towns that testified was the first selectman from Harwinton testified in support of this bill. That's a community with 5,200 people and some farms in that community. I understood, you know, I've heard through the grapevine. I haven't spoken with Representative Dubitsky directly, and I'm trying to line up some folks from our coalition from his district to speak with him directly about this. But it's not just like, again, like the condition of a farm and somebody doesn't like the look of it. It actually has to be designated by the municipality as blighted. And then it has to meet all these different provisions under the statute in order for the court to find that a receiver can in fact take over the property. So, and the property owner still has the ability to remedy the blight before that happens. So there's lots of protections, whether it's a farm or a vacant building in a city, to protect the owner from a neighboring property owner who, some nefarious action cannot happen. The court's going to be involved with this to prevent willy-nilly kind of events.
I thank you for that. And I think that's really important because that's not the intent. The intent of this bill was to allow for communities of all different kinds to have different tools in their toolbox in terms of economic development, but also in terms of public health and safety and, helping the community. But I do appreciate you answering those. And if you are able, if there's any other specific information that you're able to provide to either myself or any other representatives specific to some of those smaller communities and the farmlands, if there are communities that can provide us some data and concerns, I'd be interested to hear that.
Yeah, so I will say, and I know we talked about this a while ago after the last session, Representative McCarthy-Vahey, and this hearing today snuck up on me, so I haven't had a chance to do it, but I did reach out to a couple of members in southeastern Connecticut today from our coalition, and one of them followed up with me already and said that she was reaching out to people in Representative Bitsky's, the communities that he represents. So hopefully we'll be able to have a conversation with him soon, including people from his district, and address those concerns directly.
Yes, and just to be clear, I don't think it's just the good representative. I think it's just having an understanding of the issue that he has raised, which I think that's really what I'm getting at. So.
Sure. No, I definitely appreciate that. And hopefully, I know there's testimony from several others that we reached out to from today, from the Council of Small Towns, from the Connecticut Conference of Municipalities, the Partnership for Strong Communities, the Connecticut Main Street Center, all have submitted testimony today as well, indicating how they think this statute is useful and how it's useful even in cities or towns smaller than 35,000 people.
Thank you, Mr. Horan, and thank you, Mr. Chair.
Thank you for your questions. Senator Champagne, welcome.
Thank you, Senator Casano. Jim, question for you. Is there a recourse if somebody takes my property and goes to the court, gets this order and does something to my property? Do I have recourse against that person? Can I sue them? Can I be arrested if they went to the court?
Right. So before the current property owner is engaged in the process right now, so that if the current property owner wants to remedy the conditions on the property, they will have an opportunity to do so as part of the current court process. It's not taken from them before there's an opportunity to do so.
Okay. Well, I'm a small farmer. If you look at my property, I got hurt, was in the hospital. I'm in rehab, been gone for a while. My stuff is still in my house. My grass is 3 feet long, so I got cited for a nuisance property. I have farm equipment on the farm, and the neighbor who just moved in from the city decides that, I'm going to use this law. I'm going to take and do something about this farm. I clear out all his equipment that was out there. I cut his grass. I paint his house a color that the farmer didn't like. The farmer gets out of rehab. Didn't realize anybody's trying to contact him, and what kind of recourse does he have?
Yeah, well, for one thing, the property has to have not been occupied for 12 months as part of one of the conditions of the
He's been hospitalized and in rehab for 12 months.
Yeah, okay, so I guess it's conceivable that something like that would happen, but I believe that there are provisions in the current statute that would allow the property owner still. To be honest, I don't know exactly how it would work at that point, and I can try to figure this out and get back to you, speak to an attorney about this. But my understanding is that the owner would have an opportunity to regain the property, but I need to confirm that, and I'm not certain that that's the case, Senator.
What do you mean? What do you mean by regain the property? Does this person fix the property up and he keeps it?
So, well, they can sell the property at that point, but I will say at that point, the proceeds go to the owner of the property after other costs, including court costs and the cost for the rehab, are addressed.
You know, I guess I do have a problem with the law. I guess I think an individual community should have the right to opt into this program, number one. And number two, you know, I don't think anything should be done with somebody's property unless you can contact them and verify that they're okay. Because if, you know, even if you live out of state for 6 months and for some reason you got sick down there, you haven't been back because you spent your other 6 months sick and you just couldn't make the trip back to Connecticut, that's 18 months that you could be away or longer. And then you come back and find out some guy sold your property. I think I'd have a little problem there.
Well, so Senator, I'm not certain that is in fact the way it works, but I would need to check with an attorney to understand exactly with the scenario that you outlined. I do know that current property owners are engaged by the court before an action takes place, but whether the kind of scenario with somebody in a hospital or a rehab for an extended period of time wouldn't be contacted, I don't know. So I'll need to check into that further and get back to you. But it may be that that would not happen. I need to look into that further.
Okay. Well, I think all of us as legislators got a note from a letter basically about somebody's house being taken from them down in Greenwich. I believe, yeah, I think most of us legislators got that letter, and it was pretty interesting that somebody took a house and sold it on this person, and the person didn't know about it. And you know, when I think of that, and I think of what this you know, the receivership, and I'm thinking about farms, I'm thinking about small towns. I'm just kind of worried that, you know, even one person having their house taken away from them without permission kind of concerns me. When I look at some buildings and the building's been empty for 20 years, nobody's ever done anything with it, I can understand that. But just because somebody gets cited because their grass is 3 feet long and that starts the process, and you just can't find the owner, so you take it over, and even though all the furnishings and everything are still inside the house, that's my concern on this. And I see Doug Dubinsky's coming on. He can talk a little more about the farms and stuff, but I do have a concern about that. Thank you.
Thank you, Senator. And Doug Dubinsky has raised his hand. Doug, you there? Welcome back.
I am here. Thank you. I'm actually in 3 separate public hearings at the moment, so I'm trying to pay attention where I can. And I thank you for coming in to discuss this, and kind of expounding on Senator Champagne's comments. This is currently the law in large municipalities. What's the argument for applying this against a town with 800 people in it?
Sure. So, I mean, I do believe that there are blighted properties, you know, in towns of any size. And certainly I know last year there was testimony from several communities smaller than, or written testimony from several towns smaller than 35,000, New London, Newington, Harwinton, Canton, and I think a 5th town. So there can be blighted properties, you know, obviously in the larger cities, but in smaller communities as well.
Okay, but every one of those towns that you mentioned is maybe smaller than 35,000 people, but not by much.
Oh, well, Harwinton, sorry, excuse me.
Harwinton's, how many people in Harwinton?
It's 5,200.
Okay, well, so you got one town were there any property owners that said they wanted it, or just the town administration wants it?
Right, that was from the first selectman of Harwinton.
Right, so the issue is, and you know, I've said this before, you know, I don't represent towns, I represent people, and people own properties. so I'm not as concerned about what the town wants. I'm concerned about what's best for the people of the town, because they're the people who put me here to protect them. And I just, there's a very big difference both in substance and in quantity with regard to properties in small towns and properties in big cities. And I don't see that significant difference being represented anywhere, other than the fact that the current law says it has to be a town of 35,000 or more. When you get to smaller towns, a town of, I represent a town of 1,700 people. A property that's blighted.
Are you in the Judicial Caucus?
I'm sorry?
I think this is background from another legislator.
Oh, sorry. A town of, with only, with a lot of farms, with a lot of small, with very few people and large properties. One man's blight is another man's stuff. Who's to say? These towns don't have blight ordinances. The only one that's going to be able to tell is the neighbor. So how do you justify that? I'm just not getting it.
Well, in that case, Representative, you do have to go through a court process, and the statute has a lot of provisions about what is necessary for the court to find in order to determine that there's blight and to appoint a receiver. So they have to have, the property has to have not been occupied for 12 months. The owner hasn't marketed it. It has to be they have to find at least 3 conditions, including that it's a public nuisance and blighted, that it requires substantial rehab and no effort's been made to do so, that it increases a fire risk or a hazard to children. So there's a lot of provisions in the statute that would prevent a neighbor from trying to be appointed a receiver for a property just because they didn't like the condition of it, as opposed to having to meet these statutory requirements.
Well, in a lot of the small towns these days, you get rich people moving in from New York. They buy an adjoining property. Let's say they buy a 50-acre property adjoining your 50-acre farm, and they've got tons of money, and they want everything to look like it did in Westchester County where they came from. But your property doesn't look like that. But you've got lots of money. I mean, they've got lots of money, and they go to court, and you got to have to hire an attorney. You're going to have to hire experts. You're going to have to hire all these people. And, a lot of these farmers, frankly, they're land rich and cash poor. They can't afford all that.
I hear what you're saying. I just think that in such a case as you've outlined, that a person themselves, a property owner themselves, a farmer or other person could say, my property is not blighted. It's a working farm, and this is how it looks, but it's not a nuisance to children. It's not a fire hazard. It's been occupied. I mean, it would be clear on its face that you're not in violation. You don't have the kind of vacant, abandoned, and deteriorated property that would be subject to receivership.
Well, I don't know if you've ever been in court before, but I'm a trial attorney, and I regularly go to court, and nothing is clear. When you're a guy who gets dirt under his fingernails for a living, you go stand in front of a judge, and at the other table next to you is a legal team from the top law firms in the state. Nothing you say is going to be heard in the same way that what they say. It's not clear just to say, well, my property's not blighted. And they come out with a piece of paper with some expert that says, yes, Your Honor, under statute XYZ, this is considered blighted. Well, how are you gonna fight that? without an expert?
Yeah, so I mean, we tried to build these protections into the statute with all of the different provisions that indicate the many conditions that a receiver would have to demonstrate to the court. And so I hear you about the little guy, the individual against a team of attorneys. But I think that it wouldn't even get that far because it's just on its face, not the case that that a farm property is blighted just by nature of being a farm, or even a poorly kept farm with tall grass. It still is not at all subject to doesn't meet the conditions outlined in the statute, that it has to have not been occupied for 12 months and other factors.
Well, I appreciate your effort to build in these protections, but it just sounds like the people who would be the subject of this bill have not been consulted in developing the criteria for it. You know, did you talk to people, individuals who lived in small towns, and say, what do you think? How could we better protect you?
No, we did not. We based this on statutes in other states that have been effective, in Pennsylvania and Massachusetts in particular, where these have been in effect for many years. And I'm not aware of it being used in those kinds of situations, you know, pitting a neighbor against another, as opposed to dealing with truly blighted properties.
Yeah, well, I guess the term effective depends on whose ox is being gored. You know, a statute is effective when it suits your purposes, not necessarily when it suits the purposes of the person who it's being used against. But I thank you for coming in, and I thank you, Mr. Chairman, for letting me ask questions.
Thank you.
Thank you. Representative Drabinski, thank you. Appreciate your comments, and I know that Mr. Haran does too. So, are there any other comments of any other members of the committee? All right, seeing none. Jim, thank you very much for your testimony.
Thanks, Senator. Thank you all. Take care.
Let's see. David, I saw David here, David Kluski.
Yes.
Kazuski.
Yep, I'm here.
And then Colleen's right behind. David, welcome.
Thank you. Good afternoon, Chairman Casano, Chairwoman McCarthy Vahey, and other distinguished members of the Planning and Development Committee. My name is David Kolzuski. I am co-chair of the Legislative Committee for the Connecticut Tax Collectors Association, as well as tax collector for the town of Fairfield. I'm here representing the Tax Collectors Association in opposition to SB 128, an act concerning foreclosure, assignment, and other enforcement actions for unpaid sewer assessments and other fees and charges. A lot of what I'm going to discuss is basically what Mr. Nelson Malwitz has already talked about, but I'm going to give a little different perspective in that I'm, one of several tax collectors across the state that collects the sewer use on behalf of WPCAs. So our two biggest concerns are the fact that this threshold of $10,000, we find it unfair, not equitable. Our feeling is that the threshold should be based on amount of years. So for example, 3 or 4 years delinquent, then it's not based on how high your sewer tax bill is or your assessment is. It's based on the amount of years you've chosen not to pay the bill. So it kind of lumps everyone into one bracket. It does not differentiate anyone. The other concern that also Mr. Malwitz talked about was the fact that statutorily we can only collect these balances for a period of 15 years. There was 20 or so tax collectors that also did written testimony in opposition, and they all said the same thing. An average sewer use bill is approximately $500 a year. It's going to take well over 20 years to recover these debts. So it makes the sewer use bill purely optional now for individuals, because we can never enforce collection on it. Our hands are tied. We have no means to do this. But I want to emphasize that as an association, we're in support of the intent of this bill. We just believe that it should be revised to say amount of years delinquent, not a dollar amount threshold. Because as tax collectors, we use guardrails. We do things such as delinquent notices, intent to lien notices, demand notices. We send out series and series of notices before we would ever even consider doing a lien assignment or foreclosure. And many you ask your tax collector in your town, they're going to tell you more likely than not that if they were ever to do a foreclosure or a lien assignment, they're going to give 3 or 4 years. They're going to give time for this taxpayer to pay off the debt before they even consider such an action. And so that's why I feel that a time period versus a dollar amount should be considered for this bill. So again, I appreciate the intent of the bill, but I just respectfully request that an amendment is done to change it from amount of years rather than a dollar amount. Thank you.
Okay. Representative McCarthy Vahey.
Thank you very much, Mr. Chair and Mr. Kluszewski. I just wanted to say thank you
You're
for
welcome.
being here today. I just have to, for the sake of Representative Curry, just point out that 2 of our presenters today have been co-chairs of our statewide organizations, and I appreciate your service both to our town and to the state. And as I said earlier to the earlier speaker, that excuse me, Mr. Mowitz, that I look forward to ongoing conversations with you and others about this bill. Thank you, Mr. Chair.
Thank you, Madam Chair. Senator Wong.
Thank you, and David, welcome. It's always a big compliment when the tax collector gets the warm welcome from the community. So thank you for your very, very good work. And it is an issue that is due for great consideration. You did not comment on the nonprofit residences, or if you did, I apologize, I might have missed it. Can you give some of your experience and expertise, in your thoughts related to that? I know that I have not heard your perspective on the taxation of our nonprofit entities and group homes.
I wasn't following that one closely because, to be honest with you, that's more of a tax assessor related issue. So I really can't speak to that one directly. I was listening in and I did notice it's more of an assessor related issue.
Okay.
So I do apologize.
Nope, not at all. Not at all. Thank you, Mr. Chair. And again, David, welcome. And thank you for your great work in the community.
Thank you.
And your staff as well.
Thank you. I appreciate that.
Are there any other questions? Seeing none, David, thank you very much for your testimony. Appreciate it.
Thank
you. I got a hunch we'll be talking to each other again soon as we try to look at this. All right, next I have Colleen Bale and then Elizabeth Lane and Jeff LeMay. We have now reached the mark where we are 1/3 through the hearing.
Well, thank you, everybody. Last name's Bailey. My ancestors spelled it a little funny. So thank you for the opportunity today to speak on behalf of Senate Bill number 131 on ebook licensing. My name is Colleen Bailey, and I'm the current president of the Connecticut Library Association and the library director of the West Haven Library. West Haven is a diverse community with 55,000 residents. Our library's budget, like many others, has been reduced dramatically in recent years and is less than 1% of the city's total budget. Our material budget is already too small for a library of our size. Ebook pricing is so high that one copy of the latest bestseller, I'm going to use The Midnight Library as an example, in digital format costs $55 and expires after 2 years. Whereas the physical copy costs $12 with our CLC discount. Most libraries also have a hold ratio that determines how many copies of books they may purchase, which is just not possible to maintain with digital content. My library currently has 8 copies of this book, costing us approximately $96, that have been checked out 39 times, with a number of people also on the hold for the book. By contrast, the digital copy costs my library $55 for one copy that expires after 24 months. We are lucky to belong to a consortium where we can purchase ebooks for 29 libraries to share. Patrons end up frustrated when they may be on hold list for upwards of 6 months, depending on the number of people waiting on the list for that book. And patrons will wait that long. Not everyone has the means to purchase materials. If the pricing model for libraries was the same as it is for the general public, we would be able to purchase multiple copies to meet the needs of our patrons. During the pandemic, West Haven saw an increased interest in our digital materials with an increase of 27% of digital checkouts that has been a continued trend. With lending models such as Hoopla, we have to limit patrons to no more than 6 checkouts per month to ensure that we do not overspend. Our Hoopla checkouts last year accounted for 15% of our total digital material checkouts. Having different pricing models makes budgeting for materials year to year tricky at best. Libraries provide a window into reading. For many, library books are their only means of getting reading material. In this digital age, we should not be hindering the ability for anyone to have access to information. And current ebook pricing is a hindrance to equitable access to all. Not everyone has the ability to go online and purchase books, exacerbating the large digital divide already in our state. Publishers are not recognizing that librarians are the people that recommend those books they're trying to promote to their consumers, and librarians end up being de facto salespeople for them with every book they recommend to a patron. Thank you for your time today.
Thank you for your testimony. Questions? I'm just wondering, is there another alternative besides buying the ebooks directly from the ebook producers or whatever it might be?
At this time, no. The only way we can get those materials is by going through those publishers. So we're kind of at the whims of what the publishers decide for those models of what we're going to pay, and it makes I mean, for a couple of years ago, our consortium decided to not purchase from certain publishers, and that left a lot of our patrons very upset because those popular titles they couldn't get through their libraries. So we had to kind of rethink how we were doing those pricing. So now we're just stuck with purchasing those at those high costs.
So we need to find an end around alternative, like a large box store or something, to buy these, because they probably have direct access to these places or something. It just, you know, on the one hand, we're struggling to keep libraries alive. Any community that's going through the process of renovating the library that's 100 years old or 50 years old, and I've had this right here in Manchester, you know, we still get a lot of people saying, well, you don't need libraries anymore, everything's online. That's not the case. And what we see every year is increasing use of the library, not decreasing. And to have something like this, it's like a dark cloud over it that just prevents us from moving forward the way we should be. And so we need to find a different way. I don't know if there's something at the federal level, maybe a discussion on our part with our federal partners, but it just seems that each year it's getting worse and it's getting worse. And as we can see just by this agenda today, there are probably 10 or 12 libraries coming in to testify because they're getting killed. And it's not them getting killed, it's their constituents that are getting killed. And so this discussion is not going to end after this meeting ends, I can assure you. Thank you.
Thank you very much.
Any other comments from any other committee members? Seeing none, thank you for your testimony.
Thank you.
Okay, that was Elizabeth, I think, was next.
Yes.
Yeah, Elizabeth Lane, and then Jeff LeMay after that, and Tim Hollister.
Thank you, Senator. Good afternoon, honorable members of the Planning and Development Committee. I'm thankful for your time and attention to these important matters that affect access to information of all kinds to every resident in our state. My name is Elizabeth Lane, and I live in Bloomfield, Connecticut. I have the privilege of serving the wonderful community of Bloomfield as the director of Bloomfield Public Library. I am also a mom of young readers. I am writing today in support of SB 131, an act concerning electronic book licensing. I'm in the very important business of connecting people to information. It may sound easy, but I can assure you that it is not. Accessing information in an equitable way is a social justice issue. Libraries are struggling to break down the many barriers to access, but we do not have the staffing or monetary resources to battle the power of corporate entities who keep rewriting the rules. We need the government to step in. When similar legislation was passed in Maryland last year, I excitedly wrote Senator Slapp and Representative Gibson asking them to follow suit in Connecticut. In truth, we should have asked for this more than a decade ago. Reasonable terms. We are asking you to help level the playing field for libraries of all kinds, public, school, and academic, by creating a bill that allows us to better connect people to information without all of the added barriers the publishing industry is putting up. I want to share the 5 key points that the American Library Association once addressed about ebooks. 1, all published works must be available for libraries to purchase and lend to library users. 2, access to and use of ebooks must equitably balance the rights and privileges of readers, authors, and publishers. 3, digital content must be accessible to all people, regardless of physical or reading disabilities. 4, library patrons must be able to access digital content on the device of their choosing. And 5, reading records must remain private in the digital age. Stick up for school libraries, stick up for public libraries. Thank you, and please remember that just like you, libraries work to serve all. We must have ebooks for all. Thank you.
Thank you for your testimony. Are there questions? Senator Wong.
Thank you, Mr. Chair. And Ms. Lane, what a wonderful job. Thank you very, very much. And I love the collage behind you as well. You mentioned something that really hit home with me, and you talk about social equity. You talk about access. Talk a little bit more about how this digital cost restriction really impacts the access. We talked with Mr. Bullis earlier about New Haven and how they had a EGO program that was based on a usage, and that they used up nearly $50,000 in 3 months. So obviously there's a great need for access to reading and knowledge, but this is a social equity concern, isn't it?
Absolutely. Access to information is powerful, and we know this for all of our residents. And I know the question of public schools came up, and we know not all of our public schools in the state of Connecticut have librarians who are able to navigate all of these changing rules around these services. And you know, the equity issue, you have a kid come in and they're so excited to get a book on their device, and then we tell them, oh, there's a 7-month waiting list. I mean, that is not how you create a lifelong learner and library user. So we are coming to you to ask us to help make this easier so that we can make sure we have information and resources for all of our residents.
Thank you so much. There's so much more to ask of this in regards to your budgetary constraints and the challenge that you have and the programs that you would love to be able to undertake in outreach and interaction during the COVID time. So, but I'll leave it at that, and thank you. Have you submitted written testimony?
I will be, yes.
Okay, I would like to ask if you could include those 5 American Library cornerstones, because those are powerful statements from a standpoint of, look, make no mistake about it. You as a librarian, you understand it is important to protect and respect copyrights and access to it. But I think the question that's being reiterated earlier is, cost $15 for the same book, while at the same time on a digital cost, it's $55. The model is skewed. So
yes.
Again, thank you very, very much for what you do, and my best, and I appreciate the social equity perspective. It's very important.
Thank you, Senator.
Thank you, Senator. Representative McCarthy-Vahey.
Thank you very much, Mr. Chair. Ms. Lane, thank you very much for being here. I concur, would love to have those 5 principles, and that's my question relates to the American Library Association. We know that Maryland has passed a law. We know it's run into some legal trouble. I'm wondering what the Library Association on a national level and what other states have been able to do or have been talking about with respect to this that might help shed light on what we're doing here.
I know that there are other states working to do the same thing that we are doing, and I am proud of the work Maryland did. I think that Connecticut can also be a leader on this in moving this conversation forward. I also know that ALA wrote a letter in support to New York State when they were trying to do this. So I can share that letter with you all as well in my written testimony. And I do believe that some of my colleagues may be able to speak to that point more expertly than I as well.
Well, I want to thank you for that answer. And I also just want to thank you for saying that you are the mom of young leaders. And you know what? I think about Abraham Lincoln when you say that and how important that is as a mother and as a parent to be modeling that for your children and for your service to the community. So thank you. Thank you, Mr. Chair.
Thank you, Madam Chair. Anyone else like to speak? Seeing none, I thank you for your testimony, and we will probably be doing some follow-up. I can see collectively with the libraries, and hopefully we can turn things around. Appreciate your testimony.
Thank you.
Jeff LeMay, then Tim Hollister and Bruce Donald on deck.
Hi, good afternoon. Thank you very much. I just want to say, first of all, I'm honored to be here, and I really appreciate the opportunity to speak. I'm a little nervous. I consider myself a decent speaker, but it's my first time doing something like this, so please bear with me.
No problem. Relax.
So my name is Jeff LeMay, and I'm here on behalf of the Connecticut Water Pollution Abatement Association. That's an organization that I'm currently the president of. And I'm also here to talk about proposed Senate Bill number 128, an act concerning foreclosure, assignment, and other enforcement actions for unpaid sewer assessments and other fees and charges. And I want to thank Mr. Malwitz and Mr. I think name's Kluszewski, who already spoke on it. I'll try not to rehash the things that they've already said. The point has been brought up that essentially the way that this bill is laid out, people who pay sewer user fees would essentially never have to pay those fees. Obviously, I'm sure everybody can see why that would be a problem. I'm also the supervisor of a wastewater treatment plant. So I'm aware of the challenges that we have with all the billions and billions of dollars of infrastructure in treatment plants and pump stations, and not to mention the sewers themselves. And it would just be really challenging to be able to continue to make the improvements that we do and to update our aging infrastructure if something like this were to go through. It's also never our intention to foreclose on somebody. Eventually, you know, that action, you start the process to try to get that revenue in, but nobody wants to foreclose on anybody. And it's usually, you know, in line, I think it was Senator Champagne that mentioned the idea first of having some sort of time limit on it rather than the $10,000 limit and having it be a dollar amount. Have it be like a 4-year limit, something like that. I think that makes a lot more sense. I actually had a member of another water pollution control authority contact me just before getting on. And so at the state average for sewer user fees, it'd be about 19 years to reach that threshold. But the point that he brought up is that, you know, a lot of places are not charging flat rates on sewer user fees. They're actually usage-based. And if you're usage-based, it could be considerably longer than that. It could be 30, 35, 40 years before you reach that $10,000 threshold. So again, nobody wants to foreclose on anybody, but we do want to be able to continue to collect enough revenue for us to be able to do our jobs, which is really, we're out here to protect the environment and to protect our communities and our residents. And that's about all I have. I hope I covered everything, and thank you all very much for your time.
Thank you, Jeff. Are there any questions? Senator Wong.
Not a question, just a comment. You did a great job, Jeff, and you better be careful. They may extend your term as a president for infinitum. So thank you very much. That was all. You did a great job.
Thank you so much, Senator. I appreciate that. Thank you.
Thank you. Seeing no others, Jeff, thanks for your testimony. Appreciate it.
Thanks so much. Take care, everybody.
Yep, you too now. Tim Hollister, then Bruce Donald.
Good afternoon, and thank you. I am a land use and municipal law attorney at Hinckley, Allen, and Snyder in Hartford. As an author of 3 books, I am fascinated by this library discussion, but I'm going to stay in my lane and talk about 2 other bills. The first is 5168 concerning property tax exemption. I represented Rainbow Housing, part of Oak Hill, in their appeal of Cromwell's 2018, unexplained revocation of a longstanding tax exemption for a group home, which in the September 21, the Supreme Court reversed that revocation and ordered the exemption restored. In doing so, the court issued two clarifications that this bill would codify. The first is the court said that a group home does not lose its tax exempt status simply because it provides shelter to someone receiving mental health treatment for an unknown period of time. This bill codifies this by removing the confusing word, the court said it was confusing, the word temporary from the explanation of what type of housing is tax exempt. The Supreme Court also left intact a lower court ruling that money granted to a group home by a government agency for treatment does not make the group home taxable as government subsidized housing, as would occur if, for example, if there were Section 8 vouchers. So the bill codifies that clarification. The bill also creates three necessary procedural revisions: a standardized state form, a requirement that assessors give reasons for a denial or a revocation, and in egregious cases, and there are some, not a lot, but some, a judge has discretion to award attorney's fees. So this bill is a good substantive clarification and procedural revision and should be passed. SB 130, Regulation of Community Residences. With all due respect to earlier speakers, I would say that it is an unwarranted effort to limit group homes and mental health and substance abuse treatment. I represent Newport Academy in Fairfield in its defense of two lawsuits brought in state court by neighbors of group homes proposed by Newport, challenging the permits that were issued by the town to open those group homes, specifically building permits. This bill should be rejected because, number one, its proponents have not explained any problem in current state law that this bill would correct. General Statutes 8.3E protects homes from discriminatory zoning regulation. This bill reduces that protection. Group homes, as part of treatment, sometimes need a medical license. This bill would strip away the group home's statutory zoning protection simply because they have obtained a medical license. And frankly, that just makes no sense from either a zoning perspective or a medical license perspective. And I would say that if there's an issue with a medical license, that belongs in front of the Office of Health Strategies and the Certificate of Need process. It should not be in the zoning statutes. Thank you, Mr. Chairman. That's what I have today as to my testimony.
Thank you for your testimony. Are there questions of any members of the committee? Representative McCarthy-Vahey.
Thank you, Mr. Chair. I will recognize that you've called on me quite often during this hearing, so I appreciate that. Attorney Hollister, thank you for being here with us today. I actually wanted to ask you a question first on the 5168. The Supreme Court ruling, I'm not sure that folks are as familiar with it. And I know you talked about the bill and what the bill would seek to clarify with respect to that. But could you just give, a 90-second or so summary of what that ruling was, if there was anything that's outside of what you shared earlier?
Okay, well, it was a group home in Cromwell that had had an exemption for at least a decade before the revocation. There was no explanation that really substantively as to the reasons for the revocation. Once we get into the litigation, all of the issues that this bill addresses began to bubble up to the top from the town's lawyers as ambiguities or bases on which a revocation might be granted, such as temporary housing and the meaning of government subsidized housing. The Supreme Court did not address specifically what government subsidized housing is, but they did say that if there is a treatment program of indeterminate length, that does not make the housing in which the treatment is provided permanent housing, which would make it taxable. So that's kind of the guts of the ruling.
Thank you for that. And I appreciate you sharing your perspective also in Senate Bill 130. I think one of the things that has been tricky, and I don't I'm not familiar with all the intricacies of ruling locally. But I know that there's been some conversation with respect to the interplay between local role, state law, and federal law. And I don't know that you didn't really speak too much to that. You were speaking to the state law portion, but I don't know if you wanted to comment on the interplay between any potential changes that we might be contemplating through the course of this bill. And, is that something that would be problematic? My understanding is that given the language that we looked at, that it would not be, but I'd like to hear your perspective.
Well, the explanation was made earlier in this hearing that there was a misrepresentation that created a precedent that opened the door for what Newport Academy is doing. The public record is very clear that the town of Fairfield issued building permits and certificates of occupancy because it was required to do so by the Federal Fair Housing Act. This was not a misinterpretation of the building code or the zoning statutes. This was because of superior federal law, as driven home by the fact that the town of Fairfield and Newport Academy in federal court settled the discrimination claim just 2 weeks ago. And that resulted in the issuance of certificates of occupancy. So there's no, and there is a medical license component to the story, but the fact that a group home might need a medical license, perhaps to dispense medication, doesn't affect anything, certainly with regard to federal law, and it doesn't even affect anything with regard to state law regarding zoning. That's a medical license issue for the Office of Health Strategies. So, obviously the legal tiers are federal, state, and local, and the local gives way to the state and the state gives way to the federal, and that has played out here. So the idea that there was a mistake or something at the local level, no, this was driven ultimately by federal law. And later speakers today will make the point that if this bill is passed, more people will have to turn to federal law suing towns in order to recover the protections that this bill strips away. And I think that would be an unfortunate result.
I guess, let me rephrase my question to be perhaps a little more clear and direct. No, I thank you for your answer, but the question that I have very specifically is, in your opinion, based on your experiences and expertise, would this bill in any way run afoul of federal law?
Oh, yes, it would. And it would also run afoul of state corporate law, which is not a point I got to. But yes, this would essentially embolden more towns to take actions that could implicate Federal Fair Housing Act protections. Yes.
Okay, well, I thank you for your answer. I will just recognize that this is a really complex situation, and it seems a very complex area of the law, and with the interplay, again, as I had said, between local, state, and federal. I thank you, and perhaps look forward to more conversation in the future.
Thank you.
Thank you, Mr. Chair.
Thank you for your testimony. Senator Wong, I
Thank
expected you would be
Thank you,
here.
Mr. Chair.
Welcome.
Welcome, Mr. Hollister. It's always good to see you. And thank you for the initial input in regards to the first question of our nonprofits. And it's important, the distinction between homes. But just a simple question. In your representation of Newport Academy, is Newport Academy a group home?
What they're proposing in Fairfield is 2 group homes, yes.
So you're saying that they are a group home as the attorney representing them. That's important because from what I understand from the legal proceedings, it is the challenge that they say they're not a group home. So I'm a bit confused, but I'm glad to be able to get the attorney representing them stating that they are a group home, because the challenge I have in the federal litigation, you're right, I don't know enough about that. I'm focused on this statute, and the statute is not just specifically addressing Newport Academy. It's addressing the protection of group homes for a protected class to be sure that entities do not represent that they are a group home when they are not, and that at the same time taking away from the real need of protected communities. So it is no way looking at mental health. We all agree it's critically important, particularly in this age of mental health issues, but it is important. we're going to protect group homes and the principle that is undertaken by the federal legislation and McKinney versus Fairfield in the state statute. And that's the difference. We're looking for a clarifying definition. It's not looking at any entity, not looking at any perspective, but the difference between group homes and people that represent themselves as group homes in order to get the exemption from local residential zoning codes. So I thank you for your time, and I'm sure we'll be talking some more. Thank you, Mr. Chair.
Thank you, Senator Wong. And are there any further questions or comments from members of the committee? Seeing none, thank you, Mr. Hollister.
Thank you.
Next on our list, we have Bruce Donald, to be followed by Jeff Genties. And Jeff, forgive me if I'm saying your name wrong. Is Bruce here? Yes, Bruce.
Yes.
Proceed, and I'll turn it back to Senator Cassano.
Thank you.
All right. I want to thank the committee and its leadership for having me. My name is Bruce Donald. I am the Southern New England Coordinator for the East Coast Greenway Alliance. I am also the chairman of the Connecticut Greenways Council, and I sit on 10 other boards across the state in this space. I'd like to start out talking about SB 129, which I don't think anyone's talked about yet. So an act establishing a tax abatement for certain conservation easements. The East Coast Greenway Alliance strongly supports it. And I'd like to give a little background here, just briefly. Currently, 35% of the East Coast Greenway is built. It extends 3,000 miles from Maine to Florida, and over 100 miles of Connecticut's 200 miles are built as we speak. And I want to thank the committee for raising SB 129 because it would provide meaningful leverage to communities who want to build a variety of types of greenways and trails in the state. Recreational trails are critical to Connecticut's outdoor recreation economy, which generated $3.3 billion in revenues in 2020. Trail usage in Connecticut is huge and growing. The Connecticut Trail Census reports that overall trail use increased by 38.3% in 2020 compared to 2019. In the industry, we call that the COVID effect, right? And that's essentially what has happened. There's an enormous amount of new people using these trails. We are now in a period where the easily accessed right-of-way corridors, such as abandoned railway lines, for instance, you all recall rails with trails, right? Which obviously still exists. They've been substantially built out. They've been used. And we're now looking at solutions that include a patchwork of private, municipal, and state-owned lands. In that mix are private landowner hosts who are critical to keeping trail corridors unbroken. But these lands are often vulnerable to development and subdivision. The introduction of allowing and enabling abatement of property taxes under this raised bill would have a very positive effect on keeping certain connective trail corridors in the public domain and available for this use. An adopting community must enable this legislation through local ordinance and then must meet other criteria as well. So this is not like you can just, willy-nilly do this. There's actually a list of things you have to go through as a community. But the benefits to the community, I think, are important. Placing a conservation easement on a property.
Mr. Donald, your time is almost up.
Thank you. It reduces the value of that property substantially. This bill would allow the municipality to abate the property tax on that trail corridor by the amount of value lost, providing a genuine incentive to a landowner who wants to preserve a trail corridor as improved open space for all. Thank you very much. I appreciate it.
Thank you, Bruce. Are there questions? Any question? Madam Chair. Representative McCarthy Vahey.
Thank you, Mr. Chair. Yes, it's me again. Mr. Donald, thank you very much for being here. You said something that was of interest to me, that the conservation easement lowers the value of someone's property. Do you have any data to support that?
So you will be hearing from Claire and Eric from Connecticut Forest and Parks after me, and they will be able to give you reference data on that. But that averages enormously from a little amount to 2/3 of the value of the property, depending on where it is, what's being used, the percentage. So I can't give you a firm number on that, but I know that Eric Hammerling can, for instance.
Thank you very much, Mr. Donald, for pointing me to Eric, and I will ask him when he comes back, or comes on. Thank you very much, Mr. Chair.
Is there any other questions? Seeing none. Thank you for your testimony. I'm sure when you get to your car, you'll get a call from Bill O'Neill.
Oh, guaranteed. Yep.
So long. Jeff Gentis. And then Scott Jarosvic and Megan McCloak.
All right, thank you. Senator Casano, Representative McCarthy-Vahey, Senator Huang, Representative Zullo, and members of the committee. Thank you for the opportunity to testify today. My name is Jeff Gentis. I'm with Connecticut Fair Housing. I manage our fair lending foreclosure prevention work. And I'm with the Housing Clinic at Yale Law School. I'm here to testify in support of Senate Bill 128. I have written testimony, and I know there's been quite a bit of discussion already. Our support for this bill comes from two standpoints. One, it's mere use of using foreclosure as a means of collecting sewer lien bills is, I think, inherently abusive, and it's just an abuse of government power to be collecting relatively small bills through taking people's homes. And so our concern is for those owner-occupied residential homes, but also all the landlords who have been dealing with whatever issues they've been dealing with not receiving rent or having trouble for the pandemic as well, losing their relatively small investments through sewer liens is not something we'd find acceptable as well. The second is the use of the foreclosure process more than just taking someone's home. Even if it doesn't result in home loss all that much, what it tends to do is double, triple, even quadruple the amount that's owed. We've heard from people who are relatively good actors in this space, but there are plenty who foreclose over less than $1,000. And that money from a foreclosure of the bill going up to $4,000 doesn't go to the sewer lien authorities. It doesn't improve our infrastructure. It goes to the lawyers. It goes to the court system. And it goes to the marshals. None of which helps any of us, besides those who benefit. So for those reasons, we support both the intent and the bill as written, though we're happy to and would love to be involved in discussions and ways to improve the bill so that the members of the committee can be comfortable with a final version. And it passed slightly at the 4 years or 4,000 level from the Senate last year, and we'd love to do what we can to help it pass the House this year. So thank you.
Thank you, Jeff. Any questions for Mr. Gentis? Seeing none, thank you for your testimony. Appreciate it very much.
Thank you very much.
Scott?
Good afternoon, committee members. Good afternoon, committee members. I'm Scott Chazembek, Town Librarian for Fairfield, Connecticut. Thank you for the honor of letting me speak today. This past year marked the reintroduction of in-person library service for many of us. While we continue to provide innovative library services established during the pandemic, like online and hybrid programming, we are now finding that we need to operate in two spaces, virtual and in-person, and they are not mutually exclusive. Our One Book, One Town has 400 registered participants for this Monday. More than 100 of them will be participating virtually, which will require additional staff and technology. Another area of growth, the borrowing of digital resources. Last year, digital material made up 43% of our circulation. Over the course of the pandemic, old and new patrons have become familiar with the digital library collection of books, magazines, media, and other resources. It is important to remember e-material costs 3 to 4 times more than their physical counterparts. It requires staff time to monitor usage and manage user agreements and terms, as well as to assist patrons in accessing this material. And as pointed out before, it is not actually owned by the institution. While the demand for physical books is transitioning among some age groups, digital will never replace tangible books for our youngest in promoting early literacy and learning. We are finding here in Fairfield that parents and children are the ones most excited to return to in-person library experiences. And many educators will agree reducing screen time is important. And as a former children's librarian and father, I believe nothing replaces the experience of a physical book in a child's hands. This is fundamental to successfully introducing the joy of reading to our children and future academic success. And because of this, ebook prices should not limit purchasing of children's books in that format or in physical format. In short, we are now in an interesting and exciting time for libraries. The virtual world has created a new space for us to reach many more in our community. However, it is important to understand digital is not a replacement, but an addition to services expected by the public, therefore providing additional pressure on our budgets to operate in both. SB 131 will assist libraries, public, academic, and associations in operating in this new digital space and landscape, assuring fair pricing for ebooks, making sure that tax dollars allocated for libraries are used responsibly, and we are not forced to limit resources that are expected by the public and that the public relies on.
Thank you for your testimony. Senator Wong.
Thank you. I was actually waiting for the Madam Chair to raise her hand first. That's why I lowered my hand. So thank you, Scott. And I appreciate the important emphasis that digital should never replace the real library experience. And to see the children's library at Fairfield and the joy and interaction as you've gone more in person is one of the great gifts that the library provides. But talk to me about the cost, the increase in digital utilization that you shared, and the cost that would go into providing this kind of services, where other services could be benefited from, where you've had to cut back. You've got a tremendous community outreach program that requires staffing and moderators. You've got a great job search kind of broadband basis. You've got great meeting rooms, but this cost of the digital cost, the disparate model, does that take away from regular library services where you're already constrained and limited budgets?
Well, yes, because we have to meet demand. So as we see the demand increase for digital books and digital resources, we have to look at our budget and move our budget around. And, one thing that this pandemic has done is it's kind of, people have started to embrace technology a little more and need additional services. So we're doing outreach. We have staff that go to our senior center, and they're doing this kind of hands-on interaction with the public, helping them use their devices, including using the apps that they need in order to access library material. So whenever we look at our budget, there is always pressure on where do we cut in order to meet this demand. And again, our virtual programming, which is extremely popular, but it takes staff to do. It takes staff to operate. So as we move more into this digital landscape with books or programming, it's people and it's expertise. It's not, it's really having people who are good at teaching, good at working with individuals, but also have a level of digital literacy that they can do this type of work. So really, it's kind of this robbing from Peter to pay Paul sometimes to make sure that we can do everything. And when you look at the cost of these books and how, just the understanding of, we buy a James Patterson book, we're looking at, we pay that $26 for that book that can circulate multiple times and no one comes and shows up and takes that book away. But when you borrow an ebook, after a certain amount of people borrow it, someone comes and magically takes it away. It magically disappears. This is a real strain on our budget, and it's really something that we grapple with because I don't think the physical book is going away, and we still need to buy those copies as well, especially for picture books, especially for young children who are learning to read and want to experience reading with their family and caregivers.
But the increase in utilization is quite remarkable during this COVID pandemic, and we are focused on children initially, but look at some of our seniors with high risk and comorbidity in this environment. they're not comfortable going in, and they have found that digital library resources are a great avenue for them to be able to continue reading. So it's not just the youth population, the social equity goes to our very senior as well. Would that be correct?
Absolutely. And what libraries saw across the country was an increase in people signing up for library cards who probably never stepped foot in the library before, because it was like, here are all these services, here is Hoopla, here's video, and all of a sudden we have all these new users. And they may never step in the door ever again, but we don't want to lose them. We still serve them. It's part of our charter. It's part of what we do. So again, it's that balance of serving everyone in the community, not just inside of our walls, but outside of our walls as well. And there's pressure there. It's not a replacement for traditional library services. It never will be. And the demand for traditional library services will always be there.
Well, thank you, Mr. Chair. And again, I'll repeat, I'm appreciative of the Madam Chair of this committee and her support of the libraries as well. We're both big fans of the work that you do. Thank you, Mr. Chair.
Thank you. And I'll bring on Madam Chair. Fairfield is well represented in this committee. Thank goodness. They do a good job together.
Oh, well, I just want to say thank you, Mr. Chair. And I was going to refrain, but you know, there's something about the libraries, I just can't help myself. And Scott, thank you so much for being here, for leading our libraries. And I have 3 digital things, one on hold and 2 checked out right now on my device. But I also wanted to just give a plug for One Book, One Town. And if anyone hasn't read The House in the Cerulean Sea by T.J. Klune, I highly recommend it. And I want to thank you for bringing that program to our town. But it's wonderful. Your point is very well taken about the pressure that those rising prices and the unpredictability that was referenced earlier puts on the other programs and the other resources, particularly the physical books. So thanks specifically for that. And thank you, Mr. Chair, for your indulgence.
No problem. Any other comments? Seeing none. Scott, thank you for your testimony. Appreciate it very much. Megan McClout again is next, and then Daniel Osborne, and then Sarah Lemaster.
Hey, good afternoon. My name is Megan McCloat. I'm a resident of the town of Fairfield. I'm very grateful for this opportunity to advocate on behalf of everyone in the state, but specifically people in the town of Fairfield who would benefit from the passing of Senate Bill 130. An unfortunate thing about these things being delayed for so many hours, since most of us have been logged on since 11 a.m., is that we have the ability to listen to some of the other things people have to say and read through some of the testimony that's been submitted, which fortunately for me has completely thrown out my 3-page prepared testimony, because it really does require a very clear breakdown of the issue, because I think this specific bill, as Rep. McCarthy-Vahey said, although it's a very complex issue, I think it's being purposefully conflated and confused by some of the opponents to the bill. And I think we need to clarify that right up front, because it is actually a very simple bill. And that's the first thing I want to say, is that the bill as written and as proposed is a mere clarification of the definition of a community residence. It does nothing to change the impact of what the legislation that's already written is already intended to do. So it's really not as complicated as some people might be made to believe that it is. And I've got to say very frankly that a couple things were said earlier by somebody who testified on behalf of Newport Academy in the specific issue, that there's a lot of interplay between federal, state, and local laws. And although that's true, the reality is the oversight of this issue is a fair housing issue, which is a civil rights claim. So the definition of a community residence does nothing to speak to healthcare facilities, because it was never intended to regulate healthcare facilities. A community residence is a group home, and there is a distinguishing difference between the purpose of a group home where people live and have residential protections that are afforded to them by the federal laws that we are all able to say that we're protected by, and a difference between a healthcare facility that operates with a license that is issued by our governing body in the state that has to require them to go through the Office of Health Strategy in order to obtain a certificate of need. There was a lot of back and forth between Senator Wong and Attorney Hollister about the fact of whether or not Newport Academy in this specific instance is a group home. And that's really important, because group homes don't need a certificate of need. Certificate of needs are required in order to obtain a license to operate a healthcare facility in the state of Connecticut. So the biggest issue of why there's so many complex confusions around this issue is because we're choosing what term we want to use when we want to get zoning compliance. And then we're going to change what term we're going to use when we want to get a healthcare license to operate a medical facility. So we're confused, many of us on this call and many of us in the state, because we're trying to cherry pick what we want in order to get what we want, in order to get somewhere we need to get in order to make a lot of money. And that's what our argument is on behalf of this bill, is that it's unfortunately, it's an abuse of this definition, because it's allowing a loophole that allows corporate profiteers to get in and say that there's something for a purpose of obtaining zoning compliance, just in order to then turn around to another body in our state of Connecticut and say that there's something else in order to operate a healthcare facility. And those two things cannot be regulated by 8.3E the way that it's written, because it's not clearly defined. So by defining the fact that a healthcare facility is different than a residence where somebody lives and requires long-term residential protection in order to be part of the community fabric, it's important that we distinguish that. And frankly, that's the purpose of this clarifying definition in Senate Bill 130. It does nothing to change the impact as it is, because it's not intended to regulate healthcare facilities the way that it's written. So thank you very much.
Thank you for your testimony. Are there any questions? Any members of the committee? Senator Wong.
Thank you, Mr. Chair, and thank you, Megan. You did submit testimony that kind of outlined a little bit more in detail some of the rationale. Would that be correct?
Absolutely. I think, a lot of the written testimony speaks to specific issues, but I did feel that a lot of the things that were already spoken about in terms of this bill really does confuse the issue. And I just can't say it enough that, when you can't properly rebut a defense, you change the issue. That's the number one strategy. And the issue here is the fact that this regulation of the definition of a community residence is intended to define a group home. It is not intended to conflate what a healthcare facility is. That is governed by complete different statutes in our state. And as many people have referenced, it's governed by a complete different body, the Office of Health Strategy, who issues the certificate of needs, or the licensing body, the Department of Public Health, Department of Development Services, and Department of Mental Health and Addiction Services. Those are not zoning issues. What this is intended to do is to protect the local zoning regulations, to make sure that the term community residence is used for the purpose of which it was intended, which was to protect individuals, the most disenfranchised individuals in our communities, who need long-term residential protection for their ability to be able to live in a financially sustainable model among supportive group settings for long-term residential purposes. It's the place that they call home. That is not at all what a mental health residential living center is. That is not what any other entity that's licensed by the Department of Public Health or the Department of Mental Health and Addiction Services. Those do not meet the same needs as a long-term group home. And that's what the purpose of this bill is to really define the difference, because they really don't require the same protections necessarily or the same regulation.
If I may, let's move away from the case of Newport Academy. Let's talk about Discovery Weight Loss as an entity and how they were able to utilize the same application methodology of, quote, an application as a group home and get a local residential exemption to be able to qualify to be able to be in medical treatment, and now no longer designate themselves as a, quote, group home after approved passage of local zoning. Could you elaborate a little bit about how that proceeded? I think that comes to the core of this discussion. It's not just about one entity. It's about the process in which organizations are using the definition or the utilization of the word group home, but not utilizing 8-3E to get unaware local zoning boards and authorities to grant approval without any question. I want to move it away from the case that everybody is inflamed about, that has so much advocacy and so much interest, but just take it on basis. The purpose of this bill is really to clarify and protect group homes that are providing residences and home to protected classes that may be losing out because of entities' practices of using the confusion of that definition. The purpose of this bill is to just clarify, not to attack any entity. Through you.
Absolutely. So for the education for everybody involved, Center for Discovery is a similar entity. They target eating disorder treatment and mental health co-occurring disorders. And many years ago, about 8 years ago, in the same town of Fairfield, so unfortunately we're very familiar with this, they present themselves as a group home when they go to the building official and they ask for a change of use in order to get zoning exemption in a single family residential zone. Because of fear of being violating of fair housing, they were granted, assuming that they were protected under a disability class status, they were granted a zoning exemption. Once they took that zoning compliance certificate, they then turned around to the Office of Health Strategy, submitted it when they were applying for a certificate of need in order to operate a medical treatment facility. Very similar to Newport Academy. One of them is a mental health residential living center. What they do is they then go to the Department of Mental Health and Addiction Services or Department of Public Health, whichever classification they're doing, to get a license to operate that facility. In the town of Fairfield, as Attorney Hollister mentioned, there was a federal lawsuit that relied heavily in its decision to settle the lawsuit on previous precedent that was set in the town by allowing a similar entity like Center for Discovery to get their ability to operate. I think Rep. Laura Devlin said much earlier on our hearing that setting a precedent that already violated 8.3e because they didn't receive DEMIS funding, which is required by the verbiage in 8.3e, and allowing that to be used as a precedent that new litigation can rely upon in order to get the same type of exemption status when it's not necessarily codified in the way that the statute is written, it's poor practice. It's setting towns and municipalities up to fail, because the reality is it shows that we have specifically worded statutes that aren't being followed, and we're not going to do anything about it. And this is the second session that this bill is being brought up, because the reality is that everybody's now on notice that this is happening, but nothing's being done about it because everybody's so afraid of the conflated issue. But the reality is that this is hurting people if we don't do anything to clarify this. There is statutory specific language that caps the percentage of a municipality that can have group home beds for these purposes. So if we're going to allow transit programs that are 45 to 60 day in nature and call those the same residential protections as a group home for people that live for 10, 20, 30 years as members of our community, those people in that latter classification are going to be turned away because we're going to be statutorily capped at 0.1% of any municipality's population and how many group home beds we can provide. And I don't think that those serve the same purpose. I think the state of Connecticut and its entire intention of having a certificate of need and a licensing program that specifically licenses mental health residential living centers doesn't think it serves the same purpose as a community residence long-term group home either, because there's a reason why group homes don't need a certificate of need, because the Office of Health has already determined that they're different than a mental health residential living center. So frankly, it's very confusing how large corporate entities can conflate the terms, use the term at which office they want to get what they need in order to then turn around and go to another regulating body, say there's something else. And it's just not the purpose of what this well-intentioned 8.3e was intended to protect. And if I haven't said it, I want to absolutely clarify. There's been a lot of testimony submitted that this is trying to evade access to mental health treatment or reduce access or reduce quality. That could not be further from the truth. And I want to state that loud, clear for anybody listening. This is not going to minimize access for mental health treatment at all. In fact, one would argue that it's actually going to concentrate services and resources into places where most of the people who need to access that treatment can't afford it. Which is actually going to have a long-term destabilizing effect on the economic stability of our healthcare, delivery of mental health care. But the reality is this is a zoning issue. This has nothing to do with the quality of care or the access to care or the ability for Connecticut state residents to get access to care, evidenced by the fact that the players who are playing these cards are refusing to accept DEMIS funding, which is required by the regulation 8.3e, is that anybody who's not supposed to be prohibited from the zoning exemption has to accept that DEMIS funding. And that's intended to provide people who can't afford high quality, high expensive treatment with access to quality treatment, because it's regulated by the Department of Mental Health and Addiction Services, and it's regulated by the Medicaid regulating body. And so the absolute inability to accept those DEMIS funds, I would argue, really limits access to the people who need it in the state of Connecticut. So this bill is not at all trying to limit that access. We're trying to make sure that the access is maintained for the people that need it most, and that the protections are, protecting the people that need their protection. So in essence, it's frustrating to read some of the testimony that thinks that people are trying to limit access or have stigma against mental health diagnoses, because that is not at all what this is about. This is 83E is a zoning regulation. It is not a healthcare facility regulation. Healthcare facilities are not supposed to be included in the definition of a community residence. We're talking apples and oranges, and conflating the issue to confuse it to be a stigmatized, charged issue is, frankly, it's disingenuous, and it's insulting for some of the people that are just trying to protect the law as it's written. Nobody who is in support of this bill is doing so in order to reduce access or claim that it's not a mental health crisis that we're all living in. One of the testimonies suggested that it's an untimely bill because of the mental health crisis and the opioid epidemic we're in. It couldn't be further from the truth. That's exactly why we need to act now, because there's so many corporate entities that are capitalizing on the fact that we are in a public health crisis with an opioid epidemic. They're capitalizing at the rate of almost $2,000 a day for treatment for out-of-state, out-of-network self-payers. We can't turn a public health crisis and an opioid epidemic into a tremendous profit opportunity by invoking fair housing protections, by calling it a group home when it's convenient to do so. We do that, we set up such a slippery slope, not only for the future of protecting local zoning regulations, but for the future of quality mental health and addiction treatment services. We can't turn this into the type of funneling, it's a Ferris wheel of profiting. We've got to protect quality treatment. We've got to protect how it's regulated. We've got to protect how it's funded, and trying to let people in through zoning exemptions that don't comply with those terms. It's a recipe for disaster.
Thank you. Thank you, Mr. Chair.
Representative McCarthy-Vahey.
Thank you very much, Mr. Chair. And Ms. McLeod, it's nice to see you. I am happy to say that Fairfield is well represented here today in this hearing on a variety of issues. So Fairfield pride for sure. I'm glad that you mentioned that you were listening in earlier. I know it has been a long day, and I really appreciate your patience and the patience of all those who are still waiting. But I wanted to ask you the same question that I asked the previous witness or the person testifying earlier, which is that, do you think that this bill as it's written would in any way run afoul of the federal law?
I do not. And that's because I can say, after many hours working with our state and local representatives and extensive Office of Legislative Review processes, is we were very careful in specifically choosing defining factors. The federal law is a civil rights protection for fair housing. And although some of the testimony submitted by other attorneys in the federal lawsuits that you can read up on the website reference different settlements and different fair housing claims, all of those are not specifically addressing mental health residential living centers. They are addressing long-term group homes for people with mental health disabilities, people with addiction diagnoses that are recovering. They are not the same as a 45 to 60-day treatment turnover facility. And there is a specific difference, because there is a lot of case law, which was conveniently left out of some of the testimony that was submitted, that suggests that just because something has a residential component doesn't mean it's a residential long-term fair housing protection. Just because somebody has the ability to stay in a location for a very short period of time doesn't mean that they are entitled to long-term residential protections as if it's their residence. And after extensive OLR review and specific terms that we made sure that we use to make sure that it's a definition clarification and not anything specifically targeted towards a specific class, a specific disability, or a specific protection, it's merely to define that this does not regulate healthcare facilities as defined in the state of Connecticut. It's to regulate a community residence. And that's where the loophole, unfortunately, has been created and taken advantage of for a few years now. And that's where the danger is if we allow the verbiage to stay as it is and not make those clarifying distinguishments, because without giving local zoning directors something to look at that they can actually discern the difference between we're going to have towns and municipalities all over the state that don't know what to do when placed with an application for a change of use for a group home and not know how to treat it differently than whether they're being applied for a medical treatment facility or a healthcare facility as defined by the general statutes. So to answer your question in a long-winded way, I do not believe that this runs afoul of federal law because federal law does nothing to speak to this specific issue.
Thank you for your answer and for all of your work. I appreciate the time and the opportunity to talk to you today. Thank you, Mr. Chair.
Thank you, Madam Chair. And anyone else, any other questions? Any other questions? Megan, thank you very much for your testimony. Very powerful, very well done. Appreciate it. Daniel Osborne, is Dan on? I don't see him on the screen yet. Dan Osborne, Daniel? Gilead? All right, I'll try to come back to Dan. Sarah Lamaster, followed by Laura Bourbon and Rebecca Hollow. And we are halfway through the hearing.
Hello, good afternoon. How are you? It's a hard act to follow. My name is Sarah Lamaster. I'm the Manager of Government Relations and Public Policy for the Community Health Center Association, and I'm testifying in support of House Bill 5168. Connecticut's community health centers provide care to over 380,000 residents every year. We specialize in providing care to traditionally underserved communities. We do not turn people away based on their ability to pay, and patients have access to same-day medical, dental, and behavioral health services. 20% of our patients identify as Black, 48% is Hispanic or Latino, and 58% receive Medicaid benefits. I'm also very proud of the work that our health centers have done in fighting against the COVID-19 virus. Throughout the course of this pandemic, health centers have been working diligently to protect our communities and support our public health infrastructure. We've provided over 930,000 COVID tests and fully vaccinated over 386,000 residents since August of 2020. Unexpected tax bills are a burden to our health centers and hinder their ability to provide valuable programs and services to our communities. Health centers' financial resources have a substantial positive impact on their surrounding communities, and limiting these resources reduces access to programs and services that have been proven to reduce emergency department usage, lower overall healthcare costs, and make our communities stronger and healthier. We support this bill as a necessary statutory change to protect health centers who expect to be exempt from taxation as they are nonprofit entities providing valuable services to our communities. Our health centers are also economic engines that drive our state and local economy. Unexpected tax bills hinder our ability to function in this capacity. Currently, health centers employ over 4,000 people in the state and create an additional 1,900 jobs in our economy. According to a study conducted by the National Association of Community Health Centers, we have an estimated annual impact of over $868 million. Thank you for raising this bill and providing us with the opportunity to offer testimony on this important issue.
Thank you for your testimony. Are there questions? Any members of the committee? That means you did a great job. Thank you.
Thank you.
All right. Laura Bourbon. Laura? Rebecca Hollow?
Hi, Senator Casano, Representative McCarthy Vahey, and distinguished members of the Planning and Development Committee. Thank you for the opportunity to speak today. My name is Rebecca Harlow, and I'm here to express my support for Senate Bill 131. I am the chair of the Ebook for Lion, which is a consortium of 30 public libraries in Connecticut, and I have been managing Overdrive collection for about 10 years. In that time, we've endured never-ending attempts by publishers to make it as difficult and costly as possible for us to provide digital books to our patrons, including extreme price gouging, refusing to allow libraries to purchase titles for a certain amount of time after their release date, and refusing to sell to libraries outright. On average, our consortium spends about $15,000 a month on digital books through Overdrive. patrons still have a 6-month wait for new items. We can't afford to purchase most titles when they expire under the metered model. We can't afford to fill large gaps in our series collections, and we can't afford to purchase content that reflects the diverse needs of the communities we represent. If this is the experience of a consortium of libraries in some of the wealthiest communities in the state, I can't imagine how this is impacting our less affluent communities. The Lion Consortium has spent over $1.5 million on digital books through Overdrive. With that, we have purchased only 38,000 digital books. Because of the metered model, we've lost access to 10,000 of them and will lose access to 18,000 more over the next 2 years. And the problem is only getting worse as most publishers move to this model for both ebooks and audiobooks. In the last year, 81% of the titles the Lion Consortium purchased were metered access. If we stopped buying digital books today, by 2024, we would only have 10,000 titles to show for a $1.5 million investment of taxpayer money. A lot of what I had planned to say has already been said, so I do want to point out a couple of things that were brought up. One thing is that we are starting to see a shift in audiobook publishing where they are only being produced as digital copies. Somebody had mentioned House in the Cerulean State. And that is actually an example of a book that was only made available as a digital audiobook. And I think in the near future, this is going to be the only way that libraries can offer this type of content. I think that we're really at a critical juncture point, and time is of the essence to rectify this situation. And Senator Cassano, I believe you had mentioned that there might be some sort of federal cooperation that we need. And I don't think anyone has mentioned this yet, but the heart of the problem is with copyright law and with the first sale doctrine. And I'm not a legal expert, but the issue is that libraries are allowed to, or publishers are allowed to circumvent the first sale doctrine by leasing us the content.
Ms. Harlow, your time is almost up.
Sure, I can wrap it up here and take any questions. I just want to say thank you for your support and your time on behalf of our consortium, my library, and the residents of Connecticut.
Thank you. Are there questions? Any questions from the committee members? Representative McCarthy-Vahey. Madam Chair.
Thank you very much, Mr. Chair. Ms. Harlow, thank you so much. The tail end of what you were saying, I'm just going to confess that I had to run to grab a snack. So I just wondered if you could, and also it relates to some of the issues that we were talking about earlier in terms of what the publishers are doing in the copyright piece. This I will ask you, I had asked an earlier, someone else, one of the earlier librarians testifying related to what is being done on a national level. And since you work with the consortium, I wonder if you can speak to that in terms of what kinds of conversations have happened with the publishers and what people are running up against.
Sure. So I can't speak too much as to what kind of advocacy is happening at the national level. But I've been doing this for about 10 years now, and what we typically see are cycles in which publishers try to implement a new model that would make it very difficult for us to provide the content that patrons are looking for when they're looking for it at a reasonable price. We band together as libraries on a regional, statewide, or nationwide level and do something to put pressure on the publishers. They realize that we're not going to bow to their pressure, and they make a change and they implement some new tactic. When we first started, probably at least 50% of ebooks and audiobooks were available under that one copy, one user, buy it or lease it in perpetuity model. But their tactic was to price gouge. So, we might be allowed to buy a copy under that model, but we would pay $90 for it, where we might pay $10 if we were a consumer. That didn't really fly with most libraries, so they changed and lowered the prices, but made everything metered. There was one point where there was an embargo where you weren't allowed to buy a title for the first 3 months of purchase in order to try to push library users to purchase a title instead of getting it from the library. And it just goes on and on. Now, I think what we're seeing and what we're going to see is that publishers are testing out the metered model for audiobooks. So right now, as a library, you are able to choose between buying a copy of a book, an audiobook, for a very high price, or you can buy it metered for half the price. And they're banking on a lot of libraries choosing the metered model because we're simply too poor to continue to spend all of that money on audiobooks. And then I think they're going to go back and use that information to say, look, librarians rule this metered model, we should just switch. So on a nationwide level, libraries are constantly banding together and advocating to protest whatever the new thing that publishers come up with to make it difficult for us to serve our patrons. But without any type of legislation or protection, without legislation like this, or some reevaluation of copyright law, they're just going to keep coming up with new things that we have to band together against.
Thank you for that answer, and also just for the last piece of what you said in terms of copyright law, which is, of course, out of the purview of this body and this level of government, really. So I appreciate that as part of your answer. Thank you very much, Mr. Chair.
Representative Smith.
Thank you, Mr. Chair. Thank you, Rebecca, for your testimony. And notwithstanding what my colleague, the good Madam Chair, said, I want to thank you for introducing copywriting to the conversation, because it really is the root of the problem. And, to the extent that it is out of our purview and is a federal matter, the flip side of what you're experiencing, it seems to me, could also be a flip matter, which is that it smells to me, at any rate, like there's an antitrust issue going on with the publishers. It smacks a little bit of collusion to me. So to the extent your association is taking steps on a federal level to remedy this, I would encourage you to look at every aspect of what you're experiencing, not just sort of the side that hits you in the pocketbook, because it would only take one publisher becoming more reasonable in what they do to start to turn that tide. But thank you for expanding the conversation and opening all of our eyes to the deeper roots to the problem. I appreciate it.
Thank you.
Any other comments? Madam Chair, you indicated you got a bite to eat. I've got a bag of potato chips here, and I keep bringing up this bottle. It's not a beer bottle, it's Hosmer root beer.
Well,
that brings us to Daniel Osborne. Dan, welcome.
Thank you. Thank you for coming back to me. Good afternoon, distinguished members of the Planning and Development Committee. My name is Daniel Osborne. I'm the CEO of Gilead Community Services here in Middletown. I'm here today to support House Bill 5168, an act concerning property tax exemptions for property used for charitable purposes. I'm also hoping to also comment on Raised Bill 130. Hopefully time permits. But in terms of House Bill 5168, this act would take an important step toward ensuring that nonprofit charitable property tax exemptions are protected. Over 50 years providing quality mental health services, Gilead has owned several buildings, as you can imagine, for the purpose of providing various mental health services. Currently, we own and operate 19 different programs through 15 different sites throughout Middlesex County and Hartford County. As I testified last year on a similar bill, Gilead's story as it relates to property tax exemptions is unfortunately a complicated and costly one. Similar to many other nonprofits in Connecticut, over the first 40 plus years of Gilead's 50-year history, we were routinely approved for property tax exemptions at multiple sites in different towns throughout multiple counties. Based on Connecticut state statutes, I believe that 40 plus year history reflects a proper implementation of tax exemptions based on law, because we are a charitable organization and we are used exclusively for charitable purposes. Unfortunately, over the last several years, tax assessors have made the determination to deny our application for tax exemption after years of approval and no change in use. I stand before you today as a testimony of the impact that these unprecedented and unlawful denials of rightful property tax exemptions have on organizations like Gilead. Gilead and our sister corporation, Rainbow Housing, were victorious in our recent legal action related to the town of Cromwell's denial of our property exemption based on a favorable ruling from the Connecticut Supreme Court. This victory, however, as much as we were pleased by it, came at a significant cost. Over the last 5 years, we've spent over $100,000 fighting this issue. In addition, we have at times been forced to pay tax bills under protest while the legal process plays out. As a result, Gilead is allocating $25,000 to $30,000 each year that takes away from our mission, simply because an assessor's interpretation of a statute that goes against decades of precedent on this issue. My finance department estimates that the removal of tax exemption for all 15 Gilead properties would cost our organizations somewhere between $75,000 and $100,000 each year, which would absolutely impact services and require us to close or reduce programs. So this is no small issue for us. I know you've already heard testimony on the details. House Bill 5168 takes important steps that we do believe would help facilities like ours, even though we were victorious, removing the word temporary from the statute.
Mr. Osborne, your time is almost up.
All right, thank you. Removing the word temporary from the statute would help ensure that other organizations don't have to go through what we went through, creating the one statewide exemption form, consistency, so that nonprofits know what they're applying for, requiring that an assessor explain why an organization was denied, which never happened with us. We were never told the reason for our denial until we were in court, and allowing nonprofits to recoup attorney's fees, which obviously won't benefit Gilead or Rainbow and our attorney's fees, but would again allow other nonprofits to not have to experience the impact that we did. So I don't know if I have time to speak on Raise Bill 130, but that completes my testimony on the tax related bill.
I would like to let you go on, but seeing we're only halfway, I think I'd be shot by my committee members. So are there questions of the members of the committee? Madam Chair, Representative McCarthy Vahey.
Maybe I'm about to experience that fate. Mr. Osborne, if you can, in literally 30 seconds or less, just share your comments about Senate Bill 130.
Sure, absolutely. So I would ask you to strongly oppose Raise Bill 130 because if it were passed, it would encourage members of our community who are against group homes for people with disabilities to place added pressure on towns to oppose the rights of individuals with disabilities. So I know I don't have a lot of time. I would ask you to go ahead and Google Gilead versus Cromwell to read about Gilead's tragic story in which people with disabilities were denied the opportunity to live in the home of their choice in the community because of the discriminatory views of neighbors that this bill would actually foster and encourage. This bill would also encourage towns to violate federal law, which in Gilead's story, a jury found the town of Cromwell liable for violating the Fair Housing Act and the American with Disabilities Act, and awarded compensatory damages of $181,000 and $5 million in punitive damages. So sometimes it's about unintended consequences, and I do fear that communities would feel empowered to place additional pressure on organizations like what happened to Gilead several years ago that was extremely unfortunate, despite the recent successful legal outcome.
Okay, thank you, Mr. Osborne. I think this bill is intended to be pretty narrowly focused, but I appreciate your input. Thank you, Mr. Chair.
And thank you for that explanation. Appreciate it. Any questions from anyone else? Oh, Senator Wong.
Thank you, Mr. Chair. And Mr. Osborne, thank you for your first intro. And I'm actually familiar with the Gilead and Cromwell case. Thank you for the really good work that you do. But explain to me, are your organizational entities group home residences?
Yes, we are group
So
home.
you have 6 residences or less. They live in those communities, homes, and they are residential group homes. Is that correct?
That's correct.
They're not a medical treatment facility that requires a certificate of need requirement.
That is correct.
And did you read 130 from the standpoint of the narrow band of looking at 8-3E that stipulates it's a clarification of definition, and it is aimed at protecting group homes of residences of a protected class, similar to what your organization does. And may I be clear that for any entity, because McKinney versus Fairfield was a determining case in the state of Connecticut, we know it far too well in Connecticut and Fairfield, is the fact that they were denying group homes of individuals in hospice from AIDS because they were living there. It wasn't a medical treatment facility. It is a clear definition and delineation. And I just want to be sure that you understood the efforts we went through to delineating, and it was intended to protect group homes like the great work that you do. Now, upon this clarification, Mr. Osborne, that this is aimed to protect the 1% ratio of a protected community for residences, group homes that people will live in, interact, and be a part of a community. And it does not in any way restrict or prohibit, and it's clear in that language, Mr. Osborne. I'm wondering if you read that.
I did read it. I did read it, and I
would you interpret that?
I'm not a lawyer. I'm a social worker, so I'll put that on the table. But we do have Zoila Hinson from Relman Law, who's going to be testifying later, so she may be able to add some additional details. But my concern, and it's absolutely based on my recent experience, is that while I hear that the intended approach of this change is to benefit group homes, seeing the lengths to which community members tried to twist language that I'd look at and say 100%, this is what this language means, but that the approach that was taken was the exact opposite. I'm fearful that this creates some perceived loopholes that could be exploited in a way that does the opposite of what it sounds like you're intending. So that's my concern.
Without a doubt, and we won't want that. We've worked on this bill for nearly 3.5 years to be sure that the loophole on one end does not turn into a loophole on the other. We are emphatic in protecting group home residences, which you so effectively provide. And shame on any community that would exempt group home residences. But the difference is, Mr. Osborne, did any of your entities entertain a certificate of need? Did any of your entities consider yourself a medical treatment facility?
We do have licensed facilities, the ones that we're speaking of right now. So of our 19 programs, we do have licensed facilities that could fall into that category. The program that was involved in the Gilead versus Cromwell case was not one of those. So that experience was based on an unlicensed, because it didn't require a license based on the statutes, 6 or under program residential environment for individuals with a mental health need. But we do also have licensed facilities.
Without a doubt. And there are certain group homes that require some medical care, but did it require a certificate of need approval from the Office of Healthcare Strategies?
No, not that I'm aware.
Thank you. That's the key difference. A medical transitional facility is not a group home. Would you agree with that statement?
They are different.
That I think rereading that statute, I'm glad. I want to repeat that statement that you validated, that a medical transitional facility is not a group residential home.
I understand. Sorry, I don't know if you were looking for me.
I just wanted you to validate the first time that a medical transitional facility is not a group residential home on your expertise.
Yeah, they are different. Again, the concern is just one spilling over into the other in terms of how the community perceives the statute. So That's our concern, but I certainly
I
respect and
completely hear
appreciate-
you, and that was our concern on the other extreme as well, that the loophole and the non-clarification has afforded the potential misguided use of that language that take away, because you know clearly that the law protects 1% of the ratio of the population, that these kind of potential misuse of that definition on the other extreme that you articulated could deny rightful and justified nurse group residential homes. So again, without a doubt, language is a challenge. That's why we work so hard with a legislative attorney and have the public hearing process. This bill has gone through 3 years of those such processes and multiple legal perceptions. And so I agree with you. I certainly don't want it to go on the one end of denying legitimate group residential homes, but the clarifying definition in this bill actually protects that and protects against the other extreme of non-group residential facilities using a loophole to be able to take away potential opportunities for your valued members. So I really must say that your worry should be on both ends. And as you said, you're not an attorney, and I want to applaud you for your great work that you do. But I had to offer to you to make a blanket statement like that seems dubious to me. And really, I would encourage you to read more about the intent of this. And I love to be able to chat with you more as well. And I want to close by thanking you for the good work that you do for a needed community.
Thank you.
Thank you,
I
Mr.
do
Chair.
appreciate the support.
Any other comments by any committee members? Any other questions? Seeing none, thank you very much, Dan, for your testimony. Appreciate it. You know, we really look to take it seriously, and we've got some issues before us as a committee, and we'll work them out. I can tell you, living in Manchester, a town with more than 60 group homes, a very large population of people with disabilities, very active in our community, tremendous support in our community. If you live in a town where you don't have that, you're really missing something. And I don't want it abused by what might be happening to stretch the rules. So we're very strong on this. Thank you. Let's see. Rebecca Harlow. Rebecca was on before, right? Amy Blaymore Patterson. Amy?
I'm coming. I'm just starting my video here. Thank you, and I appreciate the patience. Good afternoon, Senator Cassano, Representative McCarthy-Vahey, and distinguished members of the Planning and Development Committee. For the record, I'm Amy Blaymore Patterson, and I'm the Executive Director of the Connecticut Land Conservation Council. CLCC is the umbrella organization for the state's land conservation community, and we work most predominantly with the state's approximately 130 or so land trusts. I want to thank you for this opportunity to present testimony in support of SB 129, which would provide an option to towns to adopt a tax abatement program for landowners who choose to permanently conserve certain trail corridors on their property. I've submitted written testimony, so I'll be brief, especially recognizing how long you've been here and how long you have to go. But I just want to quickly touch on a couple of points in support of the bill. First, I think it's important to look at the mechanics of how this program would work. The bill is enabling, the program is optional. Towns may, but are not required to adopt it. A landowner may only apply for the tax abatement if the municipality has passed an ordinance authorizing the program. The subject trail or corridor must meet statutory criteria defining a greenway, and that's codified at 23-100 if you want to take a peek. And the landowner must place a permanent conservation easement on the trail corridor. There's also a requirement that the width of the corridor is limited to 100 feet. I do want to note that in our written testimony, we did point out the need for a technical correction on line 16, which would change "or" to "and." And that's important because all of the foregoing criteria that I just enumerated are required in order to institute the program. But I want to use the balance of my testimony. I was thinking a lot about this after I submitted my written testimony and relating this to some work that I did a long time ago, and I'm going to date myself a bit. But back in the early 90s, I was honored to be appointed special counsel to the town of Vernon's Hockanum River Linear Park Committee. And my job was to put in place the legal arrangements to implement the master plan to develop the linear park, which was funded with federal grant monies and matched with significant state and local dollars. The arrangements ranged from conservation easements to pocket park development, rail to trail projects working in partnership with DOT and DEEP, as well as establishing small but critical linkages involving private landowners whose property provided critical trail connectivity along the Hockanum River. And for the latter, in the earliest days, some of those agreements started out as very personal in nature, and those agreements didn't run with title, which meant that when those properties were sold, there was no guarantee that the trail permission would be maintained. That, of course, would have created disruptions in a linear park system that is a major draw for people living, working, visiting, not only the town of Vernon, but also other towns along the Hockanum River Linear Park corridor, including Manchester and East Hartford, as you know. And that was a big concern. And you heard from Bruce Donald this morning that there are communities along greenways around the state where it's still a concern. So I think back to the negotiations and implementation of the linear park in those days and how helpful it would have been if the town had the option to offer a tax abatement program as an incentive to those landowners. It's still working on that linear park after 40 years. And so SB 129 would give towns that option. So I want to thank you for raising Thank you for raising the bill and for all you do, and I'm happy to answer any questions.
Thank you for your testimony. Representative Winkler.
No question. Amy, I just want to thank you for all the work you've done on our fantastic trail system. Thank you very much.
Oh, my pleasure. Thank you, Representative Winkler, for your wonderful representation.
Thank you, Mr. Chair.
Seeing no other hands. Thank you very much for your testimony.
Thank you. Have a great
Senator
day.
Wong has his hand up.
Oh, I'm sorry.
Nope. I just want to make it a bipartisan applause for the great work of the entire organization for land conservation and preservation. So bipartisan. Thank you very much.
Thank you, Senator Huang, for your tremendous leadership as well. I am grateful to you all for all that you do and hope the day goes quickly for you. Thanks again.
Thank you, Senator. Let me go back here. Okay, next we have Amy. Laura Bourbon. Did Lauren come in yet? Amy Blaymore Patterson. Amy?
We just heard from Amy. I think Lynn.
Okay.
Lynn
I lost on my screen here. I got Amy. Lynn Roman. I know Lynn is on deck here. I see Lynn over here on the right. Lynn, thank you for coming and for being patient.
Well, thank you for you all deserve the patience. I'm really very impressed with all you do and the stamina you have to listen to all of these issues and work them out. So here's another one for you. My name is Lynn Roman. I'm a resident of Fairfield, and I'm supporting House Bill 5107, which was, I believe, passed unanimously or with great acceptance in 2018. And this is simply a refinement. And I want to say, although I do support the bill, I think it's woefully short. When you look at other states in the country, you know, Connecticut is considered to be more progressive, and yet Texas and other places have significantly more stringent, more humane rules regarding companion animals. And I do support this bill, even though it's not quite what we were hoping for. Some of the advocates had gotten together and written up our wish list of what we would like to see for the town of Fairfield in particular, and of course for the state in general, but it's just been slow going. So you're the experts. I'm very much a novice at this, and I thank you so much for even having me. It's been an honor just to watch all the workings that you do. I never really had much of a political background. So, but this is very much a bipartisan issue. So I just want to give my full support and tell you that there's so many constituents out there of yours, all of yours, who are, again, this is a very bipartisan issue. It shouldn't be You should not be able to have inhumane treatment of companion animals in such a progressive state. I'm frankly gobsmacked that we're even allowed to have an animal tethered 24/7 and in any kind of weather condition. So this bill sort of addresses that. It's really falling short of what we would like, but I really hope that it's a first step in moving in the right direction.
Thank you. Are there any questions? Any committee, Representative McCarthy Behe, Madam Chair.
Thank you, Mr. Chair. I know you're shocked to see my hand, but I just wanted to say again, another Fairfield resident or someone connected to Fairfield, thank you so much, Ms. Roman, for being here. And also just for acknowledging the compromise. That the work that's been done has been done, as you said, on a bipartisan basis we've had Rep. Devlin and Rep. Leeper working together with other folks. And that really is kind of the name of the game here as you're hearing today. So I just want to thank you for being here, for your advocacy and just for acknowledging that, and hope that we can continue that as this bill, we hope, moves through the process. Thank you, Mr. Chair.
Thank you. Anyone else? I don't see any other hands. Seeing none, Amy, thanks again for your testimony. Moving on to Lynn Roman. I know Lynn is here. Lynn is number 35. If you're on the list, we're getting closer to 64.
I think we're on to Betsy now, Senator.
Yes.
It should be Lynn and then Betsy, but Betsy, if you're ready, you go, and then we'll go with Lynn.
Sure. Thank you. Lynn did just finish testifying, but
Okay,
thank you,
I'm sorry.
Senator. That's all right. It's a long day, as you
It is.
understand,
Too many
particularly
lists.
for you and your colleagues there on the committee. Good afternoon. My name is Betsy Guerra. I'm the Executive Director of the Connecticut Council of Small Towns. We represent 118 members throughout Connecticut. And I submitted a lot of testimony. I'm just going to summarize very briefly a couple of those pieces of testimony. I'm here today to support House Bill 5167, which authorizes municipalities to approve a delay in property tax revaluations. This is something that actually came up at our annual meeting during the Legislative Leaders Forum, and it was something that there was general agreement that this would be helpful, particularly given the spike in real estate values that occurred as a result of the pandemic, when people found out just how great it was to live in a state like Connecticut. There is precedent for the adoption of legislation allowing towns to delay property tax revals due to changes in housing markets. The legislature adopted a delay in reval in 2014 and also in 2009. That was due to a depressed housing market. So I do think that there are some towns that would like to avail themselves of this opportunity. As drafted, the authority to approve a delay in revaluation has to be approved by the town's legislative body, which in many of our smaller towns, as you know, is the town meeting. So I do think that this is a good bill and deserves your support. I do want to touch on, I know you've heard a lot about the bill, Senate Bill 128, concerning unpaid sewer assessments. We do oppose the bill as drafted because we are concerned that it would undermine the ability of our towns to collect delinquent sewer bills, which are needed to operate and maintain the water pollution and treatment systems. In small towns, as been mentioned, these costs are spread over fewer residents, and delays in paying bills and collecting bills can add up and result in some real difficulties for these systems. We do know there are some conversations among the tax collectors and the WPCAs to find a better resolution to this issue, and we're happy to participate in those conversations. And then just to touch on a bill that Amy Patterson had mentioned, Senate Bill 129, an act establishing a tax abatement for certain conservation easements. We did talk with Eric Hammerling from the Connecticut Forest and Park Association, and we certainly recognize that the trails and greenways in our communities are just treasured. People really enjoy using them, particularly during the pandemic. I think being able to get outside was a very healthy, welcome relief. So we do, as you know, have concerns about the impact that this may have on property tax revenues. It is a local option, but sometimes that does impose pressure on towns to adopt, but we do want to continue the conversation with CFPA and others to see if there's a way that we can assist them and figure out a way to
Ms.
create.
Gara, your time is almost up.
So thank you. Happy to answer any questions.
Any questions of any committee members here? I'm somehow missing. Any questions? Seeing none? Betsy, you're off easy today.
Great, thank you.
Thank you very much. We're moving on to Tom McManus and then Jason Villani.
Thank you, Mr. Chair. Can you guys see me? Can you hear me?
I can hear you, but right now we've lost you on this stream anyways.
Okay, all right. Well, you're not missing too much. Senators and representatives, I'll be brief. I appreciate the testimony that, hold on. There we go, perfect. All right. I'll try to be brief. Miss Megan McCloud covered it very completely earlier. And what I'd like to talk about briefly are the people that are left out. Okay. Senators and representatives, thank you for the opportunity to speak before the committee. My name is Tom McManus, and I'm speaking today in strong support of SB 130, an act concerning regulation and community residences. There is an exploitation occurring of people with mental health and addiction in our state. Private equity investment companies are extracting funds out of the Connecticut state healthcare system through 8-3E abuse. SB 130 will add simple and very necessary clarification that will stop the abuse of current 8-3 legislation and loopholes therein. Lack of clarity in a law that was written with real positive impact needs to be updated to account for the creativity of investment companies. As it stands, the law is resulting in an increased financial burden and underfunded services for lower income earning Connecticut residents seeking mental health and addiction treatment. The unfortunate fact is that certain for-profit corporations exclude services to patients relying on Medicaid and only serve wealthy individuals or those with the best paying insurance coverage. In doing so, a divide is created with the available mental health and addiction services in the state of Connecticut. Two groups exist, where a highly funded and highly profitable group operates completely insulated and independently from an underfunded group that should be affordable and accessible to all. This cannot be. Any for-profit corporation seeking to gain the protections and special accommodations afforded within 8-3E should not only be fully financially accessible to all Connecticut residents seeking help, but should contribute to the healthcare funding resources available to all Connecticut residents and with compromised mental health and addictions. Instead, the law as it stands, medical facilities are free to provide returns to private equity investors without regard to sustainability of our state's mental health care system and the people in our communities. Revenue from wealthy patients or those with best paying insurance coverage is sent to the corporation and not contributed to Connecticut healthcare. The extraction of profit to shareholders removes crucial resources that should be paid into our state's treatment funding. The state of Connecticut has a certificate of need vetting process that regulates certain types of healthcare providers and medical facilities. Through this process, OHS approves which types of treatments are allowed, which regulations and oversight apply, and a host of other requirements are determined. A group home is not subject to the certificate of need process, as it is a home and a protected
Mr.
entity.
McManus, your time is almost up.
Okay. OHS determines if the operator is a group home or a mental health living residential facility, requiring a certificate of need. Separately, 8-3E is currently written to protect persons receiving mental health and addiction services, but falls short to consider that some operators will be subject to the con process and OHS review and fail to achieve a group home designation. 8-3E needs to be amended to be consistent with and respectful of the OHS con vetting process, as well as require Department of Mental Health and Addiction Services oversight and funding. I urge you to vote in support of SB 130 to ensure accessibility and support the standard of care for all Connecticut residents seeking mental health and addiction treatment. Thank you.
Senator Casano, you're muted. I had to say it.
I'm muted because I've lost my committee members. I do have people on hold here. I know that Wade is working on fixing it, but I could see you, Madam Chair.
Oh, good. Senator, would you like me to take over for a moment while
For a
you?
second, till we get this straightened out.
Happy to do so. You've been carrying the mantle for many hours, so
Not a problem.
thank you, Senator, and thank you, Mr. McManus. Senator Wong.
Thank you, Madam Chair, an efficient team. Mr. McManus, thank you very much for your presentation. And let me ask you, there's been many conversations about turning a blind eye to mental health, protected classes, and that it's exclusionary kind of practices. You're a vocal member of a Fairfield community. Can you just publicly stipulate and share the philosophy and the openness of the community in welcoming protected classes, residential group homes?
Absolutely. One of the first people that we need to protect in this are a family that my middle child goes to school with. His family has a child on the autism spectrum. Okay, their plan is to have a real group home so that this person can live there for the rest of his life. It's the parents' fear that they won't be, after they're passed, that the child won't have a home to live in, that won't have the adequate support and care system. And so they've put in all this effort and time to build this location, to have this facility, this home for him. But that is now in jeopardy because right across the street, these mental health residential living facilities are opening, and by statutory restrictions is they will actually be prohibited from establishing a real group home that their child will be able to live in once they're gone. So, there's accessibility, there's protections that are extremely important on the group home side of it, as well as all the funding into people that are seeking care in a short-term way, that aren't getting the funding returned back to them because there is no Medicaid accepted. There is no Connecticut in-state insurance accepted. So, I'm not against corporations making money. I think that there's a supply and demand that works in our market and will dictate to how successful or how they will fail. But when we're giving protections, these extremely important and very valuable and in the sense of life-sustaining, okay, but valuable in the sense of dollars that are returned and extracted to investors is not what we're after. We're into protecting the value of these limited resources for our community members that need to be insured housing for the rest of their lives, as well as protect the dollars that are paid into our Connecticut healthcare system.
Thank you. It's important to kind of denote, Mr. Osborne of Gilead, who testified earlier as a kind of an aside question, but it was a public statement that he was concerned about going too far to one end of excluding group homes. I think he's absolutely right that we want to clarify this definition so that we don't go too far and alienate the necessary group residential homes versus going the other side of having private equity, hedge funds be able to use the definition of group homes to be able to bypass local zoning rules, to go to the other extreme. I think the purpose of this bill is not to punish anyone, but to maintain that the integrity, the values that we are espousing by this protection of an important community that we want to be part of every community, that these statutes are clearly defined and protect so that both ends are not excessive. And so I appreciate your advocacy and your support, but also being able to share the story that a legitimate group home, as a result of going too far on the other extreme, could jeopardize an ability for a protected community to be able to not live and reside and be a part of a community. So thank you very much, Mr. McGannis. Thank you, Madam Chair or Mr. Chair, whoever is back in the system. Thank you.
We're
Thank
partners.
you.
We're good partners.
We'll give Senator Cassano a little break for a little while. Thank you so much, Senator Wong. Are there any further questions from members of the committee? If not, I do want to thank you also, Mr. McManus, for your testimony and just for highlighting another aspect of this issue, which I think is one that's important for folks to have an understanding of. And I think it was helpful. So thank you for being here today. Next up on our list, we have Jason Villani, who is number 38, to be followed by, I believe, actually, we have next up Terrence Hart, if I'm not mistaken. And Madam Clerk, feel free to chime in if I'm wrong about that. Mr. Villani, please proceed.
Thank you. Good afternoon, Senator Cassano, Representative McCarthy-Vahey, and distinguished members of the Planning and Development Committee. My name's Jason Villani, and I'm here to speak in support of SB number 131, an act concerning electronic book licensing. I speak to you today as a reference librarian at the New Britain Public Library, currently in my 14th year, and as the librarian who purchases our ebooks for our library. I'm well versed on this topic, and I've spoken on it on a panel at the New England Library Association's annual conference in 2020. I want to also mention this is already on the radar on the federal level, and strongly recommend you take a look at the ALA, American Library Association's kind of information press release on competition in digital markets for a succinct and detailed overview of this issue. It's a great cheat sheet to have, and I could put that in the chat right now. So I can confidently say that what we are dealing with is a textbook antitrust issue, which I even think our Attorney General needs to be aware of. This is about multi-million-dollar publishing monopolies and their predatory profiteering racket targeting public libraries. When it comes to ebooks, and you've heard some of this before, so when it comes to ebooks, these publishing monopolies, there's currently 4 giants that control like 80% of the global book trade. These publishing monopolies are exploiting a digital content loophole whereby electronic content can be licensed on the terms of the publishers, which allows them to bypass the for sale doctrine with these onerous and unfair licensing contracts for ebooks. These restrictive licensing contracts are only targeted at libraries. The first sale doctrine governs the fact that when a library buys a physical book, it is now library's property and they could do what they want with it. So that's a key piece. Only libraries have to pay triple or quadruple the price, as you've been hearing, for ebooks, and even then only get them for a limited time. Publishers know that they have a captured market with public libraries, and they are getting away with a price gouging racket in broad daylight. This is actively harming libraries' abilities to provide equitable access to ebooks and even retain them for posterity. The terms libraries are forced to take, as you already know, when purchasing these ebooks are extremely unfair by any metric and absolutely unacceptable. What makes this more outrageous is that the public library system, with our national purchasing power—
Mr. Villani, your time is almost up.
Matt, with our national public purchasing power of physical material, has kept these million-dollar publishing houses well padded with big profits, so the fact that they are exploiting us with this patently unfair arrangement with ebooks, when we have already been their gravy train, is really despicable. This is corporate greed run amok in an attempt to sabotage key functions of the public library system to provide equitable access to materials and preserve our cultural record. I cannot stress how deeply important this issue is going forward and the need for a legal remedy to put these publishing monopolies in check. The future of our public library system depends
Thank you.
upon it.
Thank you, Mr. Villani, for being here today and for your work in the library. I will take this chance to remind folks that we are not able to use the chat function just because of the public nature of the meeting. So while I certainly appreciate the resource and as well the reference to the press release from the American Library Association, which we will search, but just a reminder on that. Are there questions from members of the committee? Seeing none, thank you so much for being here with us today. It's much appreciated, as well as your work.
Thank you.
Next is on our list, who I'm not sure if he's here, Thomas Reagan
Lefebvre.
Lefebvre, thank you very much for the help with that. Is Thomas here today? I don't believe that he is present today.
I haven't seen his name yet. Let me, I'll pick up again if you'd like. Brian Anderson. Is Brian Anderson here? Luis Perez.
Brian is coming into the as a panelist now.
Okay. And Brian is followed by Luis Perez, number 41, and Terrace Hart, number 42.
Good afternoon, Chairman Casano, Chairwoman McCarthy Vahey, Senator Wong, Representative Zullo, and members of the Planning and Development Committee. My name is Brian Anderson. I'm the Legislative Director for Council for AFSCME, a union of 30,000 public and private employees. We also represent 2,000 Connecticut municipal police officers. Council 4 urges you to support House Bill 5172. This bill would allow public safety personnel who have retired under the municipal employee retirement system to receive a pension benefit while they are employed by a Board of Education, which happens to participate in MERS. Hartford Mayor Luke Bronin has testified that he supports this bill because there's a shortage of qualified workers. This bill would allow for retired police officers to work in schools and protect children's safety. Retired police officers would be able to bring their experience and skills to a school system rather than using personnel with much less experience and training. The Connecticut Conference of Municipalities has testified that allowing such workers to receive this contractual compensation would not place an undue burden on the MERS system. The MERS system is strongly funded and in good financial shape. Other municipal pension systems don't bar similar employees from receiving such compensation in our state. You may be surprised to learn that Mayor Bronin, CCM, and our union don't always agree, but in the case of House Bill 5172, we do agree. Be happy to answer any questions.
The questions of the speaker, Brian Anderson. Representative Delnicki.
Thank you, Mr. Chair. And Brian, great to see you here today.
Good to see you, Representative.
We all want our children to be safe when they go to school. Now, I agree there's a shortage of professionals that can actually go in there and do the job. How many folks would be, in theory, available in the pool of retired police officers if we were to allow this bill to go forward?
Yeah, Representative, that's a good question. I don't have good information on that right now, but I could check and get back to you on that.
Is it safe to say, and this is just to make a judgment call here, is it safe to say that literally we would have enough retired officers that could jump in and do the job, even though we are conceivably have a tough time quantifying that?
I'm betting we do. We've heard from enough of our members and enough of our retirees on this that I really do think this would be helpful.
And would some of these retirees have been, say, school resource officers too at their time?
That's a possibility. Now, those are sworn officers.
Correct.
So it is a different category. And that's a great question. I should check that out too. The way it's written, I don't think it's so much school resource officers. I think that's a different pool of workers.
Okay. It's just a thought on this whole issue, and I think it's a great idea. I'm glad to hear your testimony, and I'm pleased to see that literally we have municipal leaders and we have organized labor both behind this, and I'm glad to see that.
Thank you.
Thank you, Brian. Thank you, Mr. Chair.
Thank you, Representative Delnicki. Are there other questions? Other questions? Seeing none, Brian, one quick question. This would be any retired officer, not those necessarily school resource officers, but police officers with police officer experience. Am I correct?
Correct.
Right. Which, with the changes that we've seen across America in the last few weeks, the last few months, I would, as a parent, I know if I had children in a school system, I would want that kind of protection because it is not predictable. And if you have people that know the system, know how it works, know how to protect others, there's a lot of good parts of this bill. And so thank you for testifying.
Thanks, Senator.
Anyone else? Seeing none, thank you, Brian.
Thanks. Have a good weekend, folks.
You too. Luis Perez. I don't see Luis has not come on yet. Terrence Hart. Eric Hamelin.
Right. Thank you, Senator Casano, Representative McCarthy-Vahey, and distinguished members of the Planning and Development Committee. Appreciate the opportunity to speak today in opposition to Senate Bill 131. My name is Terry Hart, and I'm the General Counsel of the Association of American Publishers, or AAP. AAP is the National Trade Association for book, journal, and education publishers in the U.S. SB 131 would undermine the long-established and uniform legal federal framework enacted by Congress to govern the distribution of copyrighted works, such as those published by our members. Federal copyright law clearly prohibits this type of regulation of copyrights by state governments. New York Governor Hochul vetoed a virtually identical bill in December because, as she concluded, the provisions of this bill are preempted by federal copyright law. AAP was joined by dozens of creative industry organizations representing tens of thousands of creators from film, music, video games, and photography in opposing that bill. More recently, a federal district court in Maryland blocked enforcement of similar legislation in that state. The court held that it is clear from the text and history of the Copyright Act that the balance of rights and exceptions is decided by Congress alone. But even if Connecticut were not federally preempted from enacting this legislation, the bill is unjustified. Most publishers, including our largest members, already make their full digital catalogs available for library lending. They 100% support libraries and want them to succeed. And library ebook lending is thriving. Overdrive reported that in 2021, libraries achieved all-time records in circulation while lowering the average cost per title borrowed. The federal court in Maryland agreed that forcing publishers to offer licenses to libraries on government-mandated terms would not increase access to those products for library users over time. And I quote, "It's only through the protection of copyright that books and other creative works may be generated and distributed at all." Bill supporters point to the difference between ebook prices for libraries and other customers as unfair or discriminatory, but this is an apples to oranges comparison. Ebooks are licensed to a single customer for personal use. Library licenses are used by multiple library patrons over the course of the license. Indeed, if you calculate the cost of the license on a per reader basis, the library license is far cheaper than the single customer license. AAP appreciates that SB 131 recognizes the importance of public libraries as a marketplace for ebooks, and we wholeheartedly agree. But at the same time, publishers must ensure that they are able to sustain their ability to create and disseminate the books that line libraries' shelves while protecting the rights and interests of authors. And they must balance the important library market with other important markets, such as independent bookstores. AAP is happy to support public libraries. Thank you. We're happy to support public libraries and digital lending in ways that do not violate federal law or undermine authors and publishers, but we cannot support a bill that does both. We therefore respectfully urge this committee to reject SB 131. I thank you for your time.
Thank you for your testimony. I think there may be several questions. As you probably know, several have already testified earlier. As somebody that's grown up using a public library, and my children using a public library, I think it's been one of the greatest resources in America since we've been a country. I was astounded to hear some of the differences in costs, and I know that probably the technology, it costs a little more to produce the product, but it seems that if I'm somewhat wealthy, I can go and I can buy these anytime, but most of the people in my town and here in Manchester, Connecticut, don't have that wealth. And so they go to the library and they probably can't get ebooks because they can't pay those kinds of costs. And that's what this bill seems to be about. And so how do we define this price differential? Why is it so expensive? And it's hurting our libraries, and it's hurting our libraries in a different way. If they were available to people who could afford, a lot more ebooks would go out and a lot more would be produced. But if they can't afford it, then what are we doing? So that's a pretty broad question, and I'll throw it at you. Thanks.
Thank you, Senator. And yes, let me preface this by saying, I absolutely love and support libraries too on a personal level. My sister is a librarian, so it runs in the family, and definitely grew up understanding the importance of the libraries. Going to your question about the price differential, I mean, I think, we have to unpack things a little, because one of the points that was raised was the differential between what someone like you or I going on an Amazon or some retailer would pay for an ebook, and what a library might pay for that ebook. And the difference there is explained because the library license allows lending. The ebook license that you or I would purchase is for personal use. And so the difference there just reflects the fact that the library license allows the library to lend it out to its patrons over the life of the term. And so there is going to be a different price there. But as I mentioned, if you break it down and look at it on a per read basis, the library cost is less per read than the ebook cost of someone, say, purchasing it on Amazon.
Thank you. Chair McCarthy-Vahey.
Thank you so much, Senator Cassano. And thank you, Mr. Hart, for sticking with us and for being here, because it's always important to hear other perspectives as we approach these issues. And I appreciate you, highlighting the creators, those who are allowing us, our tickets to the world, so to speak, our authors and creators and our narrators and all those who are part of that process. And I think that's important. I guess my question to you is related to what you just said. A couple questions, but I'll try and keep them limited. When the library purchases a book, a physical hardcover or paperback book, that copy may be loaned out to dozens of readers or consumers or patrons. So I don't fully understand why the model wouldn't parallel when it comes to the ebook. Can you help me to understand what's the difference?
Sure. Thank you for the question, Chairwoman McCarthy-Vahey. So the difference between how print books work with regard to libraries and how ebooks work regard to libraries comes down to just the fundamental differences and characteristics between the two formats. It's the same book, but they're different formats. Specifically with physical books, right, there's physical limitations. You have to actually have that book to read it. You have to go to the library, take it off the shelf, read it. There's other physical limitations. The books wear out, they could get lost, they could get damaged. And so the sales market that rose around books kind of reflects those physical limitations. And it works for publishers and authors and libraries, the sales model. Once you get to digital works, and especially digital transmission of works, there's some very critical distinctions there that change that. First, there is no physical friction. There are no physical limitations with digital files. You could sit down with a phone, with an e-reader, with a computer, and access that file instantaneously wherever you are, right? You don't have to go anywhere. You don't have to go to the library. That could travel anywhere in the world instantaneously. And the second key difference is that you could make unlimited number of copies instantaneously with digital files, where you can't do that with physical books. And every one of those copies is going to be identical to the original. So there's no distinction between a used digital file and a new digital file. There's really no way to understand how that concept carries over into the digital space, right? There's no, a used digital file is the same as the original. And so those are very critical distinctions. And without the ability of publishers to be able to put on reasonable and appropriate limitations through licensing that allows them to reflect the use of those files, it would be very difficult, if not impossible, to support digital commerce with creative works, not just books, any type of creative works. So that licensing framework is critical to making digital commerce work. And within that licensing framework, I think publishers work really hard to be responsive to libraries to meet their needs at price points, licensing options, different multiple options, so they could choose the ones that best fit their local needs. And they continue to speak with their library partners and continue to re-examine their licensing models.
So I think what I'm thinking about a little bit here is depreciation in a sense, right? A book over time the value may go down and it may not be as usable. Maybe there's a new purchase, whereas a digital file, that value stays the same over time. I guess second question, and I'll limit myself, though I'm tempted to ask many more, but I see others have questions. If I am an individual here at my house and I choose to purchase an ebook or an audio file or book, it belongs to me. And why is that not the same for the libraries?
Well, again, in both cases, the digital file would be licensed. So you couldn't, for example, if you bought that personally with that digital book, you couldn't start lending that out to other people or selling copies of that, because you're creating new copies of that work. Whereas with a book, right, when you sell it, you're not creating a new copy. It's that same copy. And so the first sale doctrine exhausts the copyright owner's right to a particular copy, but it doesn't exhaust the rights of reproduction of digital copies, which is what is implicated if you're transmitting digital files. So I don't know if that answers your question or just kind of makes more confusion, but the fact is that Congress has looked at this question of how first sale operates in the digital environment many times over the last 2, even 3 decades. And they recognize, there are issues that arise. There is, a different perception in how things work in the digital environment, but really it's so critical to the digital economy and to making sure that copyright continues to be protected and that companies and authors and publishers are able to participate in the digital economy. It's really critical that the first sale doctrine operates this way and that digital transmissions are primarily exploited through licensing.
Well, thank you very much for your answers. I see that your contact information is also within your written testimony, and I appreciate that. Thank you, Mr. Chair.
Thank you. Representative Winkler and then Senator Wong.
Senator Wong was first.
Go ahead, Mr. Winkler.
I was giving him a rest.
Okay. One question. There's certainly ways to prevent digital files from being copied. And I was curious whether your industry avoided that kind of software in order to be able to charge the charges with the justification you just gave us.
So Representative, my understanding is that the every publisher uses technological protection measures on digital files that restrict the ability to engage in unauthorized copying or unauthorized distribution. So I'm not quite sure if I understood your question.
Well, I thought I heard you say they could make unlimited copies.
Yeah, in practice, without technological protection measures, without licensing in place, as a practical matter, yes, you can copy any digital file an unlimited amount of time. So certainly, technological protection measures play a role, and licensing also provides the framework that enables publishers to sustain their businesses and get a return on the investment they put in.
So it sounded to me you were using the fact that people could copy the books as a reason for the differential in pricing. But since the books are protected, that wouldn't be a reason for the differential in pricing. Is that correct?
That's part of it. I want to be clear that, once we get into the digital environment, there's a lot of factors that go into pricing. And, publishers have to balance all sorts of factors. And certainly looking at the potential audience for any particular license is one of the factors that go into how much a license may be offered for in the market.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Wakely. Senator Wong.
Thank you, Mr. Chair, and I appreciate the rest. It's good to have you present, as mentioned earlier, to get all the perspectives in a 360 review. And I think it's really important to emphasize the balance in regards to protecting our artists' copyrights, business models of profit and loss. I understand it's a business and it's important. But you cited something that kind of raised a question to me. You talked about books and the cost differential that we've seen. We've heard from testimony that's been consistent that a book that they would be buying, let's just use Mr. James Patterson as an example, that they would buy it from many multiple sources, but they would buy through a consortium purchase group of about $12, $15 a book, okay? And we're also hearing that the same material that is digital, electronic, that has a 24-month restriction period and a limitation of your codes to limit access at 20 subscriptions or 10 subscriptions, kind of counters what you just said about physical limitation and the limitation. You have software coding that restricts a library's ability to mass distribute, to mass go on material. But also tell me why the cost differential from library to library between digital. You didn't answer that question earlier. Tell me why the justification for the price variance for digital versus real books to our libraries in your business model.
Sure. Thank you for the question, Senator Wang. And going back to your original point about hearing balanced perspectives, I'm happy to provide mine. And I just want to note that I think there would be benefit to hearing from the other stakeholders here. I know a number of the library witnesses mentioned the digital aggregators like Overdrive and Hoopla, who are part of this system, but as far as I'm aware, they haven't been present at this year. So I think their perspective would be valuable too, as well as the individual authors. I mean, my publishers, they hold their authors in very high esteem, but certainly hearing from them directly, I think would be beneficial. But, to get back to your question, I know there is, at least in our minds, it's easy to make that comparison between the print book and the digital book. And I think a lot of publishers do, and I can't speak specifically about any individual publisher, but I do think they at least try to approximate, the pricing between a print book and an ebook. But at the end of the day, I mean, these are different products essentially, right? It's the same story, it's the same book, but there are differences between the experience of reading a physical book and the experience of reading a digital book. And so there's different marketing strategies, there's different demand, there's different consumption patterns. And so these are kind of the factors that go into the publishers when they're determining, overall, how best do we recoup our investment in this story across physical channels, across digital channels, across audiobook channels, the whole sweat. They have to balance that together. They have to look at all the various markets that are in there and try to achieve that balance so that they're able to recoup the risk and the investment that went into that. It's I don't think that's an easy decision to make, and there's certainly with digital it's always changing. I mean, I think 10 years ago, people thought, everyone would be reading ebooks by now and physical books would be obsolete. Well, that hasn't happened, right? Physical books are still a very popular format, and that will continue to change, and publishers always have to recalibrate those decisions.
Thank you, Mr. Hart, but you didn't answer the question that I had in the rationale why your publishers have such a vast difference in regards to a digital book that can be easily replicated. I know you may have to hire a voice actor or to be able to interpret, but the reality is you're not publishing on paper, you're not replicating binding, you're not looking at physical movement or adjustments to it. You didn't explain to me why the pricing rationale, or even a broad answer to that. You didn't give that to me. Could you perhaps explain the rationale between $12 for a book versus $55 for a digital one-time file that you as a publisher can code and control?
Sure. So, the value of a book, the price of a book, very little of that is the actual paper, right? Paper is cheap. If you want paper, you could go to Staples and buy paper. That's not what we value. We value the words on the paper. That's what publishers are offering, whether it's through paperback books, through hardcover books, through digital books. And so, you can't just look at, oh, well, a digital file, it probably doesn't cost that much to copy, whereas, a book, it costs this much to buy. And that's not really the majority of where the value is in that. And so if you're looking at, how much do our consumers value these works in different formats, that's kind of where you have to make those decisions, right? So
well, I appreciate that viewpoint, but I actually was listening to you intently when you talked about the physical limitations of books and the challenge and versus the unlimited of digital. It just seems to be kind of just my read of it inconsistent. But let me make a quick change, and I respect other people's times. I'm not a tech person, but let's talk about Spotify. You've got performing artists and music. You pay a premium, you get that licensure, you get to use the product. Lord knows I probably listened to a song 20 times, but I pay a set fee and the artists are reimbursed. How is that model different from me actually purchasing an album and paying a premium of $22 versus paying Spotify, which could be kind of used as a model, my library, that would be able to use this technology and be able to support the artist, learn the nuances of it. Educate me on how much difference it is from a Spotify system that the consumer can relate to, that you pay one set fee and be able to use the product and the artist still reap the rewards of their creative talents.
Well, let's say, how much time do you have? I'm happy to.
Well, maybe it's a second part of that conversation, maybe a little bit more on that conversation. But I do also want to leave with you from my research and work that the state of Connecticut in 2014 actually set up an ecosystem, which is a state-managed electronic book system in addition to Overdrive and Hoopla. And perhaps that may be a different model where the state of Connecticut takes a look at being a a vendor purchaser of a group, kind of a larger group, and to be able to disseminate. But again, we're opening this opportunity to have further conversations. The current model bears some inconsistencies with open markets. And what we're looking at is to really just bring some equity into this so our libraries can provide other important resources. The last thing I want to ask you, you did cite the proceedings in Maryland where the Supreme Court made that decision. But let me get the clarification from you. The court made no determination on the merits of that case in regards to pricing, in regards to discrepancies in the cost between books and digital costs. The court rejected the injunction in the sense that they clearly said it was a federal jurisdiction. They made no commentary in regards to the question we're trying to raise right now. That is, it is not an open market, and there are tremendous inconsistencies in pricing in this. Would that be correct? Unless you may know better, and that is a difference of the court's decision.
Our motion for the preliminary injunction which the court granted, preventing the state from enforcing the law, was solely on federal preemption. Just across the board, the court found that Maryland had no room to enact that legislation, given the federal copyright law and Congress's clear intent. We brought several other claims in that case, which had not been part of the preliminary injunction, and resolution on those are still pending.
So the case that's being referred to by you and others that are advocating and opposing this had no bearance in regards to looking at the, in my words, uneven application of cost in regards to print books and digital books. It had no bearing and no part in the rejection of that case. It is purely a jurisdictional decision. You may have other cases, but in the case that you're going to cite often, it had no impact on reviewing the important question we're asking right now, is the true inconsistency and the modeling of pricing between physical books and electronic books, which is what we're striving to. And I will end by saying this. I think we can all reach a midpoint where everybody can benefit. I believe in a free market system. I believe in protecting our copyrights, but I also believe in a fairness system, particularly when we're not looking at a for-profit entity. We're looking at our libraries that is providing information and resource. And when I hear a story about New Haven, that they wanted to provide a system for a community that is craving for information and knowledge, had to shut it down because there was too much utilization because of a cost issue. So again, I appreciate the indulgence of the chair, but it is a topic worthy of conversation. And I hope that your organization and many of the others will be a part of that solution in bringing fairness and social equity access to our libraries and our communities. Thank you, Mr. Chair.
Thank you, sir. Representative Zawistowski.
Thank you, Mr. Chairman. Mr. Hart, I have a question for you regarding ownership of a book. If I download purchase an ebook, do I actually own that?
Well, it depends on kind of what the owner of that copyrighted work is offering. Generally speaking, for any digital works, there's a license involved rather than ownership. But I would kind of, flesh out a little bit more, because it's a digital work. The first sale doctrine, which is what allows you to sell used books and libraries to lend out books, it only exhausts the distribution rights. So even if you would own a digital copy of a work, that still doesn't mean that you're able to engage in reproduction or public performance or any of the other copyrighted works. You would, under first sale, you would still have rights to redistribute that discrete copy of that work. But once you start, transmitting it digitally, you're creating new copies. And so that's kind of where the limitations of the first sale doctrine in the digital space kind of manifest themselves.
Okay, so you don't, when you download a book, and pay money for it, you don't actually own it because you can't dispose of it. And you don't, you can let, I guess, other people borrow your e-reader or something like that, but you can't dispose of it. So you don't really own it. I'm just trying to figure out the ownership model on these ebooks. Because I know we've all heard stories about Amazon taking back their book, some of their ebooks after a period of time. So if you had a hard copy, I mean, you could do whatever you wanted with it. You could, let people borrow it. You could dispose of it. Anything else. So that's really the difference in the models. I'm just trying to, I don't understand the appeal of ebooks, but that's, other than the fact that they're supremely portable. And people like to read them on airplanes. But if you don't actually own them, I mean, it's not like you put them in a library or anything, your own personal library. And if a library does purchase an ebook, they said they have limitations on how many copies they have. That's correct. Yes.
As of now, I'm not aware that any of my members limit the number of copies that a library could purchase. I think that's solely a factor of their budget.
I misspoke. I meant the number of times that they could let somebody borrow it.
Correct. So there's a number of different models, and each publisher is different in which ones they offer. Just generally speaking, there's models based on a number of checkouts. So maybe 25 checkouts is what the library purchases. There are other models based on a time length. So they could lend it out as much as they want within, say, 2 years.
Okay.
But there's other models as well.
They would never own it. So they would never own it.
Correct.
It's just, it's a rental model, basically. So, okay. Thank you very much.
Thank you.
Thank you, Mr. Chairman.
Thank you. Representative Smith.
Thank you, Mr. Chair. I think my questions follow along the same line that Representative Zalewski was getting at. Mr. Hart, in 1989, my father passed away, and I inherited several hundred of his books. Physical copies, some of them 100 years old, various states of disrepair, condition, etc., but physical books. If he would have died a year ago, I think if I'm hearing this correctly, I would have inherited 0 books because they would have all been licensed to him personally and they would not have been transferable. Is that correct?
Generally speaking, and I want to be clear that this is copyright writ large. This is how it works. This isn't something publishers sat down and decided this is how it works. This is how Congress has determined it to work. Generally speaking, if you have the files on a device, you should still be able, you still have possession of those files, right? Regardless if they're licensed or not. I'm aware that many companies do try to address that issue because it has, it is something that has come up over the past decade or even more about, what happens to these digital files when someone passes along, can they inherit them or not? I think some companies allow kind of, someone to take over quote unquote custody of those files. But yeah, it is going to be different than the straightforward kind of physical model where, if there's a book there, you could, once you own it, you could give it away, you could put it in a closet, you could, do whatever, you could cut it up and use it for firewood or whatever, you could do whatever else. So there's trade-offs between, the physical books and the ebooks.
Right, but I couldn't I couldn't give it to a library that they could then lend out. Correct. If I may, I'd like to ask you just one other question. How does it work for schools with ebooks? Do they have similar limitations on the way a school book can be shared, or books in a school library, how they can be distributed among students?
So again, I could only speak very generally about how that works. I don't know, as a trade association, we can't get involved in discussions about specific terms and pricing. But There are different aggregators that work with the school markets, and there are different licensing terms that are offered that better fit, the needs of school districts rather than, say, public libraries, right? Obviously, if you assign a class book, you're going to need 20, 30 kids to be able to read that simultaneously. That's different from a library, which may be fine with, we just want to lend this out one at a time for 2 weeks. So the licensing models reflect that. And as I'm generally aware that there are, different models depending on how different teachers or different schools want to be able to use certain books, whether it's per class or school-wide or just a school library within the school acting in the same fashion as a public library.
Okay, so there are definitely other ways of doing electronic distributions. All right, well, thank you for that. I appreciate it. Thank you, Mr. Chair.
Thank you. I see no other hands. Is there anyone else with questions? Is there not? Terrence, thank you very much for being with us and trying to help us clarify this. Truly appreciated.
Thank you, Senator.
All right, I want to go back. Thomas Reagan Lefebvre. I just want to check and see if he was on here. Eric Hamlin, I see is here, and then it's Johnny Hamsey, Ben Shaklin, and Carrie Fenton.
Good afternoon, honorable members of the Planning and Development Committee. My name is Eric Hammerling, and I'm the Executive Director of the Connecticut Forest and Park Association. I'm here today to thank the committee for raising SB 129 and express support for the tool this legislation would provide for communities who wish to use it to help ensure long-term compatible public access to state-designated greenways. Recreational trails are the heart of Connecticut's outdoor recreation economy, which generated $3.3 billion in direct revenues and supported over 41,000 private sector jobs in 2020. At the community level, recreational trails provide a wide range of socioeconomic, mental and physical health, wildlife, and other community benefits. State-designated greenways are a special category of trails that often stretch across a patchwork of private, municipal, and state-owned lands. Private landowner hosts are critical to keep trail corridors unbroken, but in most instances, these lands are also the most vulnerable to disruption if there's no long-term incentive in place for protecting the trail corridor as properties are developed or subdivided over time. SB 129 would enable the abatement of property taxes for private landowners under certain limited conditions. A municipality must first pass a local ordinance allowing an abatement. A landowner must place a permanent conservation restriction on the trail corridor on their property. The width of the trail corridor would be limited to 100 feet, which must be surveyed at landowner expense. And this trail corridor must also be a state-designated greenway. We expect that the cost to most communities that may use this tax abatement would be relatively minor, given the relatively limited circumstances under which it could be used, especially when compared to the significant economic and other benefits to the community of ensuring long-term access to greenways of statewide significance. Placing a conservation easement on a property typically reduces the value of a property by 2/3 to 3/4 because it removes the developable value of the land. Under that scenario, this bill would then enable the municipality to abate the property tax on a trail corridor, meeting the criteria that I mentioned, by the remaining 1/3 to 1/4 of the value of that trail corridor. I'll quickly add that we have had conversations with COST and CCM, reviewed their testimony, and I appreciated Betsy Guerra's comments earlier about continuing to work on an incentive that works for us and for the towns that would benefit from long-term protection of trail corridors. Thanks again to the committee, both for your support and for your stamina today.
Hey, Eric, thank you for your testimony. Any questions for Eric at all? Madam Chair, Representative McCarthy-Vahey.
Thank you, Mr. Chair. I just wanted to say thank you, Eric. You actually answered my questions in your testimony, so thank you so much.
Thank you.
Any other comments? We're letting you off early.
Appreciate it.
Thank you.
Good night.
Good night. Okay. Got a couple here in waiting. Donna Hamsey, is Donna right here yet? I think, yes, I see you. Yeah.
Good evening, members of the Planning and Development Committee, Senator Cassano, Representative McCarthy-Vahey, Senator Long, and Representative Zullo. I'm happy to be before you this evening for the first time this year. So I appreciate all of you being here for as long as we have been today. So I won't, I'll be brief in my comments and certainly happy to answer any questions. You've all seen my submitted testimony, so I'll just summarize briefly. To the point of House Bill 5168 regarding group homes, I think we've made our position very clear over the years. There is just a disagreement on the way we read the statute as it's changed by this bill. And additionally, in this particular version, awarding legal fees is something we disagree with and just feel that it just creates an undue burden on the system and creates some inequities within the system that we've provided some feedback to in our comments. The other bill I'd like to just briefly touch on is House Bill 5169. There's a lot of information in that bill. It's the OPM bill. The one section or two sections I'd like to call your attention to are sections 11 and 12, where they speak to contingency fee arrangements. You all are familiar with our position on contingency fee arrangements. The conversations were had earlier this morning between Mayor Luke Bronin and Representative Dubitsky, and we just wanted to follow up by saying, Senator Cassano, that we would be happy to participate in any meetings after this public hearing to discuss that issue, because it is one that's very important to us and our members.
Thank you.
A couple of final comments. Senate Bill 128 regarding the foreclosure and liens. The bill as it currently stands, we do not support. However, I did want to just bring everyone's attention back to last year's bill, Senate Bill 968, and the amendment by Senate A that changed the language from prohibiting liens unless they exceed $4,000 or 4 years. That was actually a change that actually changed the tax collector's position on the bill, and they, in fact, ended up supporting it with that change. And I think we would be willing to support them in that support if that change was reflected in this year's current bill. But we did also offer language that suggests a working group around this issue. So we would take either of those options, but we just simply can't support the language as it currently is written. And then the last issue I'll bring up is the bill that Eric just discussed, Senate Bill 129. We have had conversations with Eric and his organization offline, and certainly are very sensitive to his and other entities who come before all of you every year to talk about property tax exemptions. And while we certainly don't begrudge Eric or any of the organizations for the mission or purpose or intent of them bringing those to our attention, we just worry that as they compound themselves, currently there are 99.
Your time is almost up.
Thank you. And there are over almost 1,000 unfunded mandates on the books. So as we think about each individual exemption, we really need to look at it holistically and think about them all in the aggregate and how they affect the very regressive property tax system in our state. So I'll end there and I'll happy to take questions.
Thank you. Are there questions? No questions?
I'm going to get off easy today. Bye.
Back when I was the president of CCM, we had rules and regulations that you had to ask lots of times. We're letting you off easy today, Donna. It must be the end of the day. Thank you. We're not unhappy. Thank you.
Okay, good evening.
And there's Ben. Ben shaking his on deck. Ben.
Hi, good afternoon, Senator Cassano, members of the committee. Thank you for having me today. It's been a very interesting hearing. I'm here today to support House Bill 5168 and that concerning property tax exemptions for property used for charitable purposes. We have also submitted written testimony on a number of bills supporting Senate Bill 126 with concerns regarding Senate Bill 130 and with comments regarding Senate Bill 127 and House Bill 5169. I need to focus my spoken testimony today on 5168. First, I want to thank the members of this committee who unanimously supported House Bill 6103 last year and look forward to working again on this proposal this year. Nonprofits are explicitly exempt from federal, state, and local taxes for a good reason. They provide essential services to Connecticut residents so that government doesn't have to. I'm here now for the fourth year trying to resolve this issue. And thankfully, as you heard earlier, since last year, there has been a unanimous state Supreme Court ruling affirming what the Alliance and our members have been arguing for years, that residential programs operated by charitable organizations are exempt from property taxes in Connecticut. Some assessors have contended in public hearings and in arguments in court that that exemption denials and are warranted as soon as the average length of stay of a resident in one of these settings is longer than 6 months, and I believe the CCM's testimony says as much, or some other durational limit that they determine within their discretion. And as Attorney Hollister mentioned earlier, the state Supreme Court has explicitly rejected this argument and said that the statute means different. Unfortunately, however, that ruling hasn't changed the facts on the ground entirely. And so we recently analyzed almost 300 nonprofit properties across Connecticut and found 44 continuing exemption denials across 23 towns, mostly residential programs, including at least 7 new denials this year. The changes proposed to this exemption and statute are needed and are still needed, and they'll clear up any ambiguity about the legislature's intent. Our recent analysis also, interestingly, shows that while these denials are certainly widespread, they don't represent the majority of assessors. In fact, 114 properties in 54 towns have had their exemptions approved. And in addition, 146 properties, almost half, have received no determination whatsoever. And we hear from nonprofits that this is common. So that's why the process changes that are dealt with primarily in sections 1 and 2 of the bill are needed. Be happy to explain those in the Q&A. We're hopeful these provisions will eliminate the disagreement that exists today amongst assessors around what the law means. And then in addition, you heard from someone earlier who had spent more than $100,000 on legal fees, Mr. Osborne. He's not alone. And for a municipality, the only downside to aggressively litigating these cases, even when denials have been issued on shaky legal grounds, is that if they ultimately lose, they no longer collect the tax. But for a nonprofit, they're out tens of thousands, sometimes hundreds of thousands of dollars. And that's why we support Section 3, which would, in a very small minority of cases where charitable property has been denied, and that denial could not have been reached except by an assessor ignoring the law, that a judge would be allowed to award attorney's fees. We understand this is controversial, but we have struggled to come up with a solution short of this measure to disincentivize the vexatious denials of tax exemptions that are happening. Finally, just to address an earlier testimony, Attorney Casagrande, way earlier today, made an argument that exemption is in the interest of the state and is consistent with that the work that these nonprofits do is consistent with government function. And I just want to point out, we agree, but so does the state of, okay, thank you. So does the state of Connecticut. The Attorney General William Tong and the Solicitor General Claire Kindle filed an amicus brief in the state Supreme Court case, which is attached as an addendum to my testimony. And if you read it, it very clearly makes that argument on behalf of the state itself, that these nonprofits are, that their exemption is in the interest of the state and is consistent with government function. So thank you very much for your time. I hope I haven't completely taken up past my 3 minutes, and I'm happy to entertain any questions.
You owe us 30 seconds, you owe us. Any questions of Ben? Representative Bisky.
Thank you, Mr. Chairman. And thank you for coming in to discuss these bills. One of the things that I've heard my municipalities have a particular problem with is when the nonprofits have a property that's used for nonprofit purposes, but then they also use it for essentially competing against local businesses who provide similar services. How would you address something like that when a assessor says, okay, you're using the property for nonprofit purposes, therefore it's tax exempt, except the part that's being used essentially for business purposes? How would you address that in this bill?
Thanks, Representative, for the question. And and for your work on this issue over the years. I know we worked together on this issue in the very first year. I think we came before the legislature with this problem. So the current state law exempts property that is owned by a corporation exclusively organized exclusively for charitable purposes. And you are correct that if a nonprofit owns a property, I'll give an example of an office building. And so they own a 4-story office building with 4 units in it, 4 office units, and maybe they occupy 3 of them. And the use of the place that they occupy is their charitable purpose, that they're running their operations, they're delivering a program, whatever that may be, and then they rent the 4th unit, that they are required to pay property taxes on any portion of the property that is not being used for the charitable purpose. So it's not enough that the property is owned by a nonprofit corporation organized for charitable purposes. The property itself must be used in furtherance of those charitable purposes. And so it is sometimes the case that a nonprofit may own a piece of property where an organization or even themselves are engaged in a non-charitable purpose in part of the property, and for that portion they are assessed and rightly pay property taxes.
Okay, well, let me give you a scenario in my district. In the town of Hampton, EastCon has essentially a training facility, which is used for, which is a charitable, EastCon's charitable organization, uses their property for nonprofit purposes. But they also own now a fleet of buses that they use to essentially, they compete against local bus companies and store the buses on the property. I know there's been a lot of back and forth about that, but I'm just trying to find out if there's anything the legislature should be doing about this situation where, the EastCon actually, put a local bus company out of business because they were able to undercut them because they don't pay taxes. So should the legislature be dealing with something like that? And is this bill the appropriate place to address that issue?
Thanks. And I'm not aware of that specific situation, so let me comment a little more generally. I think one of the sort of nuances around some of the conversation today, frankly, around a different bill and this issue is that it is certainly possible for an organization that is not a nonprofit corporation to deliver services as a business that are similar to what nonprofits deliver. So there's been a lot of conversation today, for example, about residential substance abuse treatment facilities on a different bill. And the company in question there is a for-profit entity delivering very similar services for a profit that other nonprofit organizations provide. In the statutes right now, if what the organization is doing is charitable, so in this case, I'm surmising that the purpose of operating a bus service for school districts has been deemed a charitable purpose, and the organization itself is a charitable corporation, then they are entitled under statute to a tax exemption. Regardless of the fact that a for-profit company could form itself and start a bus company and try to provide those services as well. So to answer your question of whether this bill would be a proper place to address this, I think this bill is more specific to the tax assessment process and to this specific issue also regarding residential programs that the state Supreme Court has recently decided. But I'd welcome the opportunity to have a more detailed conversation around the issue that you've identified, because I think it's certainly an issue that we would have an opinion about, but I can't give you exactly what that opinion would be until we have a bill to look at in language to see.
Okay, well, I appreciate your answer on that. One more avenue of inquiry, and you and I had discussed this in years past about attorney's fees. And I'm looking at 5168 and at line 30, it says that the court, well, actually, at 28, the court shall have the power to grant such relief upon such terms and in such manner and form as justice and equity appertains, and costs and attorney's fees may be taxed at the discretion of the court. The rest of this paragraph essentially mirrors what's in subsection A, except that attorney's fees has been added. And I'm wondering, at this point, is it necessary to even have that in there? Because there have been some recent court decisions that have addressed what it means to have the power to grant such relief and upon such terms and such manner and form as justice and equity appertains. And some court decisions have found that that includes attorney's fees. So it would include it in A and B. So is there really a need for it to be in line 130 if it's already in lines 128 and 129?
It's a good question, and I admit, although I play one really well on TV, I'm not an attorney, and so I'm not familiar with the recent case law around that you just mentioned around the awarding of attorney's fees. Let me explain a little bit about, I think, why this language that becomes subsection B has been added, and it has to do more with I think the desire to compromise, if you will, with the position of the municipalities that attorney's fees are something that they're very uninterested in. And subsection B proposes to explicitly allow a judge to award them. A judge, I imagine, could always award them, but explicitly allows a judge to award them only in denials that have been issued pursuant to subsection 7 of section 1281, which is the charitable exemption in statute. And so if you are making an appeal under 12119 for a property that should be exempt under a different subsection, that subsection of 1281, that subsection B of section 3 of this bill would not be applicable. We think a narrow approach is a way to address the issue that we care about as the Nonprofit Alliance, and that we are seeing, which is that our members who do not have legal resources to fight these cases are nevertheless being forced to fight them. And so this would allow, if they were victorious, them to at least have their costs reimbursed.
Understood. Okay. Well, I appreciate where you're going with this. And we can talk about this offline, but I don't think B is necessary because it is now incorporated into A based on a couple of court decisions. And frankly, it's been the case over the years. It just has never been explicit. And my concern would be that by now adding B and having attorney's fees called out specifically, then it would be interpreted as excluding it from A, whereas currently under Connecticut law, it's in A. So, we can talk about the language later on, but that's my concern, is that if you adopt essentially all of the language in B as it is in A and add attorney's fees, it will be interpreted by the courts as not being in A, and the courts have already interpreted A as having attorney's fees. So we can discuss this later, but I just wanted to, bring out that point and, see if you had any comment on that.
Thank you. That's helpful feedback.
Right. And thank you, Mr. Chairman. Thank you, Mr. Chairman.
Well, thank you, Representative Brzezinski.
Mr. Chairman.
Thank you. So thank you, Mr. Shaken, for being here. You mentioned a number of other bills, and I missed the list at the beginning. I know you have submitted testimony, but can you just run through that just briefly, which other bills?
Sure. We have submitted testimony in support of Senate Bill 126, which is the bill regarding a study for the handicap accessibility of the state legislative office building in the state capitol. Just very briefly, we are one of the advocacy groups that in normal times when we are in person and not sitting on Zoom, takes a lot of pride in how much effort we bring and we put forward in bringing people with disabilities to the Legislative Office Building and to the Capitol to speak with all of you as their representatives. And it is very true that both buildings were built prior to the ADA, the Capitol very, very long prior. And so people with disabilities have trouble accessing the space in a variety of ways. We also testified with comments on Senate Bill 127, which has to do with the Neighborhood Assistance Act, just making sure that the efforts in that bill are not duplicative of efforts that are already going on. And the bill that OPM was here on earlier, 5169, Section 10 of House Bill 5169 requires written notice to be given by an assessor when they issue a approval or a denial of a tax exemption, which is sort of addressed in Section 2 of the bill that we are here on, mainly of 5168. And so our comments on that bill is that we support that measure, but it doesn't go far enough, and we encourage the committee to incorporate aspects of 5168 into OPM's bill. And then finally, we have concerns around Senate Bill 130. We represent nonprofit providers who would not be covered directly by this bill, but our concern is that given how fraught the landscape is with municipalities interpreting ambiguous statutes, that it would lead to further issues and fights in municipalities, and that a court may interpret the language in it, if it's passed as drafted, in such a way that would be detrimental to nonprofits, and that we feel like the community resident statute unamended sort of already encompasses nonprofits in the or is already exclusive to nonprofits, I guess I should say, because for mental health facilities specifically, at least, it is limited to facilities already that contract with the Department of Mental Health and Addiction Services. So it's certainly a complicated issue, but we have some concerns about the language as it's been proposed.
Thank you for outlining that. No wonder I missed, because that was a lot. So I appreciate you going through that again, and I thank you very much. Thank you, Mr. Chair.
Thank you for coming in. Appreciate it. Any other questions for Ben Shakin? Seeing none, Ben, thanks again very much.
Thank
Look
you,
forward
Mr.
to
Chair.
seeing you in person again. Carrie Fenton, followed by Deborah Chandler, William Brink, and Nancy Vito. Carrie, I saw that you were here. Welcome, Carrie.
Hi, thank you very much. Good evening. My name is Carrie Fenton. I am the Director of Finance at the Chrysalis Center, and I would like to speak in support of HB 5168, property tax exemptions for the property used by charitable purposes. Chrysalis Center operates multiple affordable and supportive housing projects, serving formerly homeless individuals and families, veterans, HIV/AIDS, and mental health and addiction recovery clients throughout Connecticut. These housing projects are developed with little funding and very tight budgets. The projects would not make it through the development and bidding process if real estate taxes were factored into those proposals, as it would greatly change the per unit cost of construction and maintenance. The high real estate taxes assessed cripple these projects and render long-term and critical maintenance impossible to sustain. The real estate taxes divert critical funds away from the property upkeep, capital repairs, and client needs of vulnerable populations. Many years of budget cuts have further cut into the sustainability of these housing models. The tight margins leave no room for error, and often regular maintenance and long-term projects suffer. Vacancy rates have a huge impact on these projects as well. Our referrals come from the coordinated access networks, and those referrals can be very slow to be vetted and those units to be filled. This greatly impacts the pro forma and the performance of the properties. However, the real estate tax assessment is on 100% occupancy, which is not always the case. The property taxes continue to rise as our budgets remain flat or are cut, and the projects struggle to cover costs because of that.
Thank you for your testimony. Are there any questions? Any questions at all? You can tell it's getting near the end of the day. I appreciate you waiting so long to testify. Thank you very much for testifying.
Thank you.
That's a good sign, by the way. Carrie Fenton just spoke. Deborah Shander, excuse me.
Chandler, thank you. Good
Okay,
evening.
sorry, Deb.
That is quite all right. Good evening, members of the committee. I'm Deborah Chandler, and I'm your state librarian. I am here to speak about the ebook bill SB 131. I will refer you to my written testimony about the state library's overall policy perspective on this issue. But as I have been listening to the conversation today, I have drafted some new comments to address some of the issues and concerns that we have been talking about today. So one, as the representative from the publishers, Terrence Hart, pointed out, the existing bill language of SB 131 is substantially similar to other bills which are seeing pushback and challenges with respect to copyright law and federal preemption. By requiring publishers to sell to libraries, and by using phrases like reasonable terms, they have been difficult to define, and we are likely going to face the same response if we go forward with the language as written. That does not mean that we do not have options. There is already model legislation that reframes this issue, and it focuses the matter on contract law and a state's right to ensure that contracts, like the licenses that we have been talking about today, are not unfair or discriminatory. So rather than requiring that publishers offer those licenses to libraries, it says if you offer them, they must meet these contract standards set by the state. This legislation was written by contract and drafting experts, lawyers, scholars, and others. I would be happy to share that model language with the committee, and I would also be happy to put you and LCO in contact with the drafters if you'd like to talk about that option. As Senator Wong pointed out earlier, the preliminary injunction in the Maryland case was not on the underlying issues. It was only on the federal preemption question. And I personally remain wholly unconvinced by the arguments that we heard today, and which I found to be contradictory of each other. So I would encourage you to continue digging into those questions, because as it currently stands, and as you've heard, the relationship between libraries and publishers on electronic books is too unbalanced. Last, as you've already heard, the state library has its EGO platform. This is developed in response to previous action on this. And since 2015, we have been developing that program. With additional funding, we could continue to develop it. We could expand the resources that we are already providing. Now, I want to say that that does not get us past the cost issues, because we pay the same rates that school libraries, public libraries, academic libraries are paying for that content, but we at least would have the statewide reach and would be able to provide some more immediate relief to our public libraries, our academic libraries, and others. There is also the option to provide direct funds to municipal libraries through incentive grants which support their operations. Connecticut defunded that program in 2016, but the statute is still on the books, and so it is an available option. So with that, I'm going to say thank you for raising the bill. I hope that my comments have triggered some questions and comment, and I would be happy to answer your questions.
Representative McCarthy-Vahey, Madam Chair.
Thank you, Mr. Chair. And Ms. Chandler, thank you so much for your work and for staying to testify. Yes, please, if you would be willing to share that language. I think it is important to try and come at the issue in a way that we can be most successful in addressing it. And it's we're hearing pretty clearly that there will be pushback in some of those areas. So I look forward to working with Senator Wong and with you, and maybe through the clerk, we can connect and get the information to everybody.
Yes, we'll do.
Thank you. Thank you, Mr. Chair.
Yes, let me ask one question here. I'm just thinking out loud. Working at the state library, we have the local libraries and so on. We have university libraries. Would it make sense at all to try to put together a cooperative of some type where we had one purchase and it was distributed through all? I mean, or is it just too broad? Or, I mean, is it even a possibility to look at somehow combining to cut costs.
I think that was the idea of the Ego platform. There was a study back in 2013 looking at this issue. It led to bond funding and the development of the program. So yes, we could continue to develop that. We could provide those materials. As Brad testified earlier today, we have been focusing on backlists, so older items and items for K-12 schools, because we often are not able to provide, meet the needs of libraries who are wanting those popular items, the James Pattersons, the Stephen Kings, the Janet Ivanovich, all of those books that libraries are wanting to provide to their patrons very quickly. But yes, we could continue to develop that. But like I said, I would also say, and that would be through the Connecticut Digital Library line, which is an appropriation to us. But I would also say, again, we would continue to face the same costs. So we would be able to have a broader access to people, but we would still be paying the same costs to purchase those licenses. And we would be dealing with the same matters about the various models, items disappearing after a certain period of time. So I would love to see an approach that does both, that extends what Connecticut does in terms of state provision, but also continues to address the underlying issues that led to the development of that program to begin with, because we continue to face these costs from publishers.
Thank you. Something we should think about. Any other questions? Any members of the committee? Seeing none, Deborah, thank you very much.
Thank you.
William Brink, Nancy Vito.
Bill Brink's here.
Oh, Bill Brink is here. Okay, there we go. Hey, Bill.
Sorry about that.
Welcome.
Wasn't quick enough logging in. Well, thank you, Mr. Chairman. Thank you, distinguished members of the committee. My name's William Brink. I'm Executive Director of the Water Pollution Control Authority for the City of Stamford. I'm also here representing the Connecticut Association of WPCAs, which represents over 150 WPCAs in the state. I'm here to provide testimony in opposition to proposed Senate Bill 128. Now, this has been discussed previously, so I'll just try and keep my remarks brief and just get to the heart of the matter, which is that the proposals in this bill would establish a minimum threshold of $10,000 of delinquent sewer use fees or sewer assessments or connection charges before foreclosure action could be taken against a delinquent sewer user. As was mentioned before, this would represent, and it's a principal amount of $10,000, would represent almost 20 years, and in Stanford's case, more than 20 years of non-payment of sewer use charges. This would be an excessively long time for us to not be able to foreclose on a delinquent sewer user, and would definitely have an impact on our revenues. Let me just say that none of our members, and certainly the city of Stamford, wants to foreclose on our property. We encourage all our users to pay on time. We offer payment plans for those that cannot make their payments on time. And so foreclosure is definitely a measure of last resort and something that we do not do very often. And I don't know of any, at least I'd like to say any, but very few of our members, and certainly not the city of Stamford, takes a property through foreclosure. So it is a measure of last resort, but it is a measure that we need to encourage users to pay. We, unlike other utilities, we cannot discontinue sewer service. It's regardless of whether they pay or not. So we do need this ability. And it's also important, it's important for people to pay on time. It helps them, it helps us. If they don't pay, other people have to pay in their place. So the example was given before, if 10% of our customers were to not pay on time, the remaining 90% have to pay through higher rates to make up for that difference. Also, I think it was mentioned that in lieu of a,
Mr. Brink, your time is almost up.
we would be amenable to a time limit in lieu of the minimum dollar threshold. I'll conclude at that and accept any, and be happy to take any questions.
Let's see. Did we lose Senator Casano? Okay. Well, thank you, Mr. Brink, for being with us today. My question is earlier during, I believe it was Donna Hamsey from CCM's testimony, she mentioned that there was an amendment last year on what was then Senate Bill 968, and that CCM would be willing to support that if others were as well. And I wondered if you would concur with that. Just curious what your opinion was on that comment.
Was that the, I was mentioned previously of a 4-year time limit? Is that
Yes, sir.
Yes, I think most of our members would accept that. For example, in Stanford, we establish a threshold of $5,000 for both principal and interest, accrued principal and interest, which would represent, over 6 years of non-payment. So 4 years would be acceptable to us, I can say. I think there should also perhaps be allowance for larger users. That 4 years could be a substantial sum. So for single family homes, certainly 4 years would be fine. But if you had a very large commercial establishment not paying sewer charges for 4 years, that could be a strain.
Okay, I appreciate you making the distinction. Thank you. Rick Michelle, I saw your hand, but I believe we lost Rep. Michelle, who I'm sure was going to thank you for your service to Stanford, I'm betting. So thank you very much, Mr. Brink, for being here with us today.
Thank you for the time and the opportunity. Thank you.
Thank you for your patience. Next, 49 is Nancy Vito, but I do not believe Nancy is here. Just double checking. And Joanne Basile. I saw Joanne. There's Joanne. Joanne, welcome. Please proceed.
Okay. Thank you. Dear distinguished members of the Joint Committee on Planning and Development and your committee chairs, I'm Joanne Basile, Executive Director of Connecticut Votes for Animals, a grassroots animal advocacy organization representing over 5,500 supporters in almost every legislative district in the state. CVA strongly supports HB 5170 and urges the committee to pass the bill. This bipartisan bill before you today will go a long way to resolving some of the unnecessary suffering experienced by dogs left outside during extreme weather conditions. It is humane for animals, reasonable for people, and helpful to animal control officers, and allows Connecticut to catch up to many of its surrounding states in providing protective measures for dogs. Due to the lack of appropriate animal laws, animal control has been unable to take the proactive action that both saves a dog in distress while educating the dog owner in better practices. Currently, animal control officers only have the state cruelty law, which criminalizes the failure to provide an animal in one's charge. As you heard earlier today from one of the animal control officer, no one wants this situation to rise to that level of action. The bill builds on the current tethering statute by adding continuous access to shelter and clarifies what makes up adequate shelter, removing much of the ambiguity which often creates problems, yet providing sufficient flexibility for animal control officers to use their best professional judgment. Lest anyone thinks this is a radical approach, I would recommend looking at how Connecticut stacks up to its surrounding states. According to the Animal Legal Defense Club, Connecticut is solo among our neighboring states in failing to provide shelter and detailed requirements for dogs. HB 5170 would bring Connecticut in line with our neighbors. Connecticut Votes for Animals believes that enactment of this bill is common sense enhancement that will mitigate against the horrific suffering inflicted on dogs, such as BJ, a dog who froze to death in a Hartford backyard, and the countless others that never make the news. 4 years ago, an almost identical bill overwhelmingly passed the House by a vote of 132 yeas with only 18 nays for reasons having nothing to do with substance. The Senate adjourned by the time the bill was brought over, and the Senate had adjourned and was never able to take it up. It was truly a tragedy with significant consequences. Connecticut Votes for Animals asks you to make up for that mistake now and move this bill forward so Connecticut will have the next necessary protections required for the humane treatment of dogs. I want to thank the entire Fairfield delegation, and I want to thank this committee for the opportunity to speak to you.
Ms. Basile, thank you so much. And I appreciate your thanks on behalf of Senator Wong, Rep. Devlin, and Rep. Leeper. I'll say thank you as well. Representative Michelle.
Yes, thank you, Madam Chair. I just wanted to also thank Ms. Basile for her amazing work and champion for animals. Thank you.
Thank you, Representative.
Thank you, Representative. Seeing no further questions or comments, we wish you a wonderful evening.
Thank you. Representative Vehi, may I just mention an animal control officer from Branford, Laura Bourbon, had hoped to be able to testify earlier today. She was scheduled but had to go to work prior to her time being taken up. I would urge the committee members to take a look at her testimony, which is now in the record.
Great, thank you for that. And yes, I would remind committee members, there's a lot of great written testimony on our committee page, as well as members of the public. Thank you, Ms. Basile. Next on our list is Andrea Curran. Ms. Curran? There you are. Welcome. Please proceed.
Thank you. Madam and Mr. Co-chairs and members of the committee, thank you for this opportunity to speak. My name is Andrea Karen. I live in Fairfield, and I am here to ask for your support of HB 5170. An almost identical bill was passed by the House in 2018. I understand it was known as HB 5355, but the Senate adjourned early and never officially enacted it. HB 5170 gives animal control officers the tools they need to protect dogs from negligent owners and take remedial action before an animal suffers inordinately. It's a common sense law to protect voiceless dogs who cannot protect themselves. Thank you.
Thank you so much, Ms. Karen, for being so succinct, but also for your patience and your perseverance and staying with us today. I know it's been a long day, so I really admire that, and just want to again take the chance to thank all of our Fairfield folks who have been here today. It's really wonderful. So any questions from members of the committee? Seeing none, we wish you a wonderful evening.
Thank you all.
And next on our list is Mr. Douglas Lord.
Good evening, Representative McCarthy Vehi, Senator Cassano, and members of the Planning and Development Committee. I can't be as incredibly succinct as the last speaker, but I will do my darndest. I'm Douglas Lord. I'm the director of the Public Library in Newtown, Connecticut, at the C.H. Booth Library, and I am also the president-elect of the Connecticut Library Association. I'm here along with many other town librarians to briefly testify on Senate Bill 131 concerning ebook licensing raised by Senator Wong. As a group, we all very much appreciate your willingness to raise and discuss this bill, as it is of very large concern to each and every library in the state of Connecticut. And we really appreciate your time today and your service to your state and your constituents. And I want to go on record as endorsing the statements shared by all my colleagues and those to come. Those are from the State Library, from Colchester, from West Haven, Bloomfield, Fairfield, especially Deborah Schonder, your state librarian. The issues, as you know, and as you have heard, are very complex. There's lots of different platforms, lots of different license types. For me in Newtown, the budgetary pressure really is the main concern for my library. And I think you will find that in each and every library across the state. And that goes for not only public libraries, but school libraries, academic libraries, special libraries, corporate libraries. Each and every one of these libraries deal with the pressure that electronic books place on their budget every day. And of course, As you've heard, we band together in various consortia and cooperatives to collectively save money. You'll be hearing from one of those later, and that is funded through a line in the state library. It's called the CLC, or the Connecticut Library Consortium. We save a massive amount of money on those, on pretty much everything to do. I don't buy anything for my library that isn't through some sort of consortial pricing, except for ebooks. So in Newtown, we have a fairly high community index of support, but imagine what it's like for those libraries who are in disadvantaged communities or really small communities. I do want to say I heard the testimony of the AAP representative. Essentially, these are leased ebooks. A digital object is still an object. The industry's arguments about losing money on the library marketplace, I do not feel hold water. And I feel that that's kind of the crux of the argument. It could be said that it's not as much about the doctrine of first sale or the right of the company to pursue a profit, as much as it's something more along the lines of allowing some sort of variance or discount, as is done for physical media and everything else that governments purchase, that will in turn enable a greater ROI of public funding, because libraries exist to boost public money, to enhance the return on investment. And it's important to note too that libraries don't want to rip off the big publishers or the small publishers. It's just a David versus Goliath issue.
Mr. Lord, I'm sorry, but your time is closed.
Okay, thank you. Appreciate it.
Thank you so much, Mr. Lord, for staying with us today, as I know so many have, but for your work as we share a Senate district, our neighbor up in Newtown. I appreciate it. I just want to clarify one thing that you said, and just make sure I heard you correctly. What I thought I heard you say is that everything you purchase, you do as part of a consortium or a group effort, except for ebooks.
Mm-hmm. That's right. I mean, we do the best we can with ebooks, and we get a deep discount on everything we get except for ebooks.
Okay, I thought I heard that. I just wanted to emphasize and confirm.
Mm-hmm.
Thank you for that. Are there questions from members of the committee? Seeing none, thank you so much for being here, Mr. Lord. And next on our list, we have Elizabeth Rousseau. Welcome.
Thank you. Good evening, Representative McCarthy-Vahey and distinguished members of the Planning and Development Committee. I'm speaking in support of Senate Bill 131, an act concerning electronic book licensing. I'm Elizabeth Rousseau. I'm a senior at Trinity College and a resident of West Hartford. I'm speaking to you as a patron of public libraries. I read every day. Reading is how I relax, and reading ebooks and e-audiobooks is how I do most of my reading. E-audiobooks are great for when I'm going for a walk, doing the dishes, doing my laundry, or commuting to work. Library ebooks are convenient for me as a busy college student who, when I don't have time to regularly visit the West Hartford Public Libraries. Through the West Hartford Public Library, I use Libby and Hoopla to borrow ebooks and e-audiobooks. West Hartford Public Libraries allows patrons to borrow just 4 books a month on Hoopla. So usually I'll look for a book I want to read on Libby before looking at Hoopla because of the low borrowing limit. As a library patron, I am frustrated by the digital collection available to me. I discover new authors and series on Libby and find out that only the first 2 or 3 books in a series are available. If I'm lucky, I'll be able to switch from e-audio to ebook, but most of the time I have to switch to Hoopla, or I have to check the physical library collection, or I go on to buy the later books in the series. I also wait a long time for books on Libby. I have waited over 6 months for my holds to come through on Libby, and I usually have to wait 2 or 3 months for my holds to be fulfilled. As a college student, I read a lot for class, and sometimes my professors assign a book that is available as an audiobook, and I'll choose to borrow the e-audiobook from Hoopla. These books are generally not available through Libby, and having access to e-audiobooks helps me get through my course readings. The West Hartford Public Library serves me through their digital collections. I wish that they could expand their collection significantly, but I understand that the pricing and structure of digital materials prevents them. Thank you all for your time.
Ms. Rousseau, I will tell you that I am moved by your testimony and by the fact that you stayed here with us. I am so sure that the West Hartford Library would say that you are an asset to them, and I know Trinity would be proud as well. So thank you for being here to advocate for your library and for everyone in the state. Are there members with questions? Seeing none, thank you. Have a wonderful evening and enjoy your reading tonight. Next, we have Lorraine Shea. Welcome.
Thank you. Good evening, Senator Cassano, Representative McCarthy-Vahey, and the rest of the members of the Planning and Development Committee. My name is Lorraine Shea, and I'm the President and CEO of Easter Seals of Greater Waterbury. Easter Seals is a tax-exempt organization that each year services over 4,500 individuals of all abilities in Central and Northwest Connecticut. We've served these communities for over 63 years. I'm here to voice my support of HB 5168, an act concerning property tax exemptions for property used for charitable purposes. You've heard a lot of testimony tonight, and I'm here to tell our story as it applies to this situation. In our situation, Easter Seals owns 2 properties in the city of Meriden. We have provided childcare and school readiness programming, which I think you all know is funded by the state of Connecticut, for children of all abilities at one of our properties. And at our second property, we provide outpatient medical rehabilitation, occupational therapy, physical therapy, low vision services, and services for the hearing impaired. In 2020, the tax assessor determined that after over 30 years of providing these services in these locations, Easter Seals would no longer be tax exempt. We were provided no reason, no explanation, and subsequently, after being denied our appeal with the Board of Assessors, we have paid under protest over $60,000 to the city. We're now engaging in costly litigation and paying taxes on property that is technically exempt by state law. In both cases, this is impacting our ability to serve out our mission. Nonprofits have faced years of budget cuts and are operating in as lean of a manner as possible. And if funding is redirected away from the direct care to taxes, people who depend on community services would have nowhere to turn. I want to focus on one portion of HB 5168, which is to create one statewide exemption form and requires all assessors to use that to determine all tax exemptions, so that a charitable property in Meriden will be treated the same way as our property in Waterbury. Unfortunately, nonprofit property serving the same charitable purpose is deemed exempt in some towns, and in others, it is not. In our case, there are organizations providing the exact same services as Easter Seals in cities and towns across the state, and they are not considered they're not considered taxable. Excuse me. I'm not suggesting that any charitable organization be converted to taxable. I'm simply giving this example to demonstrate that in some cases, the decision seems quite arbitrary. The bill also requires that when an assessor denies property's charitable exemption application, they must give a reason for that denial and in writing. When asked of the reason for our denial, we were told to go through the appeals process, which we did. During and after the appeals process, we did not receive any reason for our denial. We have never been given a reason for our status change. But I can assure you—
I'm sorry, but your time is almost up.
Okay, I can assure you that our mission has not changed over all of this time. You've already heard about recouping attorney's fees. I will let you know that to date, we've spent over $40,000 in attorney's fees, and we are continuing to fight this, and that bill will double. As you know, nonprofits exist for the public benefit and must operate for specific charitable, educational, and religious purposes. And our mission is to improve the life of the individuals in our communities. We do the work so that the government doesn't have to. Thank you for raising this important bill, and I urge you to support House Bill 5168 so that organizations like Easter Seals can continue to do the charitable work we were meant to do. Thank you all for the work that you do for the state of Connecticut, and have a good evening.
Thank you so much, Ms. Shea, and thank you for the good work that you do with Easter Seals throughout our state. Are there questions from members of the committee? Seeing none, we wish you a wonderful evening.
Thank you.
Next on our list is Ms. Hinson, to be followed by Ms. Kane. Good evening, please proceed.
Good evening. My name is Zoila Hinson, and I am counsel at the civil rights law firm Relman Colfax P. LLC. Over the past 22 years, the firm has litigated important housing and zoning discrimination cases, including 2 recent cases involving the towns of Cromwell and Fairfield for resisting the opening of small group homes for people with mental health disabilities. I'm speaking today in opposition to Raise Bill number 130, an act concerning regulation of community residences, because its passage will encourage community opponents of group homes to put additional pressure on Connecticut towns to violate their obligations under the Fair Housing Act, Americans with Disabilities Act, and the Connecticut Constitution's prohibition on discrimination on the basis of disability. Over the past 4 months, Connecticut towns have agreed or been ordered to pay nearly $7 million for such violations. If the General Assembly emboldens opponents to put even more political pressure on local elected officials, Connecticut towns are more likely to curtail community-based group homes in residential neighborhoods, and thus will be exposed to even greater liability. In making zoning decisions, Connecticut towns must comply with the FHA, ADA, and Connecticut Constitution. When Congress passed the 1988 amendments to the FHA, it said explicitly that it intended those prohibitions to apply to zoning decisions and practices that limit the ability of people with disabilities to live in the residence of their choice in the community. Title II of the ADA reinforces that local governments may not use zoning and land use powers to discriminate against homes and services in the community for people with disabilities. And these authorities have been interpreted by many courts, the Department of Justice, and the state's own Office of Legislative Research to prohibit local governments from excluding small group homes from residential neighborhoods. My written testimony contains more detailed information about recent cases, but I wanted to highlight a few details. First, my firm filed a complaint in April 2017 on behalf of nonprofit Gilead Community Services, alleging that the town of Cromwell violated the FHA and ADA when it opposed a group home for 6 men with mental health disabilities. On October 15th, 2021, the jury found Cromwell liable and awarded $181,000 in compensatory damages and $5 million in punitive damages. Second, Self Inc., a nonprofit provider of housing and services for adults with mental health disabilities, filed suit in February 2020, alleging that the town of Walcott violated the FHA and ADA when it withheld local zoning approval for a group home. In December 2021, Walcott agreed to grant zoning approval and pay $360,000. Because of the significant civil rights concerns related to Raise Bill number 130 and the likelihood it would draw Connecticut towns even further into legal peril, I ask that you oppose this legislation. Thank you to the Planning and Development Committee for your time.
Thank you, Ms. Hinson, and thank you for sticking with us and your persistence today. I know there's been a lot of discussion on this bill, and I think my question would be, going forward, if this was a discussion that you would be willing to continue with others outside of the committee hearing process, is that something that you would be open to?
Of course.
Wonderful. I think there are some questions in terms of definitions, and I think as you heard earlier from you may have heard earlier, I'm not sure, from one of the folks who testified, just that this bill is aimed at a narrow definition in the statute. I hear that you are referencing the other laws that are at the federal level, and I think it will be helpful to get into some other conversation about that as well. So thank you very much for your willingness, and I wish you a wonderful evening and weekend. Seeing no other questions from members of the committee, we'll go next to Ms. Kane, to be followed by Mr. Sobey. Ms. Kane, welcome.
Thank you. Good evening. I'm Claire Kane. I'm the Trails Director for the Connecticut Forest and Park Association, and I'm here to express my very strong support for SB 129. As you've heard from my colleagues, the establishment of an optional tax abatement for certain conservation easements is the tool, frankly, we need right now to incentivize private landowners to protect trail corridors in Connecticut. Our organization has managed the Blue Blaze hiking trail system for over 90 years. The 825-mile system is being used more than ever these days, and our state citizens are enjoying the significant benefits that it offers. And the system is also a very popular component of the state's greenway system. But I'll tell you what makes our trail system so special. what really allows the system's length and breadth to exist, and it's the mix of the public and private lands that we cross. The diversity of this ownership is what really allows the trails to connect long distances across the landscape. Our longer trails, like the Shinipsit, the Metacomet, stretch 60 to 100 miles in length and can cross multiple towns. 40% of our trail system, or just over 300 miles, are generously hosted by private landowners. But as you've heard, these sections of trail are extremely vulnerable. Properties can change hands, our landowner base is aging, development and subdivision pressures are increasing, and resulting trail closures could break the connectivity of these trails forever. So again, a new tool is needed because the existing methods for protecting open space are not always practical for protecting trail corridors. This tax abatement is the game changer, frankly, that we need to keep trails permanently intact. And we may finally be able to reward our landowners for their goodwill. These private landowners have been allowing public access for years, and this will incentivize them, hopefully, to keep it that way. We have seen situations where a privately owned trail section is literally sandwiched between two conserved tracts of open space. If a town opts to pass a tax abatement ordinance, that community will be better able to encourage the protection of that private parcel and secure and permanently link those protected lands forever. Outdoor recreation, we know, has literally skyrocketed during COVID, and that's great news on so many levels. But it then becomes even more urgent that we develop innovative ways, like this bill, to maintain recreational access to our natural spaces. A public-private partnership which keeps lands in private hands, but allows for perpetual public access, is what we need. So thank you for raising this important bill and taking the lead on advancing recreation and conservation in the state.
Thank you for your testimony today, Ms. Kane. I think we could all use a walk on a trail tomorrow after sitting for so long, right?
Absolutely, I hope you do.
Very grateful for the work that you do with Connecticut Forest and Parks, and I have certainly enjoyed some of those trails and have seen exactly what you're talking about with the signage related to public lands and private lands. So if there are no questions, any questions from members of the committee? Seeing none, we thank you for being here with us today, for sticking with us, and for the work you do. Have a wonderful weekend.
Good night.
Next on our list is Mr. Sobey, to be followed by Ms. Pulse. Welcome.
Thank you, Madam Chair, and good evening to you and distinguished members of the Planning and Development Committee. I'm Stan Sobey, Vice President for Public Policy and External Affairs at Oak Hill. Founded by Emily Wells Foster in 1893, Oak Hill provides services and programs to Connecticut citizens with disabilities in some 77 towns across the state. I'm here in support of House Bill 5168. I've submitted testimony. I'm going to try to hit just a couple of key points. We've had the experience of being newly taxed in 4 municipalities on 6 homes where we had decades had tax exempt status. The cost of that was some $50,000, which was the equivalent of some 2,500 hours of direct support time that would have gone to people with disabilities. We made the decision to pay that, even though there was no reimbursement mechanism for it, because the cost of litigation would have been so much greater. Recently, we've had 2 municipalities' initial denials for tax exempt status, but through dialogue, they restored that tax exempt status. The proposed language changes in 5168 would help both assessors and nonprofits avoid similar situations like that. It becomes much clearer with the language in the bill. One other issue that we found is that this bill would help with is that when an assessor denies a property's charitable exemption application, they give that denial in writing. And having had a deadline issue arise because of delayed receipt of mail, We would hope that this and all written correspondence between assessors and nonprofits would be communicated both through the Postal Service and via email, so that those kinds of things would not happen. Nonprofits are tax exempt as part of the social compact that goes back to the time when Emily Wells Foster founded Oak Hill. I would hope that you would support this bill going forward and appreciate your raising the bill and hearing my testimony. Thank you.
Thank you very much, Mr. Sobey. And you raise a great point in terms of email and as my children call it, snail mail. But I appreciate that and appreciate very much the work that you have done for so many years for so many people. And I see Representative Smith has his hand. Representative Smith.
I do. Thank you, Madam Chair. And thank you also. I wanted to add, echo what the chairwoman just said with regard to the work that you do and have done, as well as at Oak Hill. I also feel a little bit of Colchester pride. I think on a per capita basis, our town may be as well represented as any other municipality in the state here today. But I thought that it would be helpful for all of us to know that, your particular testimony, at least for me, has more meaning because I'm familiar with your background and know that you not only are here to represent the nonprofit side of this equation, but as a public official of many years, I think you've got a real deep understanding of the pressures that exist on both sides. And so my question really is whether you would share with my colleagues a little bit about your public service background so folks can understand, as I do, what informs you as you provide this testimony.
Thank you for that question, Representative. And thank you for representing Colchester and the 48th District so well. My past history has been having many opportunities to serve the town of Colchester on a variety of boards and commissions as a volunteer, including the Board of Selectmen, and twice serving as first selectman in the town of Colchester. So I have had regular contact with the town assessor, tax collector, all of the people in town hall who make everything work every day, and understand the interest of the town to be able to maximize resources and do it in a fair way, but also recognize where there are needs and the points at which to recognize the law as it stands in Connecticut, federal law. And knowing that nonprofits are businesses, we employ people. Those people often live in the towns where they work. They spend money locally. They help, the money just gets passed right back through into the economy. And so there should be a way for municipalities and nonprofits to be able to work together for the betterment of all.
Thank you, Mr. Sobey, and thank you for your testimony today and the work that you do for citizens of Connecticut.
Thank you, Representative.
Thank you, Madam Chair.
Thank you, Representative Smith. And thank you for pointing that out, Mr. Sobey. Thank you for your service. You've been on both sides of this equation, so you understand the need to do the balance. And I think we've seen support here in this committee, obviously unanimously last year. And I think a lot of us here understand how important this is to agencies like yours. So thank you for taking the time to be here with us today.
Thank you for the opportunity, Madam Chair.
Have a wonderful weekend.
You too.
Next on the list, we have Miss Pulse. And next we have someone whose last name I recognize, and I think that we got it wrong with Kate. It's Miss Priya. Oh, well, you'll help me. But first we'll have Miss Pulse.
Thank you. Good evening, Madam and Mr. Chairperson, and the distinguished members of the Planning and Development Committee. My name is Jennifer Pulse. I am the Chief Financial Officer at Mental Health Connecticut, and I wish to share my support for HB 5168, an act concerning property tax exemptions for properties used for charitable purposes. Mental Health Connecticut is a 114-year-old nonprofit that partners with individuals, families, and communities to create environments that support long-term health and wellness. We support about 1,000 people per day through our advocacy, community education, and services that include housing supports and wraparound services in Stamford, Bridgeport, Danbury, Waterbury, Torrington, and West Hartford. Human services are not fixed costs in the budget and have historically taken on a disproportionate piece of the cuts over other departments that are funded through discretionary funding. Nonprofits continue to fight for whatever is left over in the state budget. A property tax exemption would prevent us from having to dig deeper into our already thin pockets to support state-generated revenue that could be generated through other means. Community-based nonprofits represent approximately 14% of Connecticut's workforce. Our staff often work at below living wage, and most need to work 2 or 3 jobs to support their families. Property owned and leased by a nonprofit and used for charitable purposes is exempt from property taxes, but recently, many assessors have denied exemption applications. Critical funding is diverted away from direct service provision to people in need when nonprofits, burdened by years of state budget cuts, are forced to choose between costly litigation and paying taxes on property that is exempt by state law. People who depend on community services would have nowhere to turn if the funding is redirected away from the direct care to taxes. These cuts would come at a time when the demand for community services is increasing. Nonprofits are explicitly exempt from federal, state, and local taxes for good reason. They provide essential services to residents so government doesn't have to. HB 5168 removes the word temporary from the statute to ensure that all the state's human service residential programs cited in the law are exempt. In September, the state Supreme Court ruled that residential programs like group homes, substance abuse treatment centers, homeless shelters, halfway houses, and more are tax exempt even if residents stay there for longer than 6 months. But despite this ruling, some assessors are still denying these tax exemption applications. Nonprofits exist for public benefit and must operate for specific charitable, education, or religious purposes. The mission of nonprofits is to improve the health and well-being of our local communities, enhance the quality of life, and serve the public good. In exchange, nonprofits are exempt from property, income, and sales tax and have access to tax-deductible contributions from individuals and corporations. The social compact.
Ms. Pulse, your time is almost up.
Thank you. The social compact dates back more than 100 years. I thank the committee for raising this important bill and urge you to please support HB 5168. Thank you for your time and service. I appreciate the opportunity to speak to you. And I'm also from Colchester, just for fun.
Oh, well, thank you. Great timing. And I think we've had good Colchester representation here today too, right, Representative Smith?
Yes, but I just wanted to thank Jennifer for also having the patience to stay with us all day and for her testimony and for doing everything that she does for the town of Colchester.
Thank you very much.
That's wonderful. Are there other members of the committee who have questions? Ms. Pulse, thank you for the work you do throughout the state, truly, and for staying here with us today. I know it's a labor of love. So
thank you to you and the committee for hanging out and doing all this for us. Thank you so much.
Well, it's our privilege. Thank you. Next on our list, I'm going to hopefully get this right with a little help from Erica. Miriam Byrode is our next speaker, followed by Ellen Paul. Miriam, there you are. Welcome.
Yep. Hi, yes, it's Byrode. Thank you. Greetings, Senator Cassano, Representative McCarthy Vahey, and the members of the Planning and Development Committee. My name is Miriam Byrode, and I live in Manchester, Connecticut. I am a regular library user in Manchester and a member of the Manchester Public Library Advisory Board. I also have dyslexia, which made learning how to read very challenging. My daughter also has dyslexia and had a hard time learning to read. One thing that was a huge help was audiobooks. She attended a magnet school in Hartford for many years, and I drove her in. We listened to dozens of audiobooks from the library during this time. We did all the Harry Potter and Artemis Fowl books, plus lots of classics like The Secret Garden. Because of this intensive audiobook listening, her vocabulary and reading comprehension were very advanced in comparison to her reading text ability. When her text reading abilities were able to catch up, all those other pieces of overall literacy were already in place. She and I will never be great spellers, but I am so thankful for the library and all those audiobooks that helped her develop other aspects of language fluency while she worked on the more difficult mechanics of reading. Serving on the Library Advisory Board in Manchester has made me aware of book budget issues, and I've always been very taken aback by how much is charged for e-materials. Since e-materials have the ability to change in mode in various ways, not only with audio formats, but with changing text, font, and size, these materials in essence expand access to books for various people with different abilities. Thus, inflated prices for these materials becomes an equity and accessibility issue. Towns with less resources will suffer and not be able to provide materials and opportunity for people of different abilities. When I was helping my daughter navigate her learning disability issues, I was keenly aware of how access to resources, such as materials at our public library, impacted our family's ability to help her with reading. All I wish for is that all families have the ability to access materials, and towns with less money aren't penalized for it. Thank you very much.
Ms. Byrode, thank you very much. And as I mentioned earlier when Elizabeth Rousseau testified, I'm also moved by your testimony today and by the power that the resources that our libraries have on people's lives. And ticket to the world. That's what I say. So I thank you very much. I see there's a hand, Representative Gucker.
Good afternoon. Probably my first time speaking today because I'm on 2 Zoom public hearings at the same time. So I've been listening with one ear in each place. I just wanted to say thank you for testifying today. As somebody with dyslexia myself, I understand how hard it is and how important these resources are. To both you and your daughter. And I just want to commend you on your bravery for coming out and testifying not only on your experiences, but on the importance of making sure that she has all of the pieces that she needs to move forward. And I say that as somebody who, back in my day, we didn't have these sort of resources. We didn't have books on tape. We actually had somebody had to read the books to us. So we had live people doing it. But anyway, I just wanted to say thank you. And I wanted to say thank you for standing up and speaking for your daughter, because sadly, not enough people do that. And sadly, children that are dealing with dyslexia or any kind of other learning disabilities sometimes get lost in the cracks of education. So thank you.
Thank you so much.
Thank you, Representative Gucker. Ms. Byrode, have a wonderful weekend. Thank you for being here with us.
Great. Thank you so much.
Next on our list, we have Ellen Paul to be followed by Carl Antonucci. Ms. Paul.
Hi there, good evening.
Welcome.
Thank you to the members of the Planning and Development Committee for having me. My name is Ellen Paul, and I'm the Executive Director of the Connecticut Library Consortium. I'm here in support of Senate Bill 131. Our organization represents 800 member libraries across the state, academic, public, special, and school libraries, and we negotiate discounts on the things that libraries buy every day. So when I think about the issues surrounding ebooks, I really think of this as a taxpayer issue. When your local library goes out and buys a paper book, they don't pay full price. They pay about 50% of the cost on the back of that book. And that's because libraries in Connecticut spend literally millions of dollars each year on paper books. And we negotiate together so that book distributors and publishers give us a volume discount. But when it comes to ebooks, that story is so completely different. When a member of the public goes out to buy a popular ebook on Amazon, you know, they pay maybe $10. a significant discount off of the list price. But when libraries go to buy the very same ebook, they pay double, triple, quadruple, or more. Formerly, I was the library director in the town of East Hampton. I have paid over $100 for an ebook so many times. Those are taxpayer dollars. Most of our libraries are publicly funded. Those are public dollars that are being overcharged for the same product that you can buy in the open market for so far less. And to make matters worse, as my colleagues have outlined, libraries can't even keep those ebooks after they buy them. After 12 to 24 months, they just disappear. The ebook goes right back to the publisher. So if we think about those eternally popular books like Harry Potter, can you imagine how many times libraries need to repurchase that title for that overinflated price? We are literally spending thousands of extra tax dollars. Who pays for that? The municipality pays for that. The taxpayers pay for that. The state of Connecticut taxpayers pay for that. This affects public libraries, school libraries, academic libraries, every libraries. And quite honestly, if the public knew what was happening, I think that they would be outraged. We've seen demand for ebook borrowing at our local libraries skyrocket during this pandemic, but essentially what is happening is that the government, in the form of public libraries, school libraries, public academic libraries, are being taken advantage of by these publishers. So I appreciate this committee for bringing the public's attention and championing this issue, because I think that we can solve this problem. And then the bottom line of all of our libraries will be significantly better, and we can continue to serve our communities in the way that we do best. Thank you for your time tonight.
Thank you so much. Thanks for your work on behalf of libraries all across the state and for staying with us today. It's much appreciated. Are there questions from members of the committee? Seeing none, Ms. Paul, have a wonderful weekend.
Thank you.
Next on our list is Mr. Antonucci, followed by Alyssa Gaduti. Welcome, Mr. Antonucci.
Good evening, Representative McCarthy-Vahey and distinguished members of the Planning and Development Committee. My name is Carl Antonucci, and I'm a past president, year 2007, of the Connecticut Library Association, and I work as the Director of Library Services at Central Connecticut State University. I am speaking this evening in support of Senate Bill 131. I just wanted to note my testimony is my own personal and professional perspective on this very important issue and does not reflect the perspective of Central Connecticut State University or the Connecticut State Colleges and Universities system. In 2012-2013, I was a co-chair of the Connecticut Library Association's Legislative Committee. And at the time, CLA worked very hard in securing passage of HB 5614, an act concerning a study regarding the availability of electronic books to users of public libraries. I was proud to be with some of my CLA colleagues in Governor Malloy's office when this bill was signed. But the prices of ebooks were high back 10 years ago, and they are still very high today. And that is why I'm with you again 10 years from then now to talk about this. I'm glad that the committee is considering this very important legislation. The ability to access ebooks, as my colleagues has pointed out, is an issue that is very important to library users throughout Connecticut. But it is also very important that I wanted to point out to our academic library users. In my experience, I have found that having a university library with access to a large collection of electronic books is very important to both the teaching and learning that takes place on campus on a daily basis. For example, we were closed today, our whole campus, but I know from our statistics, we can look at them that our students were accessing electronic resources in ebooks. But the extremely high prices of ebooks makes it really hard for us with our flat budgets to buy these packages. And because they bundle many packages together, it makes it very tough to provide as many as we could to our students, faculty, and staffs. And during the pandemic, our students really relied on ebooks to complete assignments and papers. And the trends of students depending more on electronic resources in ebooks that can be accessed remotely is not going away. And during the pandemic, these publishers and vendors gave us very good deals on these resources. So I know that they can do it because they're still making a profit, even though they cut it down from our 5 to 7% increases each year to maybe 1% or a flat rate. And we need this to keep happening for us to be able to provide these great resources to our students. And in another case in our system of the state colleges and universities, if one college or university buys some of the ebooks, we can't even lend them to our students at the other colleges. So I just wanted to testify tonight to let you also know, the committee, that this is a concern with academic libraries as well. Thank you very much.
Thank you very much, Mr. Antonucci, to your service to the students now and to the libraries across the state previously. And Representative Smith.
Thank you, Madam Chair. Uncharacteristically talkative today, I guess. I just would like to thank you, Mr. Antonucci. And I can tell you that when I was a student at Central, there was one year in particular where I was very, very short of cash. And there were several courses that I took where the only book I had access to was one that was a prior edition of the approved book for the classes that I was taking, that I found in your building in the library at Central. And as I think about books that time out after 24 months, if that was the case back then, those books would not have been accessible to me. And although they were somewhat out of date compared to what was on the syllabus for the course, they got me through those courses pretty well. And so that's one of the things that troubles me the most about the situation we're talking about today, is that books could actually be allowed to just time out and disappear when they most certainly would still have a useful life and find an audience in the future. So thank you for pointing out the very many uses that students make, in particular of ebooks in difficult times, because having benefited from that with hard copy books, I know how important it is.
Well, we
Thank you, Madam Chair.
Thank you as well for listening to us today. The subscription model is hard because we buy books at the academic level as a bundle, subscription wise, and every year we have to pay a subscription for these books, so we just can't afford it.
Thank you, Representative Smith. And I think, Mr. Antonucci, something you said was very striking, that this trend is not going away. And so this means that this is a problem that must be solved, because the move to ebooks and e-audiobooks is going to continue to be more and more. And as my own librarian here in Fairfield said, we certainly won't be losing hard copy books. We know that those will remain, but this is going to be an ongoing issue. So thank you for taking the time to be here with us and share your insights.
Thank you so much. Thank you.
Have a wonderful weekend. Next, we have Alyssa Gadudi, and I believe following Ms. Gadudi, we have, yes, Kate Sheehan. Welcome. It's nice to see you.
Nice to see you too. Good evening. And Representative McCarthy-Vahey, I'm a Fairfield girl, so we have to represent Fairfield as well. Good evening, distinguished members of the Planning and Development Committee. I'm Alicia Gadudi. I'm the president and CEO of Edelbrook Behavioral and Developmental Services. Edelbrook is a multi-service agency specializing in autism spectrum disorders, developmental services, and behavioral health treatment. We support hundreds of children and young adults with highly complex developmental and behavioral needs through the expertise of more than 600 talented, caring, dedicated employees, and in 20 locations throughout Connecticut. I'm here today to speak with you in support of House Bill 5168. You've heard a lot of testimony from my colleagues about an act concerning property tax exemptions for property used for charitable purposes. Property owned or leased by a nonprofit and used for charitable purposes is exempt from property tax. However, recently, many assessors, as you've heard, have denied those exemption applications. When that happens, critical funding is diverted away from direct services. And that's at a time when nonprofits like Edelbrook are already impacted by many, many years of underfunding. We are forced to choose between costly litigation and making the decision to pay those property taxes, which we shouldn't have been levied in the first place. For many years, our programs operated under that nonprofit
property tax exemption, but in 2019, we were assessed local property tax on one of our group homes. As always, we had filed a tax exempt return, the M3 quadrennial, and that was denied. We then filed a petition with the Board of Appeals for assessment. That was also denied. We paid $15,000 under protest. And that may seem like just a drop in the bucket, but this assessment on a one home is concerning. Even greater concern, though, is the impact of ongoing assessments year after year and the threat of being assessed on our other 19 program locations. The financial burden of this unplanned and unfunded expense is incredibly challenging. And as I said earlier, it diverts funding away from what we really want to do, provide services to kids in need. So we're asking for your help in clarifying the tax exempt status through this legislation. Edelbrook is a 122-year-old nonprofit organization. We were originally formed as an orphanage, and our mission is about helping people in need find hope and healing. Nonprofits are explicitly exempt from federal, state, and local taxes for good reason. We provide essential services to people in need so that government doesn't have to. Our work is charitable, it's done in partnership with the state, and it's done to support those most in need. Every dollar we get must go into our programs. This inappropriate levying of local property taxes on our charitable programs takes resources ultimately away from those who need them most. I thank you for your time and your attention. You guys have been incredible and resilient in listening to so many of us tonight, and we really appreciate it.
Well, thank you, Ms. Gaduti. Forgive me for mispronouncing your first name and for forgetting your Fairfield connection. I can't wait to remind Representative Curry. We have a running joke, he and I. I wonder if any committee members, no questions. Well, thank you for 122 years. That's a long time to be in service to the community, and that's really a testament to your organization. And we've heard from so many organizations who have been around for quite some time, serving the needs of the state and the people of the state. So thank you.
Thank you so much. Have a nice evening.
A wonderful weekend. As we go to our last speaker of the evening, I will just say, for those of you who may feel tired, the Public Health Committee is, I believe, on about number 100 of their 250 plus speakers. So yes, so we are going to introduce Kate Sheehan, who you will be rounding out the evening for us. Welcome, and thank you so much for sticking with us today.
Thank you, and thank you everyone for having us, and thank you for sticking with this. This is an intense day that you all have. My name is Kate Sheehan. I'm the head of IT at Stratford Library, and I'm a Trumbull resident. I have a kiddo in the Trumbull schools. I've worked in Connecticut libraries for almost 20 years. Before I was a librarian, I was a library patron. I was deeply appreciated the statewide reciprocity that a Connecticut library card affords. I grew up in a small town in Eastern Connecticut, and I had easy access not just to my much loved hometown library, but also to nearby libraries that had 4 or 5, 10 times as many books. Part of what drew me to libraries as an adult were the core values of equity, access to information, and the key role that public libraries play in bridging the digital divide. Connecticut librarians have always been a very impressive group, as you've seen today. They're dedicated to the stewardship of public funding, resource sharing, and providing access to resources across our institutions, large and small, despite wildly disparate funding and staffing levels. And I can say ebooks have always been popular with our patrons, but the pandemic, as everyone here has noted, has caused an explosion in their use. We hear regularly from patrons who tell us that our digital collections were a lifeline during the early days of the pandemic in particular. Seniors have always been some of our most avid ebook readers. They make the switch to digital when the print and paper books just out of nowhere becomes appallingly tiny, and they need a more accessible solution. They're often on a fixed income, and they are overjoyed that they continue to both buy and borrow books. They're always very disappointed that they can't donate the books they've purchased in digital format to the library, and they're downright shocked when they find out that our ebooks cost significantly more than retail and then expire on us after a year or two. They love our ebooks, but they immediately can see, as you all have, the financial strain that can put on a library budget. We understand, all of us understand that publishers need to make money. We want authors to do well. We want them to flourish. That's our stock and trade. Libraries have decades of experience managing digital resources in ways that are not harmful to publishers. We believe that a healthy and diverse reading ecosystem will benefit everyone. We want to cultivate good collections for our patrons. We want to extend more of those lifelines into our communities. 10 years ago, I wrote a book for a library publisher about ebooks in libraries. We were making all of these arguments then, as several people here have noted. At the time, libraries were trying to work with publishers to improve the terms of sale so that ebooks could be accessible to and sustainable for more libraries. We were shocked when one publisher began selling expiring ebooks at that time. We argued against it, and obviously that was to no avail. Librarians have been at this alone for a long time. We don't ask for legislation lightly. We desperately need your help in creating a robust law that makes ebooks and e-audiobooks accessible to libraries and their patrons on equitable terms. Thank you. This has been such a long day for all of you. I am even more impressed by what you all have to do.
Well, we don't have to. We are fortunate enough to have the privilege to do it. And I will say thank you for staying with us. I don't see any other hands. I want to thank you for being our final speaker of the day. What a wonderful way to round things out. And I've really enjoyed hearing from all of our librarians. You can probably tell from my comments that I'm a huge fan of the library and of the ability to access information and community. That's what our libraries do. So thank you, Ms. Sheehan, very, very much. And seeing no other speakers for our hearing, the hearing of the Planning and Development Committee is now adjourned. We are returning for those who need to vote for our committee meeting, which was held in recess back a number of hours ago. The committee meeting will be open for the next 30 minutes for anyone who needs to vote. And you do not need to change links. You can do so here in this Zoom link. And as we do in committee, if you can raise your hand with the raise hand function, and Madam Clerk can call on you so that you can record your votes.
Representative Gucker, I see you there.
How are we doing? Just in between two meetings again, as always.
I understand. Okay, we're going to go through the list and then we will be all set. Okay, so we took several separate votes and then a few combined votes, and I apologize for the background dog noise. Chuck, be quiet. It's a dog. It's not my dog. Rep Gucker, are you frozen or am I frozen, or just want to? Should I switch over to?
I think Rep Gucker is frozen after all this conversation about digital technology.
He freezes often.
Oh no. Okay. Well, Rep D'Agostino, are you available, sir?
I am. My dog's ears perked up, so.
Yeah, sorry. Yeah, no, Chuck is excitable. Again, not mine. So we've got the first vote is on item number 3, an act concerning access to municipal owned beaches and parks adjacent to marine or tidal waters.
D'Agostino votes yes.
Thank you, sir. Next one is item number 5, an act concerning transit-oriented development.
Vote yes.
Thank you. Number 9, an act concerning the mill rate cap for motor vehicle property taxes and concerning reimbursements to municipalities for lost revenue.
Vote yes.
Okay. Item number 10, an act concerning the eligibility of certain real property for the payments in lieu of taxes program.
Vote yes.
Okay. We voted on 19 through 22 as a block. Those are an act concerning municipalities and shared services, an act concerning municipal agencies, an act concerning planning and development and notice of certain actions or decisions, and an act concerning local government and employment.
All good. I vote yes.
Okay, and then it's going to be the long one. Did a voice vote on all of these guys. So we've got Item 1, an act concerning alternate members of municipal planning commissions. Number 2, an act concerning certificates of approval for motor vehicle dealerships and repair shops. Number 4, an act concerning Title IX protections for municipal recreation areas. Number 6, an act prohibiting charges for water lines located on private property and non-serviceable fire hydrants. Number 7, an act establishing a grant program to fund the removal of dead and dying trees adjacent to public roads. Number 8, an act concerning coastal area management application. Number 11, an act establishing a task force to study Title VII of the general statutes. 12, an act requiring an opportunity for public comment at public meetings. 13, an act concerning the charter of the Metropolitan District Commission. 14, an act concerning the recommendations of the Office of Finance within the Office of Policy and Management. 15, an act concerning the processing of land record recording fees. 16, an act establishing a pilot program delegating the management of small-scale transportation projects to the capital of governments. 17, an act concerning fire districts. And 18, an act establishing a task force to study the electronic publishing of public notices. How do you vote, sir?
Do you want an aye or a
I would
vote yes, whatever you want.
I would be perfect.
All right. There you go.
Excellent. Thank you, sir.
Thank you, Madam Clerk. Thank you, Madam Chair.
Can I also say aye as well?
Did you hear all of those?
Yeah, believe it or not, I'm running 2 laptops at the same time. I picked the other one up, the battery fell out and the thing shut off.
Yep. So you heard the whole consent
Yes.
agenda, right? Okay, then I'll just, let me just, for purposes of the record, let me just quickly go through the other ones. Item number 3, an act concerning access to municipal-owned beaches and parks adjacent to marine or tidal waters.
Yes.
Okay. Item number 5, an act concerning transit-oriented development.
Yes.
Item number 9, an act concerning the mill rate cap for motor vehicle property taxes and concerning reimbursements to municipalities for lost revenue.
Yes.
Item number 10, an act concerning the eligibility of certain real property for the payments in lieu of taxes program.
Yes.
And then finally, we voted on 19 through 22 as a block, which were an act concerning municipalities and shared services, an act concerning municipal agencies, an act concerning planning and development and notice of certain actions or decisions, and an act concerning local government and employment.
Yes.
Excellent. Thank you, sir. You are all
Thank you
set.
for hanging in there.
Yeah.
I got to go back to my other meeting because my computer's off.
Good luck.
Thank you.